Good morning, everyone. The Court of Appeal of Bermuda has assembled for the hearing of Civil Appeal number 11 of 2022, the Hong Kong and Shanghai Banking Corporation Limited against New Ocean Energy Holdings Limited. Mr. Kevin Taylor of Walker's Bermuda Limited is appearing on behalf of the appellant, and I have Mr. Keith Robinson appearing on behalf of the respondent company. These proceedings are taken before my lords, the President, Sir Christopher Clark, Justices of Appeals, Sir Morris Kay, and Jeffrey Bell. My Lord President.
Right. Well, we're very grateful to the parties for the preparation of this case and the skeletons. We particularly enjoyed the joke, which was that the material suggested could be read in 5 hours. We have obviously read the judgments, the skeletons, and the affidavits, and some of the accompanying material. Yes, Mr. Taylor.
Yes, my lord, very much obliged. I should say that my friend Ms. Tovey is appearing with me on behalf of the appellant petitioner. My lords, the other thing I should indicate is I don't see them on screen. My understanding was counsel for the provisional liquidators was going to attend. Now, you will have read their skeleton. It is exceedingly brief, perhaps unsurprisingly. My lord, so we're certainly in your hands as to, this may be them. I believe this is them joining us now.
Right. Yes. Hello.
Yes, I see my learned friend Ms. Vaswani is here for the provisional.
Right. Very good.
Right. Yes, my lord, thank you. My lords, perhaps I can begin just by summarizing that this is an appeal from the decision of the Honorable Mr. Justice Mussenden, which was made on the 9th of May. It's reflected in a ruling dated the 31st of May, which you I understand have read, that adjourned the subject winding up petition for the 8th of July. Now, I'm not sure much turns on this, my lords, but in fact, while the ruling is dated the 31st of May, it wasn't circulated to the parties until early June. Certainly, there seems to have been an administrative mistake in terms of the dating of the judgment. As I say, I'm not sure any turns on that. Lords, on the 1st, at a hearing on the 1st of June, the learned judge did indeed grant leave for the petitioner to pursue this appeal. Yeah. And so that's how we are here today. My lords, there are a number of bundles before you. I'm going to try and make at least what's in front of you for the most part more simple. I propose that I will mostly be referring to bundles A, B, and C, yes, which are the judgments and the subject affidavits. I will make some relatively limited references to some of the exhibit material, but otherwise it will generally be those bundles.
That's very helpful.
Yes, my lords, I thought I'd begin by just setting out the appellant's high-level position, if I can put it that way. We say the following. Firstly, I'd like to just broadly set out the position on the views of creditors before we get into the detail. So, my lords, from the outset, each creditor that had made its position known in the proceedings rejected any restructuring and supported the making of a winding up order immediately. And we say that whilst learned judge is certainly in his judgment written that he has given serious consideration to those views, that unfortunately, with all due respect to the judge, he failed to grapple with the law applicable to such circumstances. And in particular, my lords, nowhere in the subject ruling does the judge grapple with Section 99 of the Companies Act in any detail at all. In fact, he doesn't mention Section 99. And of course, that requirement, my lords, is that a majority in number, representing 75% in value of the claims voted at a scheme meeting, must be in favor of the scheme of arrangement for that scheme to pass. And Moses, of course, that is crucially important, we say, in the context of this matter and this appeal, because we have such an overwhelming majority of creditors. And keep in mind, my lords, and I will bring you to this particularly, not just a majority of creditors appearing, though of course that's what the number represents, but a majority of the creditors in aggregate value of creditor claims saying this company ought to be wound up. And keep in mind as well, my lords, not a single creditor has appeared to give any indication that it supports the company's position that the matter should continue to be adjourned for the purposes of reaching a compromise or arrangement. And so,
can you just pause there for a moment?
of course,
it's entirely plain that there is nobody here, or nobody has filed any document, let alone attended, who is a creditor supporting the company's position. But there were references, I think, in Mr. Schum's first affirmation to something like 15% of lenders supporting the company's position.
So, my lord, it's a very good question. And our position is that, in fact, that support and how it was framed as support turned out to be quite incorrect. Because if you actually parse, and I don't have a reference for you, but we'll be able to locate it. But in the exhibit to Mr. Schum's affidavit, what those emails actually say in various forms is broad statements about, one creditor, I believe, says, in general terms, a restructuring is better than a liquidation. But they're very equivocal statements in those emails. And similar, they don't say we support the company. They're very equivocal. And it's in terms like, well, if this and this happens, then we might support the company. And of course, my lord, Schum 1 was filed at the outset back in November. And of course, my lord, as you follow the evidence through the course of the proceedings, we hear nothing more from those creditors. And so, my lord, one assumes, and my learned friend Mr. Robinson may disagree with me, but one assumes that if that support was firmed up in a real way, the company would have either submitted that evidence to the court subsequently, or alternatively, those creditors might have filed their own notice of intention to appear on the petition to oppose a winding up order. And that's never happened. Okay. So, my lord, we say the position's quite clear, that there is no one who supports the company in the traditional sense. So, my lord, thank you. Moving back to where I was dealing with the scheme of arrangement, the fact that the learned judge hasn't dealt with Section 99.
I'm sorry to keep on interrupting.
Of course,
but I mean, Section 99 says in effect that if you want a scheme of arrangement, you need a 75% majority.
In value, that's correct.
In value, yes. But a number of other comments have been made to the effect that this is not a restructuring application at all. It's just a case where all the debtor seeks is time to pay. I mean, as I have understood it, the claim is that the company wishes to proceed to bring into effect a restructuring facility agreement by which there will be lending under one facility with repayment dates in September 20 of this year or January of next year.
Well, I think March, my lord, March of 2023 is the extension date. Yes.
Now that involves those who have existing facilities agreements under which the debt is due, entering into a new facility agreement under which the debt isn't due until September 22 or March 2023.
Correct.
Now, does that require a 75% vote under Section 99?
Well, my lord, let me explain what the company's proposing, because it's the company's proposal. And my lord, so I come to this, but
well, don't let me take you out of order.
No, well, my lord, no, that I'm obliged. But why don't I put a pin in it, and then when I come to it, we can firm it up together.
Yeah. Okay.
So, certainly from my perspective, there may have been some confusion at some point in the proceedings what the company's intentions were. But when you do look at the evidence of Mr. Schoen, it is absolutely clear that they propose to seek sanction of the court to hold a scheme meeting and to have a scheme of arrangement promoted. Right. So that is the company's plan. And my lord, I should say that at the application for leave to appeal before Justice Mussenden, I did put to Mr. Tucker, who was at the hearing at that time, sort of what's the company's plan? Because at various times it appeared that it might be seeking time to pay in full, or alternatively a scheme. The position is that Mr. Tucker confirmed that in fact the company is seeking to promote a scheme. And of course, the reason it appears that they need to, certainly in the company, or pardon me, in the petitioner's view, is that the plan will not see the creditors being paid in full. The evidence seems to be that 95% of the debts the company says will be met. Now, the petitioner disputes that, and in fact, at this point in time, we say that the company can't know the number because they do not have any agreements for the sale of any of these assets. So, but the company's position is that they will be promoting a scheme, and my assumption is that the reason they need to do so is there will be a haircut, if I can put it that way, that the creditors will not be paid in full.
But Mr. Taylor, that's a common feature of schemes of arrangement. What I don't quite follow in this case, there is no scheme yet put forward in final form on which creditors can vote, is there?
That's correct, my lord. We don't have a draft scheme document. My lord, you will appreciate, and we say it's an important feature of this case, that the company had attempted to promote a scheme in 2021, and that failed. And there are a number of reasons that that's important in the context of this matter, my lord, but you're right. The creditors have not been presented with a scheme as of now. That's correct. That's correct. Thank you.
Yeah, but sorry, it gets more confusing as one goes along. I quite understand what you say about only 95% being repaid, but what I haven't quite understood is whether the quote scheme, close quotes, as indicated, though there's no actual document in existence, is actually a scheme that there will be a new facility in which the creditors are only the bank creditors. Is that right?
Well, that's my understanding. That's correct.
Yes.
That's correct.
What exactly has happened to the poor chaps who are not bank creditors?
Well, my lord, it's a good question. It's a good question, and I'm glad you've asked it, because so, and again, we'll come to this, but you, not surprisingly to me, you keep hitting on good questions. So, my lord, part of the difficulty was, and you'll see that this featured in the provisional liquidators' reports about their concerns, and I put it as concerns. They can better characterize their views. That certain information wasn't provided. Now, my lord, what happened in the midst of all of this, and you will have seen this in the material, is that a trade creditor, Kuwait Petroleum Corporation, has filed a winding up petition in the High Court of Hong Kong Special Administration Region.
Yes.
And they are a trade creditor. Now, certainly the understanding of the petitioner, the appellant, was that this was a bank creditor scheme. However, when that petition was ultimately revealed to the provisional liquidators and the court, and I come to this, not by the company, we say, you will have read in the skeleton, that they intentionally withheld the existence of a scheme in another jurisdiction. Cobra and Kim, on behalf of the company, in my characterization, brushed off the petition and said, well, there will be enough out of the sales that the trade creditor debt will be met, and didn't say anything more about it. So I suppose the question we have is, because we don't have a scheme, this many months after the provisional liquidation order was sought and obtained and the petition was lodged, don't know what the position is. But it sounds from Cobra and Kim's correspondence in that context that they now also intend to add trade creditors. But that's, that is, I suppose that's a question for the company ultimately, what they intend to do. My lords, thank you very much for your question. Moving back to, I was discussing scheme of arrangement and the requisite majorities. And so what we say flows from the judge, unfortunately, not considering in any real manner the requirements of Section 99. The judge then didn't really consider the evidence that would suggest that there was a reasonable prospect of a restructuring, in other words, the scheme ultimately being approved. And we say he's bound to consider that, and the learned judge did not. What the judge has said is that the company should be given an opportunity to work with the JPLs on the current proposal, which is the capitalized term used for what I suppose is now being proposed by the company. But of course, what the judge hasn't done in his reasoning is provided any reason or view that the creditors will, despite their very clear and unequivocal views throughout, will change their minds such as that a scheme will pass. And I should say, if he were to do that, the proper conclusion would have been that they won't change their mind, because, my lords, there is no evidence and there's nothing provided by the company that suggests that they will. It seems to me that there's a hope that ultimately they will
It's
change.
complete speculation, isn't it?
My lord, it is. And that's where we say that the learned judge has misdirected himself, because if he squarely had in his mind what those requisite majorities were, then he needs to move into an analysis of, is there a reasonable prospect? And it is, my lord, you have said it exactly, it is complete speculation. And in fact, I would go beyond it being complete speculation, because this isn't a situation, my lord, where we have a petitioner representing a class and we don't know the views of the balance of the class. In fact, we know it very clearly. They've all pitched up, not all, a number of creditors representing almost 65% of aggregate value pitched up and said, we're not interested. So it's beyond speculation. It's really hopeless, we say. Yes. So, my lords, to continue, I mean, we know what the, and I'll come to the test, and but we know that legally there is a meaningful hurdle that an appellant in these circumstances must meet in terms of a discretionary decision, and we know it's was there a mistake in law? Were there facts that were considered that ought not to have been considered? Or were there material facts that should have been considered by the judge at first instance that weren't? And certainly we say that, and Muller, the authorities actually go on to say that even in circumstances where those mistakes aren't readily identifiable, if overall the appellate court is of the view that the judgment below couldn't have been reached by a reasonable judge in any event. That is when the appellate court has the ability to exercise a discretion of its own. And we certainly say that this is such an error by the judge that engages the Court of Appeals discretion.
Right.
Lord, we also say that the judge has made a very serious, and in fact, a serious mistake, respectfully, in how he has dealt particularly with the creditor, with the views of creditors. And there's two aspects to this that I will address. The first is, based upon the judgment, it appears the judge has misunderstood, because he hasn't mentioned it at all in his judgment, the fact that the fourth affidavit of Mr. Shum, which in the abstract may not assist you, but that the fourth affidavit of Mr. Shum, which did two things broadly. It provided evidence of the company's purported restructuring progress. Number two, it also countered certain statements and evidence given in the reports of the provisional liquidators that were highly critical of the company in a number of ways. And the way these hearings were conducted, my lords, is that you will see from the front pages of the judgments, there were a number of sort of, and credit to the judge, quite frankly, there were a number of hearings that he sort of fit into his calendar to try and move the matter along as quickly as he could.
You seem to be meeting every Monday.
I can't remember whether it was meeting every Monday, my lord. I think everybody would agree, including the judge, that it wasn't an ideal situation, but he was busy and was trying to move it along. Yeah. So no criticism. But what happened is affidavits would come in, unfortunately not ideally, the morning before these hearings. And the company would, in the submission of the appellant, the company would put affidavits in late in the process and sort of submit, well, the creditors haven't actually had an opportunity to consider this. And those seem to be difficult to know. Those seem to be gaining traction with the judge. So when Shum 4 came in, and I'll take you to this when I come to the particular point, Mr. Shum actually submitted in his evidence that the court should give very little weight to the views of the creditors because of certain statements that he maintained were wrong, incorrect, inflammatory, and were prejudicing the views of the creditors against the company.
Statements by whom, Mr. Taylor?
Statements by the provisional liquidators, my lord, right, in a meeting of creditors. And so Mr. Shum was suggesting that the court shouldn't give any weight to the views of creditors because it had been tainted by the provisional liquidators' statements. And in fact—
Is this at the meeting in January of this year?
That's correct, my lord. And there was also a letter. There is a bundle of, there's a bundle F, my lord, that is the correspondence bundle. And as happens in these matters, correspondence is submitted to the judge. And there was a letter of the 25th of March from Mr. Fung, one of the PLs, to the creditor bodies, to all known creditors. And that is in fact at tab 1 of that bundle, and I come on to that in the course of my submissions. But when I take my lords to the learned judge's ruling, he does not mention that in fact what the petitioner did in order to give the judge the creditor's view and to sort of deal with this allegation that the weight should not be, and no weight should be accorded, was Shum 4 was sent to those creditors that the petitioner was in contact with in order to show them the company's response to these statements that they said were inflammatory and incorrect and effectively prejudiced the views of creditors against the company that the PLs have made. And I'll take you to this. But the creditors, in spite of reading Shum 4, all maintained their support for a winding up order. And when we come to the judgment, my lords, what the judge has done, we say, is he has erroneously, it's not as clear in the judgment as I hoped, but it appears from the language that the judge has accepted the company's submission that indeed the creditor view should not be given weight because they haven't had an opportunity to properly consider the current proposal. And we say he's erred there on the fact. But what he's also done in engaging in that exercise, we say, is that he has made an error in law by substituting the view of either the company or his view as to what is in the best interests of the creditors of this company. And my lords, we say that is a very settled proposition, and that the judge has fallen into error in that regard as well.
Just a second. You
Yes.
say that's a very settled proposition. Whether or not a winding up is to be ordered is a matter of discretion for the judge.
Yes.
It is true that there are authorities which say that if a majority of the creditors, for good reason, propose that there should be a winding up, it will only be if in some special case or some exceptional case that the judge will not make such an order. But in circumstances where the judge doesn't make such an order, it will likely be, will it not, because his view is that the better course is for the moment not to wind up.
My lord, yes, but the caveat on that is, we say, is that when assessing the views of the creditors as to what is in their best commercial interests, what the learned judge, we say, has done, and he's not permitted to do at law, is to decide that his view as to what's in their best interest is actually the view as opposed to what the creditors say. Their own commercial view, and remember, the point I'm making here.
I'm sorry, say that again more slowly. He has decided that his view is?
His view as to what is in the best interest of the class, or the
Yes.
company's view as to what is in the best interest of the class. He's found that that is actually in the creditor's best interest as opposed to what the creditors view their own best interest as. And so, my lord, the point I'm making using a practical example is this, is that if a creditor determines that it would prefer to have a winding up order today, and that yields a particular return of 15 cents on the dollar, to use an example, as opposed to waiting for a period of a year when a company says you will receive 15 cents plus X because of this plan. If the creditors say that that is in their best interests, the authorities provide, my lord, that it is not for the court or the company in this case to say otherwise.
Yeah, I see.
And I will take you to those authorities. And I think this is the difficulty that the judge has fallen into factually as well. Because I think when we look at the language he's used in his ruling, he's misunderstood that the creditors haven't fully formed a view on this proposal. And the reason they have is twofold. One, they received Shum 4 and considered it and confirmed their views. But number two, you recall there was a previous proposal that was encompassed by way of a scheme that was unsuccessful. And it's the same proposal. And Mr. Shum confirms that in his evidence. And so this case is somewhat unusual, my lords, in that we had a dry run. When I say we, I mean the company and the creditors had a dry run at this in 2021 and it didn't work.
And why didn't it work in 2021?
Well, what ended up happening was, and I will take you to the evidence on these through the public announcements at the Hong Kong Exchange, was a very similar proposal, which was encompassed in a scheme of arrangement, was put to the creditors. And the company did obtain sanction from both courts in Hong Kong and Bermuda to convene scheme meetings. Ultimately, and we'll see why in the announcements, difficulties arose primarily because the company didn't have the support of the creditors. So the meetings were never held. And so that's a unique feature of this case. And we say the judge hasn't properly considered that either, in that we are not heading towards some new proposal in substance that the creditors aren't aware of or don't know about, or sort of we take a wait and see it. We say it doesn't matter if it was new, because their sentiment's very clear. But they've already seen this, it's already failed, and they don't want it again. They don't want it proposed again. And that's a unique feature of this particular proceeding.
So, Mr. Taylor, you say that we should infer that the company did not have the numbers because those meetings were never held, and that if the creditors would have supported the proposal put forward in 2021, then the meetings would have been held.
That's correct, my lord. And I will take you, because in the evidence, there's an affidavit of an attorney in my office, Ms. Arnold, in the material that exhibits the Hong Kong Stock Exchange announcements that go from announcing court sanction through to the point when the company has sought leave to withdraw the scheme meetings.
Did it give reasons? Did the company give reasons for the withdrawal of the proposals?
My lord, they did, and I can take you there now if you're interested. Bear with me. Yes. My lord, this is it's actually bundle D, which is the exhibit bundle.
I've got bundle D123, so which one?
It's bundle D binder 3. It's entitled Affidavit Exhibits on the front. It's a relatively thick binder.
Relatively thick. The bundles require Herculean strength to manipulate.
And my lord, they do. Unfortunately, I'm doing this remotely from Toronto, and they were boxed and sent to me. So
yes, well, they were boxed and sent to me too. D3.
D3, tab 15.
Right.
So, my lords, there's a bit of a time frame here. So perhaps we start at page 312 on the bottom right. 3192. 3192. Yeah.
Yes.
So this is an announcement of the 14th of December, whereby it says 14 December 2020. It says the directors are pleased to announce that on the application by the company, an order was granted by the Bermuda Court on 11 December 2020 to convene meetings of scheme creditors. So that announces the Bermuda order. And then if we go over the page to 3193, under the heading Adjournment of Scheme Meetings, it says, as the company and sound agents have been engaged in ongoing discussions with some of the major scheme creditors, which may in turn have implications over the terms of the court scheme at each of the scheme meetings held today, a resolution was tabled for the relevant meeting to be adjourned for up to 3 months or to such other date as directed by the Hong Kong court and the Bermuda court, with the exact date to be published upon confirmation. The proposed resolution was approved at each of the scheme meetings by unanimous vote of all those scheme creditors who attended and voted at the relevant scheme meeting. Accordingly, the scheme meeting stood adjourned, and the company will further apply to the Hong Kong court and the Bermuda court for the appropriate direction. So it was adjourned. And then over the page to 3195. There's the title that says leave to withdraw court scheme and scheduled dates of new court scheme. It says following the recent discussion among the company and the major scheme creditors, the company anticipated that the court scheme will need to be amended, as the amendments will be substantial and will entail, among other things, changes to the composition of classes. Thus, the company applied to the courts to withdraw the court scheme. On 12 April 2021, the Hong Kong court has granted leave for the company to withdraw the court scheme. A new court scheme incorporating the amendments as aforesaid is currently under preparation, expected to be finalized shortly. The leave hearing and the sanction hearing for the new court scheme are now scheduled on 7 May 2021 and 16 June 2021, respectively, and court dates have been reserved. Accordingly, the adjourned scheme meetings as scheduled on 16 April 2021 is canceled. And then finally, my lords, over to page 317.
3197.
3197, yes, my lord, my apologies. Under the heading scheduled dates vacated on application by the company. It says, since several of the major terms and conditions of the new court scheme are still under negotiation between the company and the major scheme creditors, the scheduled dates for the leave hearing and sanction hearing of the new court scheme on 7 May 2021 and 16 June 2021, respectively, becomes unrealistic. Therefore, the company's applied to the Hong Kong court to vacate those scheduled dates, and further necessary application on leaving hearing and sanction hearing would be filed upon the completion of the new court scheme. The approval to vacate the scheduled dates has been granted by the Hong Kong court on 3 May 2020. So, my Lord Justice Bell, in response to your question, quite clearly,
we can infer that they didn't have the support they needed.
Absolutely, my Lord. And those are the company's own announcements, of course. So when I say that there's the unique feature of this particular proceeding is that unlike when a company comes to court the first time on a proposed restructuring, rehabilitation, whatever the case may be, we know very well what was proposed, and we know that they've said no. So it's not only that they continue, it's from the outset. The company has not had the support for this. So, Lord, that's at a high level the summary on, my lords, on creditor sentiment. We also say that the company has committed serious breaches of the light touch appointment order. And the reports of the JPLs, as you will have noted, consistently record the company's failure to provide relevant information to enable them to carry out their functions. And we say very seriously, subsequent to the first substantive hearing, the company procured 2 group companies to pledge shares in subsidiary holding companies. And we say that these were made in breach of the appointment order. We say that they were made outside of the ordinary course of business, and they were unquestionably made without notice to the joint provisional liquidators. And so we refer to these pledges as the New Soho share pledge and the Shangyang share pledge in relation to the parties to whom those pledges were made. Those are third parties. They are not related to the company or the group. And, my lords, I should say, extensive submissions were made to the learned judge about the impact and the import of those share charges. And I'm afraid to say that the learned judge in his judgment, while referring to submissions on the issue, does not make any determination as to whether, in fact, these share charges breach the appointment order, whether, in fact, those share charges resulted in a dissipation of assets. And we say, quite importantly, the judge doesn't consider in his judgment the import. It's a very important fact. These findings would have then caused the judge to analyze whether management's conduct, we say misconduct, what that means for the continuation of the light touch order and protection of creditor interests. And I'm afraid the learned judge doesn't address those issues, because we say it goes without saying that if management is failing to abide by the order appointing the provisional liquidators, the judge needs to consider whether those breaches are such that they disentitle management to any further accommodation. Because the entire purpose, the entire structure of a light touch provisional liquidation is to allow management to continue in place, and the provisional liquidators have an oversight function. Their primary duty is to the court, of course, and to report to the court. They also have a duty, of course, to act in the best interest of creditors and to make a determination as to whether the continuation of a light touch order is in the creditor's interest. And part of that analysis, very crucially, is whether management is living up to its obligations. And effectively, its pledges to the court, or the court expectation, that it act with utmost good faith and in a straightforward and honest fashion. Because if management refuses to do that, then the whole process breaks down. And we say that's exactly what's happened here. The interplay between the provisional liquidators and management has been fraught with difficulty from the outset. So the judge should have considered that, in fact, we say the company wasn't acting with utmost good faith in the best interest of creditors in relation to these transactions. And importantly, the reason the transactions are so important is the provisional liquidators have not been given any opportunity to opine on those transactions, to investigate them, to understand the counterparties with whom management has entered into these transactions, and whether or not, in fact, they're in the best interest of the creditors. The judge hasn't considered that at all. We say that that's a serious and meaningful error that the judge has made. Along the lines of, and along these lines, there's another significant, we say, significant gap in the judge's ruling and in his considerations. And that is in relation, my lords, I mentioned the Hong Kong winding up petition. That, my lords, and we'll bring you to this, because this was all discussed. I made detailed submissions to the learned judge on this, and it doesn't feature at all in his ruling. And we say that's very problematic. So this trade creditor, my lords, is Kuwait Petroleum Company. It's a trade creditor. And it lodged a petition. It presented a petition to the Hong Kong court on the 12th of April, 2022. My understanding is, based upon what counsel in Hong Kong to the petitioning creditor Kuwait says, it was served on the 12th of April. And of course, this is happening in the midst of our arguments before the learned judge, because it started on the 8th, but it extended over a period of a number of hearings. Mr. Shum affirmed his sixth affirmation on the 22nd of April. And so that's some 10 days after the Hong Kong petition was served on the company. And so, and my lords, what happened was, and we say in breach of the order, and I'll come to this when I take you to the documents, and the provisional liquidators view this to be in breach of the order, we say. Mr. Shum did not reveal this to the court or to the provisional liquidators. He had every opportunity to do so in his affidavit of the 22nd of April, but it wasn't communicated to the court. Importantly as well, what the company did not do, contrary to the Hong Kong listing rules, the Hong Kong Stock Exchange listing rules, is the company did not publicly disclose the existence of the petition on the message board of the Hong Kong Stock Exchange. And of course, Lords, the appellant petitioner's position now and before the learned judge was that that was an intentional, considered decision not to reveal that petition because creditor sentiment and view was very important, and the company did not wish to bring that to the attention of the judge in the course of these hearings. But for some reason, my lords, the judge doesn't deal with this at all. And so, unquestionably, for these sorts of appointments to work, the company has to be open and honest and can't, by omission, not provide all relevant facts to the court, and they didn't do that. So, and unfortunately, once again, for whatever reason, that fact and that analysis wasn't in the judge's order, or pardon me, in his ruling. And we say that's a serious problem, which then ought to have caused the judge, along with what we have said about the shared charges, it ought to have caused the judge to consider very carefully whether management's conduct was such that the light touch provisional liquidation ought not continue. And he didn't do that. And so we say, at a high level, my lords, what I've described are the learned judge's failure to take into account relevant factors that he ought to have in making his decision. And because he hasn't done that, and because these are very material omissions, that then opens the door to this court, my lords, to then exercise a discretion of its own. And we say that in all of the circumstances, the discretion you ought to exercise is to wind up the company immediately. So at a high level, my lords, those are the submissions you'll hear in some detail. The next thing I intended to do, my lords, is just, and some of these we've discussed, but just a quick background facts to, I hope, assist, my lords, with sort of what we consider to be the key facts in the time frame. Right. And so, and these come from the evidence, and I don't believe that there's controversy, but undoubtedly, if there is, my learned friend will address you on those. So the company's financial difficulties arose in early 2020. The company first defaulted on the petition debt, or at least a portion of the petition debt, because there were subsequent sums that became due on the 2nd of September 2020. And so we're looking at almost 22 months ago when that occurred. And my lords, of course, I have taken you and I've explained the company's proposed schemes in both Hong Kong and Bermuda, and that those meetings were to be held in January. And I've explained to you why those didn't come, and I've invited you I've invited you to conclude that those meetings didn't take place because the creditor body didn't support it and the company was aware they wouldn't be sanctioned. The terms of that scheme envisioned a sale of group assets to pay creditors, and that is the same as the so-called, we call it current proposal, and that was a defined term that the company placed on what this is, which the judge then carried on with, which we say it's a misnomer. It's not a current proposal at all. It's really the same proposal, just presented later. We know that the scheme was withdrawn by the company, and I've taken my lords to that. Since that first default, or I should say that the company has received, or pardon me, that the petitioners received no payment since. The petitioner served a statutory demand on the 30th of September 2021, which was not met, and so the company is unquestionably cash flow insolvent. The petition was presented on the 22nd of October of last year. And then 2 days prior to the first return of the petition, on the 17th of November 2021, the company filed its light touch application to appoint provisional liquidators for the purposes of restructuring. Now, I pause there. In his initial ruling, the judge referred to this as a proactive step by the company that was not brought, on his words, on a quote wing and a prayer. We would obviously disagree with that in the context of bringing it 2 days before a petitioner's winding up petition was due to be heard. Of course, a proactive filing might have taken place in April or May 2021, at the point in which it was clear that the previous scheme was not successful. So since that initial filing, my lords, as I've said, there have been no payments received whatsoever by the petitioner. The learned judge initially adjourned the petition for 4 months to the 8th of April 2022. He subsequently adjourned the petition for an additional 3 months to 8 July 2022. And subsequently, and this is in the company's authorities, at the final tab, I believe, you will see in the most recent ruling of the judge that he has now adjourned for an additional 2 months to 2 September.
Yeah.
And that this is nearly 2 years since the default of the initial petition debt, and 11 months since the petition was presented. And as I've said, my lords, the company has not to date provided any scheme document to the creditors representing what they call this current proposal. And they have not to date entered into any agreement to liquidate any group asset with any potential purchaser, conditional or otherwise. So there are some letters of intent. There are some statements of people being interested. Some purchasers have, we are told, shown interest and have dropped off. One creditor by the name of China Huaneng was interested at one point in what are called the LPG assets, but they've dropped off. So here we are, this far down the track. We don't have a scheme, and we don't have any agreement to sell any assets. And of course,
are all these debts unsecured?
They are, my lord. Yes, that's correct. And in fact, I should say as well, in relation to the Hong Kong petitioner, and I'll take you to this letter. Hong Kong counsel for the company has indicated that the trade receivables, the debt which forms the subject of the Hong Kong petition, are not secured either.
Yeah.
So we're talking about unsecured debts, my lord. Yes, thank you.
Yes.
And of course, lords, I mentioned as I say, I've mentioned the Hong Kong petition, which was not a recent development, but happened in April. So again, those are the background facts that I hope give my lords a time frame of what's taken place. What I'd like to do now, if I may, is I'd like to describe what the company refers to as the current proposal.
Yes.
So I think, my lord, it's important for you, of course, to understand what the company says the current proposal is. And so could I please ask you to find bundle C for me? These are the affidavits.
Mm-hmm. Yes.
And these are summarized by the company in Mr. Shum's affidavit, which is at tab 1. And I'd just like to refer you first to page 174. My lords, first, just beginning at paragraph 5, Mr. Shum's affidavit reads that the company wishes to avoid an immediate winding up order, which it's considered would cause significant damage to the interests of the creditors of the company. In order to do so while giving the lenders the comfort of independent third-party supervision, the company seeks the appointment of provisional liquidators on a soft-touch basis for the purpose of supervising the company's implementation of a debt restructuring by way of scheme of arrangement. And then to paragraph 8, secondly, the current proposal for a scheme of arrangement as defined below is well advanced, having previously progressed to the point of arranging meeting dates with sanction of this court. And he goes on to say, and should be capable of the implementation of certain limited differences between the company and its lenders can be resolved through negotiations facilitated by the JPLs. So I draw your attention to those paragraphs, my lords, to make 2 points. Company's evidence, it is clear that they are going to proceed by way of a scheme. And my Lord President Clark, you posed that question. And in paragraph 8, it's also self-evident that what is now being proposed is the same as before, because Mr. Shum makes clear that the current proposal is well advanced, having previously progressed to the point of arranging meeting dates. And so the company's own evidence make clear that this is not anything new, and it's really just a continuation of what was done previously. Now, Lords, my Lord President, as you and I discussed near the outset of the hearing, payment to creditors is envisioned to be initially on the 30th of September, but extendable to 31 March 2023. And I'm going to ask you to now please turn to page 184 of the same affirmation of Mr. Shum. And again, he says, the current proposal is the result of ongoing discussions with the lenders since May 2020. So again, there's no question that Mr. Shum views this as the same proposal. Now, in paragraph 40, over the page at 185, under heading F, sale of LPG asset, at paragraph 40, Mr. Shum says, since the beginning of the restructuring negotiation, the company has taken active steps with a view to dispose of its assets so that the lenders could be repaid. In respect of the LPG asset, the companies engaged Norton Appraisals Limited to prepare a valuation report in June 2020, which valued the LPG assets at US $548 million. So one of the, and when it's called LPG assets, there are a group of assets that the company says it will sell, and there's an appraisal which is now, you will appreciate, more than 2 years old, my lords, that indicates that those assets are valued at 548 million US. Over the page, at page 188, this is at sub B, 51 sub B. At this point, the company is giving an indicative view with regard to China Huaneng, which I discussed, and said the purchase price would range from US 270 million to US 450 million, and the transaction would be completed by 30 September 2022. So the company's evidence suggests that, and as I say, China Huaneng has now dropped out of the process, we're told by Mr. Shum in subsequent evidence. But even if it were sold, if these assets were sold at 450 million US, which is, we say highly speculative, of course, because we have no purchase and sale agreements. That doesn't really come close to covering the overall creditor debts. In other words, the company's own evidence has the aggregate debt load of the company at somewhere north of 860 million, and that's on their figures. So significant shortfall. So the company is also proposing to sell a property called the Zhuhai Commercial Complex, which they say is valued at 248 million. But similarly, even at those figures, the company won't be able to satisfy creditor debts in full.
So where's the reference to the commercial complex?
I'm sorry, my lord?
Where's the reference to the commercial complex?
Yes, my lord, I will. Well, I don't have it to hand. I'll certainly come to it.
Okay.
I'll certainly come to it.
And what did you say they were hoping to sell it for?
Well, I think the value was 248 million, and I certainly come to it when I discuss the share charges that I've referred to.
Okay.
Yes. All this really to say, my lords, that even if the company is able to liquidate those assets at the high end of the indicative purchase price or the valuation, we're talking about a sum less than what creditors are owing, and so ultimately there will need to be a compromise by a scheme if that's what the company intends to do, and if they can actually engage in these sales. So my lords, this is the current proposal. As I say, we do not have a scheme document to reflect that. I would like to move on. We talked about creditor sentiment. My lords, I'm going to take some time on this. I'm going to take some time on this section and take my lords through the evidence so that I'm hopeful that you're comfortable that the position of the creditors is clear. May I ask you to just stay in bundle C, which are the affidavits, and turn over to tab 17.
Mm-hmm.
Lord, this is the third affirmation of Ms. Lung, who is a Bermuda admitted associate in the Walker's offices or Hong Kong offices of Walker's. So I'm going to ask you to turn over to page 365. And in paragraph 6, Ms. Lung says this, that on 6 and 7 April 2022, the petitioner sent emails to the supporting creditors, attaching a copy of SHM 4 and asking if the supporting creditors could confirm whether there was any difference in their position on the petition. And it says on 7 April 2022, Walker's, as the petitioner's attorney, sent a letter to Kerry Olson stating the petitioner had sent a copy of Shum 4 to the supporting creditors. And so, my lords, this is the process I explained at the outset of my submissions, whereby late evidence was filed wherein Mr. Shum questioned whether creditor sentiment should be given any weight. And Ms. Lund goes on to say all the supporting creditors sent email correspondences to the petitioner confirming that their position remained unchanged and that they continue to support the petition. And copies of these emails are found at LMKM3. So, Lords, now over the page, and this is what had traditionally over the course of the hearings been presented to the judge, whereby the creditors who were supporting the petition, their views were summarized in this table. And so, Lord, you'll see in the fourth column over under percentage of debt owed, there's a footnote there, and these percentages are actually based on the company's evidence. Back to paragraph 78 of Shum 1, his 15 November 2021 affirmation. And so you'll see on the left, ABN AMRO, ANZ Bank, Cathay United, number of banks, and their percentages. And then over the page to 367, this affirmation, which was affirmed on the 8th of April, 64.8% of creditors, and that represents the aggregate unsecured debt of the company based on the company's evidence, seek a winding up order and aren't interested in a restructuring. And I should say, before I leave page 366, number E in the left column, do you see there's a bank there, Dosing Bank, and it says date of support emails 8 April 2022, and they're owed 1.2%. Now I'll come to why we say that this is important later. At the outset of this hearing,
just wait a moment.
Of course, Miller.
These are an email was sent to people described as the supporting creditors, paragraph 5 of the affidavit, who had confirmed their continuing support for the petition.
Yes.
So this, all the people who no, I'm so sorry. I follow. This is support for the petition.
Yes, my lord. Correct.
Yeah,
correct.
No,
quite all right. Quite all right. No, I'd
I'm
much rather we clarify things as we go. Quite obviously.
Yes. Right. No, I'm sorry. I've understood. Yep.
Not at all. I was referring to number E in that chart, and there's a bank, Dosing Bank Limited, and I was saying that Dosing is significant. We say because this is the first time that Dosing had actually come forward and said we seek a winding up order, and I'll come to why that's important in terms of the judge's reasoning a bit later as well. So. And as I was saying, the 64.8% reflected at page 367 is the percentage of aggregate debt out from the company's evidence. And reminding again that all of these creditors seek a winding up order and did so at the hearing, at the subject hearing, and no creditors had come forward to support the company. Now, what I want to do, and I'm afraid, my lords, I'm going to do it to you. I'm gonna ask you to flex your collective muscles, please. And I'm going to, well, actually, before I do that, while we're at bundle C, why don't we turn over to tab 14?
Which tab?
Tab 14 of the same bundle.
1-4, right.
Yes, please. And so, my lord, this is an affidavit. This is the fourth affirmation of Mr. Shum that was affirmed on the 1st of April, 2020. And you'll remember at the outset of my submissions, I had mentioned that the company took grave exception to the manner in which the PLs were behaving, they said, and they had misled creditors and made statements that were incorrect. And so what Mr. Shum did in this affidavit was set out his views in that regard, and he also set out, you know, the progress that he says the company had made in moving ahead with this asset sale. And so, Lords, just if I could ask you to look at paragraph 46, which is page
351.
351. Mr. Shum says at 46, on the basis that the creditors received information from the JPLs which contains untrue and unfair allegations against the company, which also omits material information regarding the company's progress in sale negotiation, I believe that little weight should be given to the purported creditor's support garnered by the petitioner, which is corrupted based upon misleadingly and incomplete information. And so, Lords, I'm not going to take you through this affidavit in detail, other than Mr. Shum does take the time here to explain all of the reasons why he says the JPLs have been unfair. Well, some of the whether they're all or not, I don't know, but he goes through in some detail why he says the JPLs have done things wrong, and that's in sub B at page 346. He has response to JPL's obligations. He says they refuse to meet a potential buyer. They refuse to provide contact information of a bidder. They allege a conflict of interest in using Allen and Overy as counsel. And so what the appellant petitioner then did was say, well, okay, we wish to give the learned judge below the information of what the company now says about what the PLs have allegedly told the creditors that's been misleading. And so Shum 4 was sent to them. And the point I'm making is that Ms. Lung's affidavit of the 8th and the support that's set out therein was all confirmed with these creditors post their having seen Shum 4 and being provided with it. So that's the point, and it's an important one. And it's not only important for what happens, so we can independently rely upon creditors' sentiment, but I'll come to it, and the judge has made a mistake here, and it's important, and I'll show you where we say he's made a mistake, the learned judge. So now, could I please ask my lords to go back to, well, we've seen the percentage at tab 17 being 64.8%.
And it goes up a bit later.
That's correct, my lord. And of course, I've made the point that Dossing was a new creditor. What I think, though, what I will do to contextualize the creditor position, and this is where I said that I was afraid I was going to ask you to flex your collective muscles. Could I please ask you to turn over bundle D? And it's actually bundle D binder 3, which is the one where I showed you the Hong Kong Stock Exchange announcement.
Mm-hmm.
And I'm going to ask you if you would please turn to tab 17. And this is at page 3227.
Yes.
Yes. My lords, this is an email of the 8th of April. And of course, that was the return date of the hearing, but the 12:46 p.m. I assume is Hong Kong time. And it's from Mr. Paul Liu at Wilkinson and Grist. And they are counsel for Citibank, one of the creditors. And it's to Ms. Chan, who is a lone workout person with the petitioner. Well, I don't think I need to read it all out, but perhaps ask you to read what Mr. Liu says about his about his client's views in relation to the petition.
Shall we read that?
Yes, please, Mark.
Yeah.
Yes, my lord, and so to be entirely honest, not all of the emails that came back from these creditors were as detailed as the one from Mr. Liu for Citibank, but they all advised that they haven't changed their position. And for good order, my lords, if I could please ask you just to turn back to page 3224, just so that you're aware of what was put to the creditors by Ms. Chan. Could you read that email from Ms. Chan? This is an example. It's to Lydia Shum at Dawsing Bank of the 7th of April. And this is the email that the petitioner sent to the creditors, just so that you're aware of what was put to them that prompted their responses.
Yes.
Yes, my lord. So as I say, we say that there can be no question that the creditors had the countervailing view, if we can put it that way, of the company, and then made their views known by way of these responsive emails that were in evidence at the hearing. And so now what I'd like to do, armed with that, is I would like to now ask you to please have to hand bundle A, which is the very thin bundle that has the learned judge's rulings amongst other documents. And I'm going to ask you to turn over tab 5 at page 76. Now this is the subject ruling of which the appellant complains. Actually, my lord, the first ruling is actually the one I referred you to, is actually the decision. And effectively what the judge did was he issued a decision on the 9th, and then he issued a latter ruling, which is dated the 31st. And so I'm going to ask you now to turn over to page 80, if I may. Before I embark on the specificity, it's an unusual ruling, in that, at least from my perspective, Lord, take from it what you will. It's an unusual ruling in that the judge's approach seems to have been to summarize the submissions of each side, and then reach conclusions, but not always particularly provided analysis of why he's done that, the facts he's accepted, or the law he's applied in all circumstances. So I'd like to start in relation to the creditor's sentiment issue at paragraph 17. And so paragraph 17 reads as follows. Mr. Robinson submitted that the petitioner had not been able to obtain any additional creditor's support in favor of winding up the company. So the first thing I'm going to do is I'm going to pause after that sentence, because I have just shown you that one of the new creditors that appeared was Dah Sing Bank. So I'm not, and ultimately, as I say, the judge here is reciting a submission. He doesn't actually then go on to say whether or not he's accepted that submission. But if he has, that's clearly incorrect, because we did have an additional creditor come forward. See, but here's so that's an important point. But here's another important point. Goes on to say that he argued that the support of the existing creditors is tainted by multiple factually untrue material statements about the company made by the JPLs at the creditors meeting before the support was reconfirmed. Thus, little weight should be given to the purported continued creditor support. So, and this is where, my Lord, the petitioner has difficulty, and we say the judge has made an error because he hasn't recognized or recalled that, in fact, the creditors had seen all of the complaints that Mr. Shum had put into evidence by way of Shum 4, such that they were fully aware of the company's position. And so if we then go ahead to paragraph 24, and here's where the judge is now summarizing the petitioner's submission. And again, he begins by saying, second, a significant majority of the company's creditors, including the petitioner and the supporting creditors, supported and continued to support the winding up of the company. And really, other than that statement, the judge doesn't go into any further detail. And he certainly doesn't mention the interplay between Shum 4 being sent to the creditors and their views. And then, once again, moving ahead in the judgment to paragraph 39. The judge says here that in respect of the court's exceptional circumstance 4, I've once again given serious consideration to the views of the creditors and to their position atop the hierarchy of interest that I should bear in mind. Their position remains that they are not interested in restructuring of the company. Mr. Robinson's submissions, in essence, were that the creditors have not given proper consideration to the efforts of the company. Moreover, that they have been prejudiced in one way or another against the restructuring efforts. In my views already stated, the company should be given the opportunity to work with the restructuring troops, that's the JPL's words, so that the proper information can be collated, analyzed, and properly put before the creditors for their full consideration. So, Lars, here's the difficulty. The difficulty is that the judge hasn't recalled and hasn't mentioned the provision of the Shum affidavit. And when he goes on to say, put before the creditors for their full consideration, it certainly does appear, despite the fact that there's no express finding, that he's accepted my learned friend's submission that the creditors haven't given these full consideration, which on the facts is absolutely incorrect. To the extent that the company has provided any information, and particularly in the context of him citing Mr. Robinson's submissions that the views of the creditors have been prejudiced, the judge seems to accept the submission when the facts are absolutely incorrect. The facts are very clear that the creditors saw the company's response. So that is a finding, assuming it is a finding, and I think it is, because he says, my view is that the creditors should be giving their full consideration. It's a finding that the creditors don't actually know what the current proposal is and haven't considered it. And I think that's just fundamentally contrary to the evidence in the hearing. And it's a significant error.
Well, just there are two different questions, aren't there?
Yes,
one is whether or not the creditors had been made aware of the criticisms that were being made by Mr. Schum, to which the answer is yes, they were, but the judge doesn't refer to it.
correct.
The question number two is whether the creditors were aware what was the nature of the scheme that was proposed, to which you say, yes, they were, because the scheme that was proposed was effectively a rerun of the previous one.
That's correct, my lord. That's correct.
But we don't have the detail of what is actually proposed, do we?
Well, the only detail we have, my lord, is, as I say, the sale of these two.
Right.
But you're right, we don't have the detail. And, we don't have the detail. What I can say clearly is that to the extent that the company has provided any detail to this point, which it's their responsibility to provide, I add, the creditors have considered it and don't want it. And as I say again, the unique feature of this case is they're aware of the previous scheme that Mr. Schum himself says it's effectively a carry-on of that. We saw that in the evidence.
Right.
President, we've been sitting for an hour and a half, and I wonder if this is a convenient time to adjourn just for 10 minutes.
Yes, I think we might, if that's convenient to you, Mr. Taylor, is that convenient?
My Lord President, very convenient. Thank you so much.
Okay. We'll
Thank you,
adjourn.
Mr. Craig.
Thank you.
Mr. Coelho, do you want us to go into the breakout room? Mr. President, do you want us to go into the breakout room?
Yes.
But if I click leave meeting, it will offer me the breakout.
There's a joint breakout room.
Well, that's my problem, is there isn't on my screen.
At the bottom, in the middle.
I know. Oh yes, I see. Yes. Mm-hmm. Right, I think we're all here.
Yes, my lord, thank you. My Lord President, during the break, Ms. Tovey's helpfully found some of the references into the evidence to some of the questions you posed, my Lord. You had asked about the value of the Zhuhai commercial complex.
Yes.
And I can say that at paragraph 16B of Mr. Shum's fourth affirmation, he confirms that according to a valuation report prepared by Savills, a well-established real estate consulting company dated 29 November 2021, the Zhuhai commercial complex is worth, there's an RMB figure of 1.8 billion, which he then says is approximately US 286 million.
Yeah.
Which I believe is the figure I gave you, my lord.
Yes.
You had also asked about...
Mr. Taylor, before you go on, could you just give me the page reference to 16B of Shum 4?
Yes, my lord, it's at page 341, and that is in bundle C.
Right.
I'm obliged, my lord. My Lord President, you also posed questions about the company's early evidence in relation to creditor support for the
Yes.
petition. I can provide you the evidential reference there as well. At Lawrence Shum's second affirmation, which is at tab 3 of bundle C, he deals with those in paragraph 9.
Yes.
So, and I should, my lords, you will wish to read those. Cathay United Bank at 9A has subsequently said they support the winding up order.
All right, give me a page number, Mr. Taylor.
Yes, my lord, that's at page 209 of bundle C.
209.
That's correct. And so there, Mr. Lawrence Shum summarizes what they say are creditors' support. But as I say, one of them is flipped and most of them are equivocal and conditional upon certain things happening or seeing this or that. So I thought that might assist.
Thank you. It's very helpful.
Yes. Now, before we, my lords, before we took the break, we were talking about how the Shum's fourth affirmation was sent to the creditor before providing their views.
Mm-hmm.
I've shown you paragraph 39 of the learned judge's ruling. I mean, we also say that what the judge has effectively done here is he has substituted the company's view in terms of what's the position and what's in the best interest of the creditors with the stated view of the creditors themselves. And so, Lord, if I may ask you, I think the simplest way to make references to the authorities here is at paragraph 80 of the appellant's skeleton argument. And so at 80 sub A2 in Reed Crigglestone Cole, the cited passage is the court gives effect to such right as the majority of the class desired exercise. This is no exception. It is a recognition of the right, but affirms that it is not the right of the individual, but of the class. That is for the majority to seek or to decline the order as best serves the interest of their class. It's a matter upon which the majority of the unsecured creditors are entitled to prevail, but on which the debtor has no voice. This passage was quoted with approval in P&J McRae, which is also in our authorities, and in Maud. Now, 80 sub A1, this is an authority that, my lords, and my apologies for this, the wrong version of the authority had actually found its way into the bundle. I think what you were provided was a judgment or ruling on consequentials of Mr. Justice Snowden. This is in the subsequent authority that was sent to replace that authority. And whether that found its way into tab 18 of our authorities bundle or not, I'm not sure, but it was sent to the court. And Justice Snowden says here, I do not think, however, that there is support in the authorities for the proposition that it is for the court to formulate some view of a hypothetical rational creditor who is a member of the class, or which may amount to the same thing, to impose its own view of the commercial merits or the best interests of the class. And my Lord President, that was the discussion we had earlier. And that we say that by undertaking the analysis that the learned judge has in paragraph 39, he's effectively accepted the company's view of what's in the best interest of the creditors as opposed to the creditors' views themselves. And that's contrary to the authorities. And there is another point here that I should make, my lords, which is important and may well come to mind, and I'm going to address it, is there's never been any suggestion from the company in the context of argument below that there would not be some benefit accruing to the creditors if a winding up order was made. And in fact, the previous scheme document, there has been no up-to-date liquidation analysis provided, but the previous scheme document suggested that the return to creditors, if the company were to be wound up, would be something in the region of 17 to 31%. And I can provide the page reference for my lordships if
Yes,
that's
please.
of assistance.
Yes,
But it's never been suggested that some benefit wouldn't accrue, which of course is also part of the test for making a winding up order. My lord, I will give you the site, pardon me. That evidence is found, and I'm not going to ask you to pull it up because it is. So it is at page 2304 of bundle D.
D which?
Page 2304 of bundle D, the largest, and this is its exhibit.
Mr. Taylor, when you go to D, we have D1, D2, D3. I assume you're talking about D2.
D2, my lord, yes. That's correct.
Thank you.
Well, sorry, whilst we're on, thank you for that. Can you go back to paragraph 80A
Yes.
of your, you said that we might have in the bundles some wrong case, but what you're citing from at 80A1 is Ray Glenn at 2020 EWHC 1469. I have got that in the bundle at tab 18, but when I turn to paragraph 79,
Something different.
it doesn't say what you say it does.
No, you're quite right, my lord, and that was what I tried to explain, obviously rather inelegantly. So if you look at tab 18, Mr. Justice Snowden made a number of rulings in this bankruptcy. And
Yes.
quite right, this is
The wrong one.
This is the wrong one.
Oh, I see.
Yes.
So-
what
So we don't want 2020 EWHC 1469.
That's correct. What we did do is subsequently we sent to my lords the correct authority.
Oh, right.
And
Am I to
will-
assume that this is 2020 EWHC 974?
That's correct. That's correct, Mr. Quaylo. And that at paragraph 79 indeed has the correct quote. And I do-
2020, what number?
2020
974?
EWCH 974.
Right. Okay, I'll be able to find that. Right.
Thank you. And once again, apologies for that.
No, don't worry.
And so effectively what we say is when you couple the fact that the learned judge has not considered the delivery of the Shum Fourth affidavit to the creditors, also the fact that the creditors are fully aware of what the current proposal is because it is a carry-on or the same from the first, and when you consider what he said in his paragraph 39, that unfortunately the learned judge has made an error in fact, an important one, in concluding that the creditors have not given full consideration to their proposal. And really, he's also, we say, made an error of law when you consider Remod and Crigglestone and the principle that the judge ought not to either import his own view of what's in the best interest of the class or the views of the company. And so we say that that is yet another basis on which the court can exercise a discretion of its own. Lords, I had, at the outset again, I had referred you to the importance of Section 99 of the Companies Act, and it's self-evident that the learned judge has not referred Section 99 and the requisite majorities.
Was it referred to him?
My Lord, I'm afraid to say it was referred to on numerous occasions. Yes.
Right. Okay.
And very clearly, to be fair to the judge, what he does say is he does say that he's considered the views of creditors, and then he reaches the conclusion that the company should be given the opportunity to work with the restructuring troops. But he's failed. He's failed to properly consider Section 99 and what those requisite majorities mean, or the requirements, and particularly when the whole purpose of adjourning the petition is so that the company can promote a scheme of arrangement. And he does at one point, I believe it's in his first ruling, he does say, Mr. Taylor's submissions are that the whole thing is futile, but he doesn't grapple with the reasons in law that it is futile. And I'm not sure I can put it. Any more clearly. And I come to, I'll come to some of the authorities in course about particularly some recent Caymanian authorities that one of them's in my learned friend's skeleton of submissions. And as part of the consideration of whether in the context of a light touch for the purpose of restructuring, there is a real prospect of a restructuring being successful. I mean, that real prospect, of course, includes how likely or not is it that the commercial plan that the company is embarking upon will be successful, whether an asset will be sold in this case, whether a particular refinancing will be secured. But it doesn't stop there. It really must go. Real prospect includes the likelihood of the creditors voting in favor of it with the requisite majorities. And as I say, had the judge properly directed his attention to Section 99, he would have then asked himself, well, what is the evidence that the creditors will change their mind? And there isn't any. There just isn't. There's no basis, in fact, at all, that somehow, because provisional liquidators are involved, the creditors are going to change their mind. And the point I make about these creditors, and it's something I stressed at length to the judge below, was the identity of these creditors, and that's a relevant fact. You saw some of the names. You saw some of the names that were involved. This is HSBC, it's ABN AMRO, it's ANZ Bank, it's Standard Chartered. Significant experience in these sort of situations and sophisticated commercial institutions. So second guessing their judgment is not appropriate. And certainly there is no reason to suggest or to find that they're going to change their mind and suddenly flip and vote for a scheme that they've already decided isn't for them. My lords, those are my submissions on the creditor position. If I could now, I'd like to move on to what the petitioner says are breaches of the appointment order. And I wish to start with the shared charges, but in order to really, I think, embark properly on this analysis, we ought to begin with the appointment order itself, of course. And that is at bundle B, tab 6, in other words.
Mm-hmm.
So, Lords, may I first ask you to refer to page 145, subparagraph, this is subparagraph 3L of the order. And of course, the preamble to paragraph 3 reads that the JPL shall be empowered to carry out the following functions. And sub 3L reads, in relation to the company, to review and approve any asset disposition of the company valued at more than 40 million. And so I pause to say that we have seen that on the company's own valuation evidence, the LPG assets and the Zhuhai commercial complex are more than 40 million US. My lords, then if I can please ask you to turn over to page 147. At paragraph 7, which reads, notwithstanding paragraph 3L above, which, my lords, I just referred you to, the JPLs will obtain the prior sanction of this court for any disposition of the assets of the company where the value of those assets is an amount in excess of US 40 million. Down the page at paragraph 13, it reads that for the avoidance of doubt, no payment or disposition of the company's property shall be made or effected outside the ordinary course of business without the direct or indirect approval of the JPLs. And then over to pages 148 and 149. My lords, paragraph 18 provides that, and the preamble on page 148 reads, save as specifically set out herein, and then sub C reads, in the event that the JPLs on the board cannot agree upon a proposed course of action outside the ordinary course of business of the company's business, the JPLs and the board have liberty to apply to the court for directions. And so the way the order works is, in the event that there is a disposition that is outside the ordinary course, that the company wishes to undertake, and the PLs don't agree, they go to the court and they have a discussion with the judge about it. So those are the operative paragraphs of the order, Lords. And I will stop and I will say this. Now, the company's position, certainly the position that it had taken in the courts below, is that, of course, the paragraphs refer to the company, as in the company subject to the winding up petition. And the company's position is that because the order refers to the company, and they say that that should be interpreted to the exclusion of the company's subsidiaries, that at the point in time where these subject share charges were entered into by the company, the subsidiaries were permitted to do so without reference to any of these paragraphs of the order, because they were subsidiaries. What we say is this, that firstly, on a plain reading of these paragraphs, that if the company were to procure the entering into share charges such that the equity value that it has in its subsidiaries is lessened, on the face of it, this order clearly attaches to those transactions. We also say that in circumstances where...
Just a second, you say that's plainly so. Let's assume there is a charge. So what was the charge on exactly?
So, well, I'll take you to it. I will walk you through, I'm going to walk you through which entities entered into the charges and the shareholdings, but these were, the charges were entered into by intermediate subsidiaries. But I'll take you through, I will take you through, there's a structure chart that I will show you to give you the, it certainly helps me. It may or may not help the court, but it helps me to see structure charts, see where these charges were actually entered into. But they were not entered into by the company proper, but they were entered into by subsidiaries of the company down the chain. And the point I'm saying,
wait a minute, again, I'm going to say it more slowly.
yes,
A subsidiary of the company charges the subsidiary's shares in a sub-subsidiary. Is that what happened?
yeah. So, Muller, I think the best way to do this, and I'm quite happy to take it in this order. Could I ask the court to please turn up page 2806?
Which bundle are we in?
Just wish to make sure I have the right bundle.
Yes. It's a colored chart
That's correct, Muller. Are you with me?
so far.
I think that's going to be in bundle D.
E3.
Yes. Yes, deep blue. Correct. So the print is quite small.
Yes.
It starts, obviously, you'll see it's divided between listco level, offshore, and onshore on the left-hand side by the broken lines. At the top is the company. And I'm going to start with well, ultimately what I'm going to do, my lords, is I'm going to take you down to the group company where the assets are held. So on the bottom there are green boxes, and the third green box from the right reads oil storage terminal. My lords, are you with me there?
Yes.
All right. So this is ultimately the assets that have been affected by this charge. And so if you go back to the top, you'll see that the company is subject to the petition. The list goes at the top, which owns 100% of a company called Sound Hong Kong BVI, or Sound Hong Kong Limited BVI.
Yeah.
Yes. And then it in turn holds 100% of Max Investments Limited BVI,
Mm-hmm.
which in turn holds 68% of an interest in New Ocean Energy Hong Kong Company Limited.
Mm-hmm.
Now, it is New Ocean Energy Hong Kong Company Limited, and you'll see there's a box with some text in the square there. It says New Ocean Hong Kong has pledged its 65% shareholding in, and I apologize, I will say in Company B, in Shenzhen Shanghai Industrial Co. Ltd. So when I say that there's an intermediate holding company that's pledged its shares, it's New Ocean Energy Hong Kong that's entered into that share pledge.
Yes.
Okay. Now, that is one of the share pledges, and that's the one we call the Shangyang share pledge because it was pledged to a company by the name of Shenzhen Shangyang Industrial Co. Ltd.
Yes.
Now, following along the same way, my lords, if you could look, the next green box on the right, but a little lower as it's presented on the chart, you see it says there, Zhuhai Commercial Properties Complex. We've discussed that.
Yep.
Those are the other assets that are ultimately affected by these share charges. And again,
We have the same box with the reference to the pledge.
that's correct. And we call that the New Soho pledge because the company to whom these shares are pledged is New Soho Commercial Management. So, and again, following from the top, it goes from Listco to Sound Hong Kong. We go long over to the right, and there's a company, New Energy Limited Hong Kong.
Yeah.
And it goes down to Zhuhai Chengfu Trade Co. And so again, the pledge there has not been made by the company, but we say it's been procured by the company through one of its subsidiaries. And so, my lords, I think now you'll understand why I embarked on an interpretation exercise in relation to the order, because the company's position is, because the order refers only to the company, that it was free without reference to the JPLs or to the court to enter into these share charges, which pledged the intermediate subsidiaries shares of these companies that hold these assets to third parties. So their interpretation of the order, which we disagree with, is that the company was permitted to do that without telling anyone. Now, My Lord President, what I was contending in the first instance was that on its plain reading, by procuring the entry into these shared charges, the company has devalued its own equity interest ultimately in these assets. So that we say the order applies to catch these transactions and that they had to be discussed with the PLs. And we'll come on to ordinary course of business momentarily. But the other thing that's
I follow perfectly that
yes,
there's a devaluation of the interest of a subsidiary if you pledge the shares to somebody else.
that's correct.
But this isn't a covenant against devaluing or interests. It's a covenant against the disposition of the assets of the company. And the
which we say is what a share pledge does, my lord, simply.
But yes, but the trouble is that the pledges that are the shares that were pledged were owned by somebody else.
Correct, which is why I've raised the point, and which is why I've said that why I've framed it in the way that I have, that if one devalues its equity, the order catches it. But the next point.
I'm sorry, there's plainly been a disposition of the assets. Take the first one of New Ocean Energy Hong Kong, which has pledged the asset, namely its shareholding in the unpronounceable company beginning with B.
Yes.
That's plainly a disposition by that company of its asset. There has also been a reduction in the value of what is owned by New Ocean because its subsidiary is now worth less than it was before the pledge.
Correct.
But I'm still struggling with how you can say that there has in fact been a disposition of the assets of New Ocean Energy Holdings Limited, Bermuda.
Well, I mean, my lord, the petitioner's view is certainly that when the company procures its subsidiary to take this step, it is ultimately a disposition of its ability, if I can put it this way, to have equity returned to it.
Okay.
That's position one. Position two, though, is that if the court isn't with the appellant on whether or not this is actually a disposition of the company's assets, the next contention we have is that, in fact, keep in mind that the oil storage terminal and the Zhuhai commercial complex are the very assets that the company has said it will sell to pay its creditors.
Mm-hmm.
And so what we're saying is that in that context, a fact that was heavily submitted and relied upon by the company and continues to be, that the proper construction of company in that context must include subsidiaries, we say, and that these transactions should have been discussed with the provisional liquidators prior to being entered into.
I mean, it would have been very easy to put it beyond doubt by including subsidiary within the definition of company in the soft touch order.
My lord, it may well have been. And ultimately what happened was the company voluntarily, well, the company's position is they voluntarily offered to do that. The judge ultimately, without really hearing much argument about it, agreed, and the order has subsequently been amended to include subsidiaries at this stage. But again, the difficulty is these propositions were put to the court, and the court doesn't really deal with, or come to a conclusion at all in the judgment, doesn't consider in any real way the effect of these transactions and their legal effect in relation to the order.
There is another point that arises. If we go to page 148, bundle 8, there's a subparagraph of clause 18 that you didn't refer to, which reads so far as material, save as specifically set out herein. B, the board shall continue to manage the company's day-to-day affairs in all respects and exercise the powers conferred upon it by the memorandum and the bylaws, subject to the oversight and monitoring of the exercise of such powers in relation to matters relating to the ordinary course of business of the company and to matters outside the ordinary course of the business of the company, subject to the JPL's granting prior approval of the exercise of such powers. Now, it could be said that if and insofar as the company permitted or acquiesced in its subsidiary creating these pledges, that permission was outside the ordinary course of business of the company and was subject to the prior approval of the JPLs.
Well, you're quite right. And I come to this, not only did the company
Was that
acquiesce,
suggested, just a moment, I can only say things in stages. Was that suggested to the learned judge?
whether it was in those particular terms, I don't believe it was, my lord, but certainly let's put it this way. You'll see that the judge definitely in his ruling refers to my submissions about these transactions being outside the ordinary course of business.
Yes, he does.
There's no question about it. And so certainly ordinary course of business was a debated topic we submitted on at some length, and we've cited some cases that I will take you to that, authorities are relatively clear that when a transaction is undertaken in response to financial difficulties, while not a prescriptive rule, the indication is that that's outside the ordinary course of business, and that's what we say. So our position certainly is that these were outside the ordinary course of business and were required to be approved by the provisional liquidators. My lord, not only did the company acquiesce, but and I'll take you to what they say. The company is subsequently given its justifications for these transactions. And so just before I leave, well, what I may do, well, how about I do this? I'll come to the company's justifications momentarily. How I plan to take it, if my lord, if you're minded, was take you to the judge's ruling on these issues first, if that's all right with my lord, and we'll go from there. So we're back to Bundle A again, of course, my lords, and we are looking at tab 5, and I'm going to ask the judgment begins at page 80, but I think I first wish to take my lords to page 84. And so the judge first, and here he's summarizing effectively the operative terms of the order that he made on the 9th. Lords, I'm sorry, everybody seemed to have froze for a minute. Did you hear my last submission?
Yes, here the judge summarizes the terms that
Yes.
The order he made on May the 9th.
Yes, I'm glad. So 9E, the judge indicates that he ordered that the company was to adhere strictly to the amended order in respect of the dissipation and or disposition of assets. So the amended order is the order that I referred you to, wherein what took place before the learned judge is the company then proposed to include the definition of subsidiaries in the order. And my submission was...
Where do we see that, Mr. Taylor? You referred to that before, but I don't believe I've seen the... Where's the amended order?
Yes, my lord, the amended order will be... It should be in bundle B.
It's at the end, I think.
It is. It's at tab
10, is it?
It's
Yes.
at tab 10. Now,
No, is it? Yeah.
it is at tab 10. Now, this
It's tab
and
10.
what you see,
No, wait a minute. I'm not sure that's right.
so your bundle B tab 10.
I see page 162.
Yes.
Yes,
with
so-
the- Yeah.
That's correct. That's correct. And so this was effectively, if you see how it was done, my lords, this is effectively an annex to the order at page 158, right? And so it's in red so that it's quite obvious to see the amendments that were made. And so subsidiaries were included. The exchange between the order was presented by the company, this amendment. The position that I took for the petitioner at the hearing was, and I made it very clear to the judge, I remember, was that we take no objection to the amendment, but we certainly don't concede in any way, shape, or form that it was in any way necessary because of the submissions that I had made in the main that the order applied to these share charges. So that's the amended order, my Lord Justice of Appeal Bell. And so if I may, if you're so minded, if I may return to the judgment.
Mm-hmm.
So we've looked at 90 on page 84. And then if I could please ask you to turn over to beginning on page 90. My Lord President, the first thing I will notice about the judge's ruling is that paragraph 26, and it partly answers the question you've just asked me, my Lord, and I'm glad you did. Paragraph 26, it says, third, the company has breached the December 2021 order referred to by Mr. Taylor as the light touch order on multiple occasions. If you go down to paragraph C, my Lord, you see the judge has summarized my submissions where he says, paragraph 13 and 18B. So, my Lord, it's precisely the paragraph to which you referred me.
So you
And
must
so-
have said something about 18B.
I certainly I did.
Yeah.
So indeed, there you have it.
Yep.
But this is what the judge has said. The company has breached these, and remember, he's summarizing my submissions here because he says, Mr. Taylor submitted that were breaches of specific paragraphs of the December 2021 order, including a colon, and then C is paragraph 13 and 18B. The company's breached these paragraphs by entering into the new Soho share pledge and the Shangyang share pledge. Mr. Taylor made extensive references to the company structure chart, which showed the group's major and key assets, namely the LPG asset, which consisted of the LPG refueling stations, its LPG storage terminals, its LPG oil storage terminals, etc. Goes on to say, the petitioner referred to the evidence of C3, and of course, Mr. Tim C is a representative of the petitioner, which set out what it believed was asset dissipation based on publicly available searches of the company's Hong Kong and PRC subsidiaries. Now I'm going to pause there because this is important, and I'll continue. It's important for my lords for you to make note of this. These share charges were never the information, the fact that these shares were charged was not voluntarily provided by the company. These share charges were found by the provisional liquidators and the petitioner through public searches. So it's along the lines of the submissions I've made about this company not being forthright with its creditors or the provisional liquidators or the court. And then we go on to talk about, he goes on to summarize, referred to the evidence, which sets out to believe was asset dissipation based on publicly available search of the company's Hong Kong and PRC subsidiaries, namely the Dynamic Frontier allotment in respect of company's indirect interest in the commercial property business, the Sky Courage allotment in respect of the LPG bottling stations, and the Shangyang share pledge in respect of the LPG oil terminal. Mr. Taylor noted that in Shum form, Mr. Shum explained why no dissipation occurred as Dynamic Frontier and Sky Courage are wholly owned by Sound Hong Kong, and the purported reason for setting up these two Samoan companies was to reduce stamp duty liability. He noted that while those companies may not have an impact on the company's interests, the new Soho share pledge and Shangyang share pledge would have an impact on the company's interest. And over the page, the learned judge goes on to say, Mr. Taylor submitted that the new Soho share pledge.
I'm just interrupting you, and I'm sorry to do this, Mr. Taylor.
No, that's okay. It's fine.
The judge sets out the competing arguments, and he does that very fully. The problem is that he never then rules upon them, as I see it.
He doesn't. So, my lord, what he doesn't do, and I'm happy for you to cut to the chase, and this is why I said at the outset, it's an unusual ruling.
Well, I mean, he goes to paragraph 38, deals with your exceptional circumstance 3.
That's right. But he has never found, he's never made a determination as to what this was. Oh. And it's a significant issue. And my learned friend in his skeleton, his position is that, well, sort of it was so obvious that the judge didn't make a ruling. Well, I certainly don't accept that proposition. This was a hotly contested, and I mean, from the judge's own summation of my submissions, I went through that structure chart in complete detail with the judge. And I made the very point that this disentitles the company to any further accommodation by the court. And he has not made any determination, I'm afraid, as to what his view of the competing arguments were. So, Lord, that's exactly right. And so we say it's quite a problem in the context of a light touch provisional liquidation when the JPLs are supposed to be reviewing all of this in the best interest of the petitioner and the other creditors.
This has been the subject of submissions by the company to the judge. Did the company submit, well, these are pledges by the subsidiaries, and so they fall out of the picture?
My lord, absolutely the company has, and of course, my learned friend will be in a better position.
That's what he said now, but was that what was said to the judge?
My lord, it was said to the judge, yes. It was said to the judge. I believe that's exactly what
the judge doesn't come to any conclusion about that, does he?
No, he doesn't, my lord. You're quite right. You're quite right.
Could you just help me on one tiny point? At paragraph 26B(c), the learned judge refers about 4 lines down to its LPG storage terminals, its LPG oil storage terminals, and he uses that phrase a little later. That's presumably some typo, isn't it? Liquid petroleum gas and oil are different commodities. he's presumably referring to the liquid petroleum gas terminal and the oil storage terminal.
I mean,
There
I think
wasn't a
that
mix-
must, I think that must be right. My lord, I
Must be
think
right.
that must be right. It must be. Correct.
Thank you. Thank you.
You're very welcome. And on this point, I mean, why it's so very important is because keep in mind that these assets are the very assets with which the company says they're going to sell to pay the creditor body. And they're entering into these shared charges without the oversight and consideration of the provisional liquidators. Now, I think it may. I'm just making sure that I've completed my submissions on this point. My Lord Justice of Appeal Bell, I think it was you had anticipated what I was going to say next over in paragraph 36. So in his discussion and analysis, and that's on page 94, the judge says, whilst there's been the impression that the company has barreled forward on its own without regard to the JPLs with these developments, I anticipate that the company and the JPLs will work together in a purposeful manner to give effect to the December 2020 order. My Lord, unfortunately, once again, I'm afraid to say, I think the learned judge has skipped over the most important part of the submission. And that is what was done. Was it within the scope of the order or not? And then really, and this is the most important thing, remembering that these are the very assets that they're going to use to pay the creditors. What follows from it? So he identifies that he says there's an impression that the company's barreled for, but what follows from these actions? And so again, over the page at paragraph 38, again, here the judge cites arguments, but he doesn't squarely address the issue. So he says, I've considered the submissions by Mr. Taylor that the company's been entering into various agreements and pledges for which it should have consulted the JPLs. Mr. Taylor's point is that it's doubtful whether the value of the company, the group for that matter, has retained its value in light of asset dissipation has taken place. True only in part. And I come to the second very important part of this momentarily. Then he goes on to say, on the other hand, Mr. Robinson has pointed to evidence to show that there's not been any asset dissipation. Rather, the actions taken by the company were always intended to be taken to allow the company to restructure and address its financial obligations. Then he goes on to say, however, I'm focused on the main issue and that the winding up order has potential for value destructive consequences. He never comes to a finding, I'm afraid. And it's a significant error that he's made, we say, because it's a crucially important question. Now, Lords, I have taken you through the structure chart. I don't plan to take you back through that. You have an idea. You have a sense of what's happened. But I would remind you again that these share charges, they were entered into on the same day, the 18th of February, 2022. That is quite clearly after the appointment order was made. The JPLs were not advised in advance of these, and in fact found out about them on their own. Now, what I'd like to do is I'd like to take you through the company's justifications for this. And so what I'm going to ask my lords to have to hand now is the affidavits binder, which is at bundle C. And I'm going to ask you to turn up Mr. Shum's fourth affirmation, which is at tab 14. And particularly page 342.
So, could you give me a page reference?
Page 342, my lord. 342.
I'm sorry, you part of that. Could you repeat?
Yes, my lord, page 342.
In the wrong binder, I'm sorry.
Whatever.
Yes.
Yes, so this is subparagraph F of paragraph 16. So over the page on 341, Mr. Shum begins by saying, in relation to the Zhuhai commercial complex, he says the company is also pleased to report the following developments. Now over the page on F, here's what Mr. Shum says. He says, as a prerequisite to commence due diligence, being TNG required the company to obtain the title deeds, which first required settling outstanding construction fees. In order to achieve the liquidity to do so, Beijing Tianji paid part of the construction fees by way of a deposit to Chengfu. Now, Chengfu is the company that holds the asset, the commercial complex, with an expression of intent to buy the Zhuhai commercial complex in a 9-figure market value transaction, and to provide further payment to settle the construction fee in exchange for a security interest in Shanghai shares. Beijing Tianji required this in order to provide comfort pending completion of the transaction. In view of its interest in acquiring the complex at market value, which would generate US $268 million for the group, and given the importance of the sale due to the company's time-sensitive debt restructuring, the transaction was viewed as commercially imperative, and the company accepted Beijing Tianji's offer. So, in short, they say that there are outstanding construction fees in relation to the complex that had to be paid, and so they entered into this pledge of a security interest because the potential purchaser paid part of the construction fees by way of a deposit. So that's the explanation in respect to the charge related to those assets, the commercial complex. In relation to the Shangyang share pledge, the company's position is, it is at page 346. Paragraph 21 sub H. The company says it's entirely false that the group dissipated its interest in the oil business. The group retains the same level of control over the oil storage terminal. The purported share pledge, I mean, it is a share pledge, is a part of a greater series of transactions between Shenzhen Shangyang Industrial Co. and the group in relation to a lease of the oil storage terminal and LPG terminal. On 31 March 2021, BFY Zhuhai and New Ocean Energy rented the oil storage terminal and LPG terminal to Shangyang for 10 years through July 2031. After entry into the lease, Shangyang prepaid 5 years of rent and made substantial investments to maintain and repair the oil storage terminal and LPG terminal. As a consequence of the petition to wind up the company, Shangyang threatened to repudiate the lease unless the company would reimburse the prepaid rental fee or provide a pledge over the shares of BFY Zhuhai and New Ocean HK. Repudiation of the lease would be devastating to the resale value of the oil storage terminal and LPG terminal, as the unused equipment and facilities quickly degrade and depreciate, and the company was not in a position to return the prepaid rental fee. Therefore, it granted Shangyang the share pledge as the most viable commercial option for it. So, broadly speaking, those are the company's justifications for these share pledges. What we say is this: it won't surprise you, and it shouldn't be a controversial submission, that the petitioner certainly doesn't particularly trust company management, and they don't accept these explanations at face value. But even if at best what Mr. Shum says is correct, they've breached the order and particularly have not given the provisional liquidators the opportunity to independently consider these transactions and whether they're in the best interest of the company's creditors. So, practically speaking, the security agreements in question, and they're in the evidence, are governed by Chinese law. And so, as a non-Chinese lawyer, the questions I have, and the question the petitioner has, is what is the effect of the agreements? What is the law related to the share charges? What is the law applicable? How does it work? What other commercial options may have been available? Are the underlying explanations, the rationale of the transactions accurate? The JPLs were not given the opportunity to in any way discuss these and determine whether, in fact, they're in the best interest of the company creditors. And so this is why, even were the judge to have made a decision, he's failed to consider not only whether he accepts the company's explanations for these, but with respect to the learned judge, he's missed the whole point of his own light touch order, that his office holders must be given the opportunity to consider potential transactions such as these, even if they're stated to be in furtherance of a restructuring, which the petitioner doesn't accept. But even if they're right, there has been no oversight. And the companies don't know what the ultimate result of any of this will be. What happens if a winding up order is made tomorrow? What happens to these share charges because they're governed by foreign law? The company has an explanation, but the provisional liquidators haven't blessed that explanation and said to the creditors, we think this is a good idea to preserve these assets and we recommend them, or alternatively, we don't think these are in the best interest of the creditors because of these reasons. There's fundamental problems here that the judge hasn't considered, I'm afraid. Now, so that's the factual background, my lords, to the share pledges and to what the judge has ruled. What I should do is, again, I think the simplest place to refer you to the authorities on ordinary course of business. Could I please ask you to turn to page 36 of the petitioner's skeleton? And I just beginning at paragraph 97, we say that the principles regarding what constitutes ordinary course of business are well established. We cite countrywide banking, the decision of the Privy Council, and over to page 37. The excerpt reads that plainly the transaction must be examined in the actual setting in which it took place. That defines the circumstances in which it is to be determined whether it was in the ordinary course of business. The determination then is made objectively by reference to the standard of what amounts to the ordinary course of business. as was stated by Fisher J and Modern Terrazzo Ltd. The transaction must be such that would be viewed by an objective observer as having taken place in the ordinary course of business. While there is to be reference to business practices in the commercial world in general, the focus must still be the ordinary operational activities of businesses as going concerns, not responses to abnormal financial difficulties. We say that's clearly what this is, that routinely companies don't grant share charges or procure their subsidiaries to grant share charges when things are going along swimmingly. And quite obviously, the company is facing abnormal financial difficulties. That's the context in which we're considering ordinary course. And then paragraph 98, we cite Freerider Ltd, which is a Cayman Islands decision. And it actually held that a grant of security over property, such as a share pledge, is indeed a disposition, which would fall within section 99 of the Cayman Islands Companies Act, which is the equivalent of R166. And the Grand Court noted the following key points were to be taken from Countrywide Banking, that A, the transaction must be examined in the circumstances in which it occurred. B, the transaction must be such that an objective observer would view it as having taken place in the ordinary course of business. C, the focus of the inquiry must be on the ordinary operational activities of businesses not responsive to abnormal financial difficulties, and prior practices of the company will be a relevant consideration. And of course, we conclude there, my lords, by saying these aren't prescriptive and they're not absolutely rigid rules that the court must follow in every circumstance. But we would certainly say that in this particular case, it's absolutely clear that the charges in question were out of the ordinary course of business and certainly caught by paragraph 18 of the judge's order. And he unfortunately has failed to make any determination about whether or not they did breach the order. And then he's failed to go on and ask himself the next question, an equally important question about what does that say for how management is treating the process, whether they're acting honestly and in utmost good faith with the court and its creditors, and what that means for the continuation of the light touch appointment. He hasn't addressed any of that, I'm afraid, and the learned judge has erred in failing to do so. It's another basis upon which we say that this court can exercise an original discretion of its own in considering this matter. Whereas I see it's about 7 minutes to 1. My Lord President, I'm not sure what time you were thinking of.
Well, we were thinking at 1, but 7 minutes to 1 will do equally well. How are we getting on?
My Lord, I shouldn't be much longer. I'd like to discuss in further detail with the court the Hong Kong petition. I can move through that fairly quickly in the circumstances in which it came to the attention of the court. And then I'll be referring the court quite briefly to some excerpts of the JPL's reports, but not in detail, because I certainly would be minded to suggest that it would be a good idea to review those. And then very briefly, I want to discuss a little bit with the court about the concerns about Bermuda as a winding up jurisdiction if this judgment is given any further credence by this court, my Lord, and that will conclude my submissions.
Okay. Well, would it be convenient to speak up if it wouldn't, if we took a 45-minute break?
My Lord, I'm quite content with that, subject to my learned friend's views.
Yes, of course, my Lord.
Yeah. Right. Well, we'll resume in 45 minutes. See you then.
I'm obliged.
Breakout room.
Yeah, the breakout room. Just a second. Okay.
Right. On we
Yes.
go.
Lord, thank you. I wonder if I could ask my lordships to have to hand bundle F, please. It's entitled Correspondence.
Yes.
Yes, my lords, I had I previewed the Hong Kong petition. I'd like to take you through the correspondence that was presented to the learned judge on this. So the first, I'd like to take you behind tab 2, which is page 4341 at the bottom. This is a letter of the 4th of May from Appleby, who are of course counsel to the provisional liquidators, writing to the registrar of the Supreme Court, providing copies of material to the learned judge. It says the JPLs have recently, third paragraph, my lords, the JPLs have recently obtained correspondence enclosed relevant to the hearing of the petition, which concerns the presentation of a separate winding up petition against the company by trade creditor Kuwait Petroleum Corporation. And then over the page, Appleby simply says, we would be grateful if these could be provided to Justice Musselman as soon as possible. They were before the judge during the relevant hearing. And again, I made extensive submissions on these materials. So I'm going to try and move through this quickly and read the correspondence highlights. The first letter of the 28th is from the provisional liquidators to Ashurst's Hong Kong office. Ashurst apparently acts for Kuwait Petroleum Corporation. And in this letter, the JPLs are seeking information from Ashurst. I begin by saying, I refer to the above matter and the winding up petition filed by Kuwait Petroleum Corporation against the company on 12 April. And the 4th paragraph down, I understand that you act for the Hong Kong petitioning creditor, and I would be grateful if you'd provide the following. Their bullets seeking the petition, creditor's contact details, total amount outstanding, details of any security, copy of all documents related to the debt. Now over the page on 4345, my lords, Mr. Comber at Ashurst comes back, or at least Ashurst's come back. I assume it's Mr. Comber.
So just remind me who FTI Consulting are.
My lord, FTI is the corporate entity through which the provisional liquidators are employed. So of course, these are the Hong Kong liquidators. So Mr. Sutton and Mr. Fung are employed by FTI. Of course, they're appointed in their personal capacity, but this is Mr. Fung, the JPL, writing to Ashurst in Hong Kong. Ashurst's response of the 4th of May, in the first main paragraph says, they confirm they act for Kuwait Petroleum. They say that their petition was duly served on 12 April. In the 3rd paragraph, they say, we note that pursuant to paragraph 4 of the order provided with your letter, the directors and officers of New Ocean are required to provide you with all information relevant to your appointment, which you may reasonably require. It is therefore not clear to our client why you've approached us for information, which should be in New Ocean's possession and readily able to be provided to you by its management. Very good question. They confirm that the debts to their client are a little over $3 million. They say the debts have been subject to numerous demands, including a statutory demand that was served on the 9th of November, 2021. At no stage has New Ocean sought to dispute the debt owing to our client, notwithstanding our client's repeated demands for payment. New Ocean has failed to engage on the matter in any reasonable way or to make payment of the debt. Our client's position is therefore that New Ocean is demonstrably insolvent and should be wound up. Furthermore, it considers that Hong Kong is the appropriate jurisdiction in which the winding up should occur. New Ocean is a registered non-Hong Kong company pursuant to Part 16 of the company's ordinance, is listed on the Hong Kong Stock Exchange, and has significant operations in Hong Kong. For the avoidance of doubt, our client does not wish to participate in any restructuring of New Ocean's debts, nor does it in any way submit to the jurisdiction of the Bermuda courts in respect of the restructuring exercise for which you've been appointed. Now back to the 28th of April on the next page, 4347. On the same date, they wrote to Ashurst, appears the provisional liquidators wrote to New Ocean Energy, care of their Hong Kong attorneys Cobray and Kim. They say in the first paragraph, it's come to the JPL's attention that a winding up petition has been filed by Kuwait Petroleum against the company in Hong Kong. It says, for the purposes of restructuring in accordance with the JPL's appointment order dated 14 December, the JPLs would have appreciated if the petition, or indeed its existence, or indeed the existence of this creditor, was brought to our attention. It's plainly relevant to the JPL's functions, as you will recall. Paragraph 4 of the appointment order requires you to disclose information relevant to the JPL's functions, quote, whether expressly requested or not, end quote. Counsel for the Hong Kong petitioning creditor informed us that on 27 April 2022, that the company was served with the petition on 12 April 2022. The company failed to bring this to the attention of the JPLs and the Stock Exchange of Hong Kong. And over the page, the penultimate paragraph reads, we note that Rule 13.251B of the Hong Kong Exchange's Consolidated Listing Rules requires the company to issue an announcement and inform HKEX of the presentation of the petition. We've not seen any such announcement. Please attend to this forthwith. And finally, over the page, Cobray and Kim responds, and at paragraph 2, encloses a copy of the petition and related documents of the underlying debts. It seems this is the first time this was provided to the PLs. At paragraph 4, Cobray and Kim says that, as stated in the first affirmation of Lawrence Shum, dated 14 November 2021, the company's bankers abruptly terminated credit lines to the company and its various subsidiaries, causing the company to default in paying KPC as it was unable to issue letters of credit. The outstanding invoices amount to just north of $3 million. Confirm here, paragraph 5, that Kuwait does not hold any security over the assets of the company or subsidiaries. On 12 April, the company was served with a petition. The petition will be heard at the Hong Kong High Court on Wednesday, 15 June 2022 at 10 a.m. In view of the pending winding up proceedings in the Supreme Court of Bermuda, the company was advised that the petition will likely be stayed by the Hong Kong court. Well, that has not happened, my lords, and this petition is to be heard substantively in Hong Kong this coming Wednesday, as I understand it.
You mean the day after tomorrow?
That's correct, my lord. So you can imagine that I'm going to preview my submission at the end of this and make everybody's lives potentially exceedingly difficult, but in any event. The paragraph 7, the final paragraph, the company confirms that it does not have any other non-bank third-party creditors. Given the progress made by the company in selling its core assets, as defined in the 4th affirmation of Shum Siu Hung dated 1 April, the company would be in a position to repay KPC together with the other bank creditors of the company. Therefore, the petition does not affect the current restructuring plans. So, cited, my lords, for another example of how the company has breached the order, this clearly ought to have been provided to the provisional liquidators as soon as reasonably possible after the petition was served. It was not. It was not advertised on the website of the Stock Exchange of Hong Kong. I will say that submissions were made in significant detail regarding this correspondence that was placed before the court by the provisional liquidators. And submissions were made that these were breaches of paragraph 4 of the order requiring the PLs to provide information. So not only was it a breach of the order, but that it goes to the very heart of the matter of the creditor support issue. such that submissions were made to the judge by myself that the company had intentionally hid this from the provisional liquidators for fear that it would reflect poorly on their submissions seeking a winding up order, because yet a further creditor has come forward, and whilst doesn't support the petition in Bermuda on jurisdictional grounds, has made very clear that it does not wish to participate in a restructuring. And so, Lords, again, the judge hasn't dealt with this, and it's a significant error, because again, it's about breaches of the order, and it's about what the creditors think. And in fact, the judge went so far as, it seems, to make a finding that there was no further creditor support from the time of the first hearing to the hearing that concluded on the 9th of May, which is clearly incorrect. So we know there was Dawsing Bank that joined, and we know that while this creditor was not discovered, shall we say, by the petitioner, it certainly had come forward and said, we also don't want a restructuring. We want the company wound up, albeit Hong Kong. And the submission, of course, with respect to this, and generally the failure to provide information, is that the whole premise upon which these orders work is the provision of information, partly the provision of information, and the company following the appointment order, and they failed to do so. And again, the judge hasn't made any findings in relation thereto. Well, I'm going to complete in relatively short order, I hope, my submissions about paragraph 4 of the order and the failure of the company to provide information. I'm going to ask you to remain with bundle F, if you might, and I'm going to ask you to turn to the first page, tab 1, which is 4316. This is a letter from the provisional liquidators to all known creditors of the 25th of March 2022, and it's useful in summarizing the JPL's view of the process as of that date. So on page 4317, which is the second page of the letter, under progress in developing and proposing a debt restructuring, Mr. Fung says in his letter, regrettably, very little progress has been made over the last 3 months, including since the informal creditors meeting that was held on 28 January 2022. As a result, we were unable to put before the creditors a proposal for restructuring the company at this time. And then under the next heading, the JPL's duties, the final sentence reads, the JPLs have now repeatedly requested, amongst other things, and there are a number of bullet points there, contact details for the board and management of the company, a group organizational chart, a full list of creditors, an asset summary, a debt summary, a list of bank accounts with their balances, and a cash flow projection for the group. The company has not provided this information. Initially, it suggested that operational difficulties prevented the disclosure of this information. The company has now communicated to the JPL through its counsel that it's unwilling to provide this information as it believes that the requests are not legitimate and does not trust that the JPLs will keep the company's information confidential. Below, under oversight, to date, the JPLs have not been allowed any monitoring or supervision of the company or of the board of their activities, have no visibility on operation or asset disposals, and are unable to satisfy themselves that creditors' interests are being safeguarded. And then finally, my lords, over the page at 4319, under position of the JPLs, the final 3 paragraphs read, the JPLs do note, however, that irrespective of whether or not the proposed amendment finds favor with the court, any restructuring proposal must be in the best interest of creditors, and that the JPLs must be in a position to give their professional opinion on the merits and feasibility of any such restructuring proposal. For the JPLs to be able to do this will of necessity require the disclosure to the JPLs of information about the company and the group, access to management and operations, and the cooperation of the company and its advisors. In addition, and should this go without, and this should go without saying, the JPLs will take all steps to facilitate the company continuing as a going concern, provided this remains consistent with the JPL's overriding duties to the court and to serve the creditor's best interest. Any restructuring will be subject to the approval of the creditors in the court. The form which a potential going concern restructuring could take and the feasibility of the successful debt restructuring being implemented is something the JPLs are currently unable to assess, let alone prejudge. And I pause there to say they're unable to assess the commercial terms, not the creditor views, because we know what they are. So again, Lords, I think the company will say that since this March 25th letter, further information has been provided. But the fact that the PLs have written to the creditors indicating that they can't do their job in their view because they're not being provided with the relevant information is highly problematic. And I would ask now, Lords, that we go back to the learned judge's ruling, which is in bundle A. That page, take you to page 88. And so there are 2 paragraphs dedicated to what the learned judge calls the JPL submissions, where he says, counsel for the JPLs filed a skeleton argument for the hearing on 14 April in response to the company's summons dated 12 April for disclosure by the JPLs of various categories of documents. And keep in mind that this is an application brought by the company for disclosure of certain things, including the report that was filed with the court and had been sealed, I believe. So by the time of the hearing of 14 April, the JPLs had agreed to provide most of the documents sought by the company. The JPLs objected to providing all their correspondence to the company on the basis that this request was too wide and there's no factual basis for such request. So what's happened here is it's the JPLs providing documents instead of the company providing documents. Court says, Mr. Rialoma submitted that the JPLs were continuing to work with the company. He noted that the JPLs had provided a list of 80 items of information that the company was presently working on to provide to the JPLs. He noted that this development was a positive start, but if an adjournment was granted, there may still be requests for further documents out of the information provided. He was of the view that it would be beneficial to return to court in several weeks so the court could be provided with an update on the provision of information by the company to the JPLs. My Lord, my Lord, the learned judge has missed out on referring to the 25th March letter, and I am not going to take you in detail through the PL reports, but I will recommend them to my lordships for consideration because they say some concerning things that the judge just doesn't address. So these reports are at bundle E. The report that was before the judge is the one at tab 1. It's the March 22 report, which is voluminous. But I'm going to ask you, by way of summary, to refer to page 3397. And these are the conclusions that the JPLs have reached in their March report. Paragraph 12.1 says the purpose of the provisional liquidation, and the final two paragraphs read, the board of directors and the company have not demonstrated any willingness to offer real assistance to the JPLs to enable them to properly conduct their duties. The company contests the powers and authorities of the JPLs and asserts that the JPLs are no more than court-appointed observers in the provisional liquidation process. This is not what light touch provisional liquidation encompasses and is contrary to the clear and unequivocal terms of the appointment order and the directions of the Bermudian court as set out in the appointment order. Carrying on to under the appointment order 12.2, the second paragraph. The appointment order grants the JPLs a broad suite of powers to assist the company to facilitate a restructuring. These powers are designed to work in concert with the board. They are not directly enforceable when the board refuses to act cooperatively. The JPLs consider that the company has not complied with a number of the terms of the appointment order. The company continues to resist providing the JPLs with the information and access required for the JPLs to perform their duties. The actions taken and approach adopted by the company since the appointment of the JPLs appear to be deliberately intended to obstruct the ability of the JPLs to gain the clear understanding of the company and the group's assets, finances, and operations necessary to enable the JPLs to quote the terms of the appointment order to develop and propose a restructuring and so on. And that's verbatim from the order. Over the page, the JPLs say at page 3398, under the current proceedings, creditors are relying on the JPLs to at least conduct an assessment of the proposal and provide their recommendations. Therefore, it was conveyed to the company that in order for the JPLs to properly engage with creditors, information was required to enable them to conduct the review. At the commencement, Mr. Shum initially endorsed that cooperation between the JPLs and the company was necessary to successfully facilitate a restructuring. Correspondence following the initial meeting with Mr. Shum also assured assistance will be provided by the company. However, the steps and actions taken by the company so far suggest otherwise, which would appear to the JPLs that the proposal is questionable or even potentially disingenuous. The JPLs have been insistent in requesting the company to provide the relevant information. However, the company considers that the information is irrelevant to facilitating a restructuring. Over the page, the first full paragraph reads, the company is already clearly insolvent on a cash flow basis and may well be on a balance sheet basis, bracket, without current financial information, the JPLs cannot say. The JPLs are concerned that as things stand, the company is on a path towards a disorderly insolvency without due oversight. So there's a lot more detail in those reports, but again, I raise them for two purposes. One, the judge clearly hasn't in any real way addressed the report of the PLs and why he's disregarded that report, or at least hasn't taken it into his consideration when granting a further adjournment, when the PLs, certainly as I read their report, are saying that the light touch provisional liquidation is not working. And he certainly doesn't go on to ask the question and to consider what this means when management of the company, according to the provisional liquidators, is actively thwarting their efforts by refusing to provide information. And that's not found in the judgment time.
Mm-hmm.
Yes. My Lord, very quickly, I wanted to refer to some of the points made in the company skeleton and in particular deal with one authority. I'll deal with both of them, but in particular deal with the Midway Authority of Justice Siegel out of the Financial Services Division of the Cayman Islands. So, in other words, if you have the company's skeleton to hand, I would be grateful. Beginning on page 2 at paragraph 5, I'm not sure that how our submissions are characterized are quite right, but in any event, moving on to paragraph 6, the skeleton reads that while the matters stated above are relevant to the exercise of discretion must be considered by the court in determining whether to adjourn, the court retains a wide discretion to adjourn a petition, taking into account all the circumstances of the case, including any proposal which will preserve value, by ensuring an ordinary disposal of the debtor's assets with the consent of its creditors. Well, that's the fundamental difficulty with paragraph 6, because there is no consent in this case. Paragraph 7, the company goes on to say that simply because there is no creditor appearing to oppose the petition, or the petition is supported by a majority of creditors, and or the proposal sought to be pursued in the alternative to winding up doesn't involve payment in full. Well, I mean, I think the point we make, of course, is that you have to look prospectively at whether or not a scheme will be supported. And so in circumstances where all of the creditors representing a significant majority of aggregate debt support a petition, then the court needs to take that into account and hasn't done so. In paragraph 8, the company quotes from CFL Finance versus Bass over on page 3. Again, I would say this authority assists the petitioner. The excerpt reads, "In my judgments, these authorities provide useful guidance. The court should take into account, 1, the class remedy of the nature of insolvency, 2, if a meeting of creditors is held, whether it is likely that a majority by reference to the value of votes will pass the proposals." And my lord, you have my submissions on section 99. And so we don't get near the prospect that it's being likely. In fact, it's exceedingly unlikely that proposals will pass. And going down to the underlying position, the factors I set out above, in particular 1, 2, and 3, are matters which are routinely taken into account as a matter of practice in the company's court, where a debtor company seeks to adjourn a winding up petition for the purpose of putting proposals to the creditor. So, of course, we've had that. This was, of course, the second hearing. I mean, I think it's questionable whether, the details of a proposal will put to the creditors. We know what it is because of the previous one. But any of them, the creditors have made their views clearly known. And we say that, of course, it shouldn't have been adjourned a second time, and it shouldn't have been adjourned yet again by the learned judge. In paragraph 10, my lords, the company cites the case of Founder Information Hong Kong, which is a decision of Justice Harris. Again, this decision, in fact, helps the company. What I'm going to ask you to do now, my lords, is the decision helps the petitioner, and in fact, illustrates some of the points we've been making. Could I ask you to pull up the company's authorities at tab 7 is the Harris J decision in Founder. So, my lord, the portion of the judgment quoted in the skeleton on page 4 at the top of page 4 reads that the evidence will need to be all the more compelling if a company is unable to find a creditor to oppose an immediate winding up, which is the case here. And then 6, when dealing with substantial listed companies with very significant debt, the court will expect the evidence that is put before it to support an application to give time to allow a company to progress a restructuring to be consistent with the character of business and the debt. But then if you go into the judgment, my lords, at page 6 of the judgment, at paragraph 51, Justice Harris goes on to say, I summarized how this balancing exercise is to be approached when, as in the present case, creditors take differing views about what is in their best interest.
Where are we looking for?
My lord, so we're back in the
Oh, I see. When you say
bundle.
paragraph 51, it's paragraph
That's correct.
51, quoting from another case.
Yes, this is Justice Harris quoting from his case, Rechase on Development Ltd., where he says, in cases in which a company is clearly insolvent and a petitioner's debt is not in dispute, an important consideration when a court is being asked to adjourn a petition by a company in order to allow it to attempt to restructure its debt are the views of its unsecured creditors. If the creditors are taking different views, the court will normally take into account all the circumstances, including the following consideration. Well, of course, the creditors here aren't taking different views. And over the page, Justice Harris says, in practice, the court is making a decision which commonly will be more commercial than legal. In most situations, the court takes the view that a party is best placed to assess what's in its best financial interests, but the nature of the insolvency process involving, as it frequently does, multiple creditors involved inevitably throws up situations where there are genuine differing views. So that's not the case here, but Justice Harris, again, supports the proposition that the court takes the view that the parties in its best interest is best placed to assure what's in its best financial interests. Over the page, again, quoting his decision, this time in paragraph 10. So it's page 8 of this judgment, it's paragraph 10 of the judgment to which Justice Harris refers. He says, it seems to me that the company has failed to demonstrate a good reason for the court to adjourn the petition rather than exceed ICBC's wish that it be put into immediate liquidation. ICBC is rather better placed to assess what is in the creditor's best interest than the court. Generally, unless there's a substantial body of creditors opposing a petition for sensible reasons, the court will defer to a petitioner's wishes. I would add that ICBC is a mainland bank, and I think I can reasonably assume well placed to assess the prospects of the company reaching a satisfactory resolution to its present financial problems. I will therefore make the normal winding up order. Now, continuing in the case Justice Harris was dealing with in Founder, paragraph 9, in the 5th line down, he says, in the present case, the burden on the company is higher because it cannot point to any independent creditor, except that it's apparent from the company's evidence that, unsurprisingly, other members of the PUF group, that's the debtor group, or creditors support an adjournment. He goes on to say at page 9 at the top, as is well established, the court proceeds on the basis that the parties are best judges of what's in their own financial interests and will rarely depart from the creditor's views if they're consistent. In this case, the petitioner, which holds 54% of the company's debt, is a sophisticated party, far better placed to determine what is in the best financial interest of the bondholders than am I. So those are the additional useful parts of the Founder's judgment.
Yes.
Excuse me, Lord. In paragraph 11, the section quoted of the learned judge in his judgment on the 4th of March, it's just notable that the company doesn't deal with creditors, or the judgment doesn't deal with creditor views, which is one of the petitioner's major complaints. I'm gonna paragraph 12, my lords, deals with the judgment in Midway, which I will take you to, which is, we say, useful in this context. I will come back to it. In paragraph 13, my lords, the company says that as regards the nature of the proposal put forward to justify an adjournment, neither Justice Harris' decision in Trinity, and we've cited the Trinity management cases, my lords, as authority for the proposition that a liquidation isn't schemable, if I can put it that way. I will say I'm not sure that I'm going to press that argument today. I'm not sure it's our best one. I don't necessarily resolve from it, but I'm not going to press it today. So I make that point.
So what's the argument you're not pressing? I didn't catch.
Well, my lord, in our skeleton, we effectively have said that the type of proposal being put to the creditors by the company is not one capable of being sanctioned by Section 99 of the Companies Act. I'm not going to. I'm
No,
not
okay.
going. I'm not going to press that point.
Okay.
Thank you. Lord, in paragraph 17, the company makes the point that the judge's view is that there was no evidence to controvert the company's position that the company remains balance sheet solvent. Just very briefly on that point, of course, the position that the petitioner has always taken is that the finding that the company is balance sheet solvent isn't justified on the evidence at all, because the financial statements that have been provided are consolidated group accounts. The company has not submitted separate company accounts. And on top of that, they are very dated and unaudited. So we also make that point.
On top of which, Mr. Taylor, there is the statement of the provisional liquidators, which you just referred us to.
Yes, the PLs have said they're unable to confirm it because of the lack of information being provided. That's correct. Lord, finally on the company skeleton, I would like to deal with Midway. Midway is the decision of Justice Siegel in the financial services decision of the Cayman Islands. And I thought it might be helpful for the petitioner to put this into some context. So factually, Midway is quite different than this case in that it's quite evident, and this is in paragraph 8 of the judgment, that the proposition being put to Justice Siegel was that if Midway's subsidiary, which I believe was a Mauritian entity, was successfully restructured, then it was possible that the company itself could restructure, and that was in paragraph 8 of the judgment. In paragraph 41, there's also a very meaningful difference in Midway, and that was that two significant creditors of Midway actually indicated a willingness to compromise their debts. And so in the affidavit submitted on behalf of the company by Mr. Worthington, this is at paragraph 41. The page numbers are very small at the bottom. It's page 17 of 33, my lords. But here's what the evidence was in relation to creditor support. It said, moreover, this is about halfway through, moreover, as part of the proposed restructuring, Emerald Holdings Limited and MRI Management LLP will be asked to compromise their debts in exchange for equity in the group. Emerald and MRI have indicated that they would be receptive to such a proposal on the condition that the proposed restructuring is successfully implemented. So, of course, we have none of that in this case. So
where are you reading from?
My lord, I am at tab 6 of the...
Yes,
page 17 of 33 at paragraph 41. Yes. So that's a quote from the affidavit that was submitted on behalf of the applicant company in Midway, whereas they've indicated that there are two creditors that are supportive. Keep in mind that the debt load of Midway was 20 million compared to significantly more in this case. So then, my lord, over the page, still in the judgment, and I'm going to ask you to go to paragraph 50. Now, this is a part of the judgment that is indeed excerpted by the company in its skeleton. And so here, Justice Siegel is quoting Chief Justice Smelly in his decision in Fruit of the Loom. No, I'm sorry, Sun Chong Creative Development. And the last sentence of paragraph 50 before the quoted section reads, the Chief Justice summarized the matters to which the court may have regard when exercising this discretion as follows. And now Justice Siegel has underlined in subparagraph C, that there's a real prospect of refinancing and or a sale as a going concern being effected for the benefit of the general body of creditors. And paragraph 1 goes on to say, Justice Siegel says, in Fruit of the Loom, the Chief Justice has said that, underlining, added, there's a three-stage test. Now, this is under Section 104, I believe, my lords. It's on appointment of PLs, 104 of the Cayman Companies Act. That the PL should be satisfied that a refinancing and a sale of the company's business as a going concern is likely to be more beneficial to creditors than a liquidation realization of the company's assets. Two, that there is a real prospect of a refinancing and or sale as a going concern being effected for the benefit of the general body of creditors. So in Cayman, there is this jurisdiction that's built up that we're looking at when you're talking about a light touch provincial liquidation, the real prospect of a refinancing or sale. But here's what's crucially important, we say. If we turn over the page, this is paragraph 53C. And this is where Justice Siegel says, the court should, in the circumstances of this case, exercise its discretion to appoint JPLs. The company was in the process of making bona fide proposals for a restructuring to the group's creditors. And while the process of consulting and obtaining the support of creditors was still at a relatively early stage, and while there have recently been challenges by and potential difficulties resulting from the action of the Kenyan creditors, there was a real prospect that the requisite creditor support would be obtained and that the restructuring proposals and a restructuring of MRI Kenya and the company would be successful. And he goes on to say at the end of this paragraph, in addition, it was clear that the restructuring proposals were in the interest of Zurara's and the company's creditors. Zurara is the subsidiary. And the company's creditors, since the alternative was an insolvent liquidation of Zurara and the company, which was likely to result in creditors receiving nothing. So I'll stop there. That's much different than this case. We know that the company said in a liquidation scenario that there will be a return. But what this does is it makes very clear that when you're analyzing real prospect, and it makes sense, that you must look at requisite creditor support. So that I say, and the petitioner says, my lords, that if there was a situation, as in this case, where there isn't sufficient creditor support, that goes directly to the question of real prospect. And if we're going to, my lord, if my lords are considering clarifying the law in relation to these light touch provisional liquidations and what the court should be looking at, it seems to me that a clear statement of creditor sentiment is important. And if we're going to import
a clear statement of what?
Of requisite creditor support,
right,
must be considered in the context of these decisions. And it makes absolute sense. But if the court is indeed looking to establish some principles around this, it only makes sense. And this is what we tried to express to the learned judge, and I'm afraid he didn't really reveal that consideration in his rulings.
Yeah.
That if the company, and remember, the company's had time to do this. There was the original scheme that failed. There was the first return. There was a suggestion that the creditors hadn't considered it. There was a second return, and there was no creditor support. In fact, further creditors come on board saying we don't want this. And in those circumstances, we say a further adjournment is clearly wrong. And this court respectfully ought to intervene and make a winding up order and allow the appeal.
right.
My lords, I've gone on for some time. The final point I wish to make is on public policy. Very quickly, there is a decision in the matter of Up Energy Development Company Limited. It is I believe it's the final authority in the appellant's authorities bundles. Straightforwardly, the proposition I make is this: that in recent times, the Hong Kong court has become much more active and willing to take jurisdiction of offshore companies in relation to winding up petitions. In Up Energy, in fact, what Madam
Mr. Taylor, I don't have the authority you're referring to at least.
Yes, my lord, I will find it for you. It's in the appellant's authorities bundle. It is at
I'm
tab
sorry.
26.
That's why I'm looking at the wrong bundle.
Yes, my lord, it's at tab 26.
Thank you.
Mhm.
This is a judgment of the Honorable Madam Justice Chan. And anecdotally, I understand that Madam Justice Chan is hearing more of these sorts of company petitions in the Hong Kong court. I'm not going to take you through it, but the judgment does illustrate that the Hong Kong court is moving to a more interventionist approach to dealing with the presentation of foreign petitions in relation to offshore incorporated companies, Bermuda included. This Up Energy decision is in relation to a Bermuda company. The very real concern that I espouse, and I ask the court in some way, shape, or form to consider, is that in the event that in cases such as this, where we say the principles and the facts overwhelmingly point to a winding up order being made, the concern is that our court will cease to be a court of choice for certainly winding up petitions being brought by creditors in relation to Hong Kong listed companies. And my lord, in short, and you'll see in this Up Energy decision that the Hong Kong court is more willing to intervene. And if Bermuda law doesn't strike the appropriate balance between maintaining its light touch provisional liquidation regime, which has been very valuable for companies looking to rehabilitate themselves on appropriate grounds when the right facts and circumstances exist, but at the same time protecting creditor interests in circumstances where creditors clearly wish a winding up order. And in the circumstances of this case, which is somewhat unusual because we have a preview based on the previous scheme, and there's absolute unanimity in those have appeared, and it's a significant majority of aggregate debt. Our court will cease to be a court of choice for creditors looking to exercise their winding up rights, and there's a real concern about that in my opinion.
Right.
And I won't take it any further. Finally, of course, the orders that are being sought by the appellant are as that the appeal be allowed, that this court assert its own jurisdiction based upon the errors that I have said respectfully the learned judge has made in the judgment below, that an immediate winding up order be made, that costs be awarded to the petitioner in the usual insolvency way, that is on a first priority basis in the liquidation. And my lords, finally, and I may make an unfair request, and I acknowledge it is an unfair request, that if you are with the petitioner and you feel that you should intervene and make a winding up order, that if the court is at all able to come to consensus, that happened before the 27th. Because my concern is this, in line with what I've said about the reputation of the jurisdiction, is that I put it no further than it seems to me that it is possible that the Hong Kong court will make a winding up order Wednesday. And if that winding up order is made, it's possible that the court will decline to follow through or doesn't seem to me it needs to follow through in a ruling in this matter because the company will be in liquidation. And I am concerned about these judgments being relied upon for the proposition that you can promote a scheme without any creditor support and continue to have it adjourned when creditor support for winding up increases, and that will be cited as a justification for companies continuing to do this and precluding winding up orders. And that's my concern. So Lord, I know it's a very big ask, but I do so for what it's worth.
Well, there are a number of possibilities. One is that we're not with you, in which case the question doesn't arise.
That's correct, my lord.
The other is that we might be with you and we might not, and don't really feel like it's possible to determine before 48 hours have elapsed. The third is that we do think it's possible to determine in your favor, in which case, speaking for myself, the most that we could do would be either to announce that we will be making the order or to make the order. The idea of producing a judgment on a written judgment on less than 48 hours notice seems a little unrealistic.
No, my lord, and I would never expect that. And I recognize all of the possibilities that you've cited. I mean, what I had imagined was that if the court was together on this, and it's an if, that it would be a pronouncement with reasons to follow. I certainly would never expect the court to come up with a reasoned ruling in this length of time, my lord.
Right. Okay. Thank you very much.
Thank you, my lords. I'm very much, and I should say, I'm very much obliged for the court coming together in a special sitting for this matter.
Thank you. Right, Mr. Robertson.
Good afternoon, my lords. I hope you can hear me clearly.
Yes.
From setup. Obviously, my lords, you have with you our skeleton argument, which there were sequential exchanges of skeleton arguments, so it wasn't possible to respond to the petitioner appellant's position in our skeleton. But very broadly, my lords, the position put forward by Mr. Taylor in my submission really boils down to two central propositions, which I will seek to address. And the first of those is that the judge was fundamentally wrong in his 31st of May ruling, his 9th of May decision to further adjourn the petition because it is submitted that he didn't appreciate or didn't accept the overwhelming creditor opposition to a soft touch provisional liquidation and then a potential restructuring scheme. And so, so my lords, the first point really is that fundamental point that he didn't appreciate properly, that it was that effectively the provisional liquidation was hopeless. And then secondly, the second thrust of Learner Friends submissions are that the company was guilty of breach of the soft touch provisional liquidation order, and that the judge ought to have appreciated that the company was in breach, and for that reason to have abandoned the soft touch provisional liquidation in favour of a winding up order. So in my submissions, my lord, I will attempt to deal with those two broad areas of submissions from a learned friend, dealing with the detail, of course, of the points which I would respectfully ask the court to take consideration of. Now, it's clear, my lords, that the decision that the judge reached on the 31st of May, following his 9th of May ruling, can't be, in my submission, viewed in isolation from his prior decision in March, which followed on from the December order of the 14th of December, because in the December order, of course, he deals in some detail with the legal position in terms of his jurisdiction to adjourn. There's no dispute, of course, that he has a jurisdiction to adjourn because the Companies Act says he has a jurisdiction to adjourn in section 166. And therefore there can be no question that he had the power to adjourn. And the proposition put forward by the appellant is that there was only one way in which he could exercise his discretion, principally because of creditor opposition to the proposition that if allowed time to work with provisional liquidators, the company could put before the creditors a scheme of arrangement proposal, which the creditors may vote in favour of. Of course, I accept everything that Mr. Taylor has said in terms of the percentage of creditor support that the company would need to muster in order to restructure its debts by way of a scheme of arrangement. But, my lords, principally where I depart from my learned friend submissions is this proposition that the judge was wrong to accept that creditor support could be garnered so as to support a scheme of arrangement. And if I could ask you to turn, first of all, to his ruling on the 31st of May, which you have in the binder, tab 9, bundle A, tab 9, it starts at page 80. I want you, first of all, please, if you wouldn't mind, to turn to page 87, which is a submission which I made to the judge, and Mr. Taylor has already referred you to. But it's an important submission and my respectful submission in addressing this point. And it's paragraph 17 in particular of the ruling, which is at the bottom of page 87. And what the judge says there is that I submitted that the petitioner had not been able to obtain any additional creditor support in favour of winding up the company. He argued that the support of the existing creditors is tainted by multiple factually untrue material statements about the company made by the JPLs at the creditors' meeting before the support was reconfirmed. Thus, little weight should be given to the purported continued creditor support. Now, dealing with the first sentence of that, where the judge records my submission, I accept, of course, that the percentage creditor support that Mr. Taylor referred to and his client referred to in his evidence that was before the judge is what it appears the current creditor support to be. But the second part of that paragraph is a submission which the judge accepted that I made, and that was that the creditor, that he should not simply accept the proposition that the creditors will vote in favour of a scheme according to the position that they adopt in terms of what could be referred to as the show of hands.
Where did the judge make that finding, Mr. Robinson?
Well, I'm taking you through that, my lord, and if I'd ask you to turn, please, to page 96, and it's his finding on what he refers to as exceptional circumstance 4. And I respectfully submit that this paragraph needs to be read extremely carefully, because when one does read it carefully, as I'm going to go on, hopefully to do, in my submission, it shows that the judge did not accept that there had been appropriate surveying of the creditor's position. And what he says, I think I'll pick it up, Lord, sorry, if you give me a moment. Where he says, paragraph 39, page 96, after he refers to exceptional circumstance 4, he says, I've once again given serious consideration to the views of the creditors and to their position atop the hierarchy of interests that I should bear in mind. Now pausing there, my lords, he doesn't say, I've given serious consideration to the fact that there's 66.4 or 65.3% referred to by the petitioner. He doesn't say that. But my submission, what you can take from what he does say, is he says he's given serious consideration to the views of the creditors and their position.
Mr. Robinson, sorry to cut across you. The problem is that the judge makes these statements without reference to the evidence that Mr. Taylor has taken us to, in particular, the fact that sum 4 was sent to all the creditors, and they were asked to whether they would restate their position, and they did. And Mr. Liu for Citibank went into rather cogent reasons as to why his clients weren't prepared. Now, those are matters which, if the judge was going to ignore, he should surely say why he's going to ignore them. But this seemed to me rather cogent.
Well, my lord, Mr. Taylor refers to sum 4. But what he doesn't do, of course, is he doesn't refer to the fact that the judge had before him 3 further affidavits from Mr. Shum dealing with key important issues which are said against the company in terms of these serious allegations that the company had been guilty of asset dissipation.
No, but the only point I'm referring to is the fact that sum 4 went to the creditors. The creditors were canvassed as to whether it made any difference to their previously expressed wish for there to be a winding up. and none of them changed their position.
No, my lord, that's quite right. I'm learned Fred, Mr. Taylor, and my lord's question to me puts to me that in terms of Citibank's position, Wilkinson and Grist replied in detail to explain why they hadn't changed their position. But many of the other creditors simply replied by short emails saying they hadn't changed their position. And my submission is, and I want to take you on to the end of paragraph 39, because my submission, what the judge says in paragraph 39, is entirely explicable given what he was told in terms of Shum 4 being sent to the creditors, containing certain allegations against which Mr. Shum then responded to. But then, of course, the judge had the benefit of further evidence about the allegations that had been made against the company before he reached his decision. And so what I would ask you to do, my lord, is to look at the rest of paragraph 39, where he says, so he's accepted in my submission, he's accepted that the hierarchy of interests is with the creditors, and he's accepted that he's obliged to give their position serious consideration. But then he says, Mr. Robinson's submissions in essence were that the creditors have not been given proper consideration to the efforts of the company. Moreover, that they had been prejudiced in one way or another against the restructuring efforts. And I will endeavour to show you, my lords, why I submitted that to the judge and why that is correct.
Okay.
And then he says, in my view, as already stated, the company should be given the opportunity to work with the restructuring troops. And this is his reference to restructuring troops is a reference to Chief Justice Caveley's decision in Up Energy Developments Limited, which is not in the papers before you, but I think it's extracted in his first ruling, where Chief Justice Caveley used this very, I would say, opposite metaphor for JPLs with soft touch powers, that they were effectively the restructuring troops. So in reading that sentence again in paragraph 39, in my view, as already stated, the company should be given the opportunity to work with the restructuring troops so that proper information can be collated, analysed, and properly put before the creditors for their full consideration. And in my submission, my lords, when one reads carefully that paragraph, it is clear that what the judge is saying is that it's what the court is interested in my submission, quite rightly, is the creditors being given proper information, collated, analysed, and properly put before them.
But this is all general stuff. I mean, the big problem with this is that he has had specific matters to which he was referred, namely the fact that creditors, after they had been shown Shum 4, had not changed their position. And he hasn't said why he's disregarding that. He's just come out with general language about them being, quote, given the opportunity to work with the restructuring troops.
Well, all I can do is submit, as I've already submitted, that when one reads it, it's clear that the judge is saying that he's not accepting the position of the creditors at the time of this, that he had the various hearings that led to this order, because the company, with the benefit of court-appointed officers, should be given the benefit of putting before the creditors proper information. I can't take it beyond that. But
but that's the problem, isn't it?
It's slightly unsatisfactory, because I think you're saying that the judge must be taken to have found that the creditors haven't received proper information, or that it hasn't properly put before them. But if one then says, well, why did the judge find that?
Well,
completely unclear.
All I can do is point to the references in the judgment where he refers to the submissions that were made to him and what he then says in response to them. And I've showed you already paragraph 17 of the ruling, in which he recites my submission that there had been multiple factual inaccuracies in the information put to creditors. And then to give you a further example, in paragraph 26 on page 90, and this is a major point taken against the company, it's taken against the company in the multiple hearings before the judge, and taken again before this court in detail today, that point is made, the allegation is made that the company's been guilty of asset dissipation. And what he says in paragraph 26, he's reciting Mr. Taylor's submissions, and you have about 12 lines down, you'll see a sentence that starts, Mr. Shum explained. Mr. Shum explained why no asset dissipation had occurred, as Dynamic Frontier and Sky Courage are wholly owned by Sound Hong Kong, and the purported reason for setting up those two Samoan companies was to reduce stamp duty liability. And so he's not
all he's doing there is saying that Mr. Taylor noted that Mr. Shum had explained. He hasn't said anything beyond that.
Yes, that's right, my lord. But if I could also draw your attention to paragraph 38 on page 95, and in paragraph 38, he says, I'm just following on from circumstance 3 in the first line. I am still of the view that there is potential for value destructive consequences in making a winding up order. I'll come back to that point. However, I'm also still of the view that the JPLs with soft touch powers will insist in ensuring that the company maintains the value of its key assets by avoiding such value destructive impacts by negative impacts of continuing to operate in the PRC under a winding up order. And then I've considered the submissions, Mr. Taylor, that the company's been entered into various agreements and pledges for which it should have consulted the JPLs. Mr. Taylor's point is that it is doubtful whether the value of the company or the group, for that matter, have been retained its value in light of the asset dissipation that's taken place. On the other hand, Mr. Robinson points out to evidence to show that there's been no asset dissipation. Rather, the actions taken by the company were always intended to be taken to allow the company to restructure and address its financial obligations. And then he continues, however, I am focused on the main issue, is that a winding up order has potential for value destructive consequences. Therefore, it is incumbent for the company to cooperate fully with the JPLs in order to benefit from their expertise as restructuring troops, in order to avoid a value destructive consequence. In my view, exceptional circumstance 3 still applies. So
that's another example of reciting submissions but not making any decision about them. Because he says, I've considered the submissions by Mr. Taylor company as being entered into varying agreements for which it should have consulted. Doubtful whether the value has been retained in the light of the asset dissipation. That was the submission. Then Mr. Robinson has pointed to evidence show there hasn't been an asset dissipation. So when you ask oneself, well, are we now coming to what the judge finds in relation to those submissions? One goes into the next sentence, no, I'm focused on the main issue of this exceptional circumstance 3, in that a winding order has the potential for value destructive consequence. So we haven't a clue what the judge has found.
And more to the point, Mr. Robinson, he's made that finding and made the statement that it's incumbent for the company to cooperate fully with the JPLs, when the JPLs have said that's precisely what the company has not been doing. They haven't cooperated. The JPLs don't.
Well, Lord, the company before the judge and the company before this court strongly contests the proposition that they haven't cooperated with the JPLs.
Well, that's interesting. So when the judge says it is incumbent for the company to cooperate fully, are we to take that as a finding that the company had not cooperated fully?
Well, my lord, he doesn't say that. But I'll take you to the evidence that was before him, which is in Shum 7, in which in Shum 7, an affidavit not provided to the creditors, for example, that Mr. Taylor relies upon. In Shum 7, Mr. Shum explains in detail the lengths to which the company went to cooperate with the JPLs. Now, the judge and this court could be here for a very long time to make factual findings of whether or not the JPLs asked for X and the company were provided X. But in my submission, that's not the function of the judge on this application for a German.
Just a minute, Mr. Robinson. The problem with all of that is the JPLs are independent professionals who have made a very strong statement that the company is not, in fact, cooperating with them. I mean, the language in their report is very strong.
Well, Lord, Mr. Taylor is open to you part of that report, and the report is 51 pages long, and I'm not going to go through it, nor could I go through it in detail. But what I submit about the conclusions in that report, and I'd ask the court to bear in mind, of course, that when the hearings started, which led to the ruling on the 9th of May, the company didn't have the report from the JPLs. It was in the course of those hearings that the JPL report was disclosed by the JPLs to the company. So the JPLs approached the hearing on the basis that they could report confidentially to the court. And then in the course of the hearing that was produced, and then the company had to respond to the accusations made against the company in the JPL report. And that was done in Mr. Shum's 6th affidavit. Again, an important affidavit giving factual responses to these allegations of wrongdoing, which was before the judge when he reached his decision on the 9th of May, but which was not shared with the creditors. And the point, in answer to my Lord Justice of Appeal Bell's point to say, well, the report is critical of the company's engagement with the JPLs, and I accept that the report reads as if it's critical of the engagement between the company and the JPLs. But what the JPLs do not do as officers of the court in their report to the court is to recommend to the court that there should be an immediate winding up order. And so I could ask you to turn to that report in bundle.
But before we do that, can you tell me when the company got the report?
I'll get the precise dates for you, my lord, but you'll see if you turn to bundle C into the affidavits and the sixth affirmation of Mr. Shum, which is at tab 20 in bundle C at page 399. At 399 paragraph 2, sorry if I'm going too quickly for you. You'll see in paragraph 2, he says, I make this sixth affirmation.
Hold on a minute.
I'm sorry, Lord.
I have it now. 399.
399. I make this sixth affirmation pursuant to the order dated the 14th of April 2020 in relation to the disclosure by the JPLs of A, their report to the court dated the 14th of March, which was only provided to the company on the 14th of April, and B, over 330 documents purportedly corresponds with the company's creditors provided on the 20th of April, less than 1 day before the affirmation was due. And so the order of the 14th of April is in bundle B at tab 10.
Okay.
And to take the chronology back slightly, you may have seen this in the papers, but there was an order sealing the order of the JPLs on the file, which was obtained ex parte, and then the JPLs agreed for the disclosure of their order. So you'll see at paragraph 1, page 150 at paragraph 1, the order dated the 17th of March is varied as follows. And then over the page 159, after paragraphs 4 insert, notwithstanding the above, i.e. the sealing of the report on the file, the JPLs may serve on the company and the petitioning creditor any report filed with the court. And then 2, the company and the petitioner shall file any evidence upon which they intend to rely by the 22nd of April. So that's the order to which Mr. Shum is referring in the sixth affirmation. And so the hearings which took place before that took place before the company had disclosure of the JPL report, and the judge was proceeding, and it only became apparent in the course of the proceedings and the various hearings before him that there had been a confidential report to the court, which the company did not have. So I hope that, my lords, that might be of some help in giving you part of the sequence, and part of the reason why I say that Mr. Taylor's and the appellant's focus on having sent the fourth affirmation of Mr. Shum to the creditors informs in my submission what the judge is saying in paragraph 39, where he makes the finding that the company should be given the opportunity to work with the JPLs so that proper information can be collated and properly put before the creditors. And very importantly on this point, I need to take you back, I'm afraid, to the information that was provided to creditors about which Mr. Shum complains in terms of the information not being accurate. And this focuses particularly on the meeting of creditors which took place in January. And so if I could ask you please to turn to Mr. Shum's third affidavit, which is at tab 11, bundle C, tab 11. And you'll see if you look at page 259, which is the first page in tab 11, this affidavit is sworn on the 15th of March, and it's sworn in support of the company's application by summons, which is recited at paragraph 2 of Mr. Shum's third affidavit on page 259. an application by the company to restate the express limitation in the scope of the powers that effectively that the appointment of the JPLs was for restructuring purposes. But I want to take you in this affidavit to paragraph 33, which is on page 265. And this deals with a meeting of creditors which took place on the 28th of January of this year. So the JPLs, as you know, were appointed on the 14th of December, and they held I think what's referred to as an informal meeting of creditors on the 28th of January. And what Mr. Shum says in paragraph 33, first, one of the JPLs made several inappropriate and incorrect statements at the creditors' meeting, which was the first morning meeting hosted by the JPLs and attended by the company's legal and financial advisors. I'm sorry, but there's some feedback on the line, and I'm not sure if you can hear me.
I can hear you, but I can hear the feedback too. I think. Yes.
So in paragraph 33 on page 265, Mr. Shum is dealing with the meeting of creditors on 28th of January. Paragraph 33A, and as you said at the outset of this hearing, you've read the affidavit evidence, so you'll recall perhaps that the company had retained Oriental Petron Asia Limited as an advisor. That's referred to in same page in paragraph 31. And so paragraph 33A refers to their report after they reported that there was very little discussion, but that's by the by. What I really want to ask you to look at is paragraph 33B and C. So Mr. Shum is saying in paragraph 33B, rather than asking questions of the company's advisors about restructuring, he says instead one of the JPLs states the sale of the company's assets would be a liquidation sale rather than a restructuring sale, undermining OPAL's entire report without explanation. When confronted with a request for the grounds for the statement, the JPLs were unable to explain the basis for the statement. This comment was deeply prejudicial given the role of the JPLs as the independent officers of the court. Despite the company's request, the JPLs continued with their refusal to clarify the statement, explain its basis, or retract it with the creditors. 33C, one of the JPLs stated to the creditors that the core assets of the group may no longer be under the company's control. Prior to the creditors' meeting, the company explained in a letter dated the 26th of January 2022 why that assertion was incorrect. Despite not disputing the explanation, the JPLs omitted the company's explanations during the meeting, causing immediate alarm and confusion amongst the creditors. When confronted with this, the JPLs also refused to clarify the statement or acknowledge the company's response. I'll just give you two further paragraphs, please, 34 and 35. In addition to these highly prejudicial or incorrect statements, the JPLs failed to inform the creditors of the company's achievements, including the company's offer for the JPLs to meet with a potential investor and the company's arrangements for the JPLs to visit the group's facilities in the PRC. One of the JPLs confirmed the JPL's prejudgment by remarking in front of the creditors that, quote, unless there is a miracle, the JPLs will be making an application to the court stating that this arrangement is not working. Such a statement unequivocally showed that the JPLs had already reached a conclusion without reviewing all of the evidence or taking the necessary steps to facilitate restructuring, such as meeting a potential bidder. So the minutes of that meeting are in. You may have a separate. I certainly have a separate binder G, which is white in color. It's different from all of the others. But the minutes of the meeting are found in several different places. But where I find them most conveniently is in this bundle G behind tab 1, starting at page 4564.
What was that page number again, Mr. Robinson?
So the report starts at 4564 behind tab 1 in this
4564.
And of course, again, very long minute of what must have been quite a long meeting. But I want to show you two short passages from the minute, if I may.
I'm sorry, I've lost this bundle. Why don't you read it out and I'll find it later.
There are two short passages which I want to direct the court to, if I may. And the first one is on page 4566. And that's on, and 3 paragraphs up from the end. There's a fairly short paragraph which I'll open to the court. Further, the JPL, and this is part of the JPL's presentation, as I understand it. Further, the JPLs have found through publicly available information that the company has conducted a series of share allotments and transfers of shares that appears to have resulted in a significant dilution of controlling interests in its holding over the major assets of the company. This may affect the structure of the aforesaid LPG asset, which is up for sale, and also the assets and share pledges that the company is proposing to be put up for security. These transactions were undertaken just prior to the winding up application and are subject to further investigations, as this also may have a potential material effect to the consolidated book equity value of the company, since it would appear that certain subsidiaries are no longer controlled by the company. Not only has this not been disclosed in any announcements made by the company, but the company has also not provided any supporting document to explain the reasons for the transactions. So that's the statement to the creditors meeting, that there is effectively being shared allotments and transfers to the detriment of the creditor body. And then second passage, which I would ask you to notice, is on page 4571, just a couple of pages over. And this is in the middle of the page. There's a paragraph which starts, Mr. Fung interrupted.
Sorry, what was the page number again?
Sorry, my lord, page 4571.
Mm-hmm.
And there's this is in part of the meeting where Mr. Han from Coburn & Kim is representing the company, and he is speaking about the proposed restructuring. And then Mr. Fung interrupted. Mr. Fung is representative of one of the creditors. I'm afraid I don't recall which one, but the paragraph starts, Mr. Fung interrupted and asked if the creditors would like the JPLs to do a brief summary of what the public information has shown, i.e. the public information which allegedly shows asset dissipation. He then continued, Mr. Arthur Lai of the JPL's office went on and explained that the transactions referred to with Mr. Han and Mr. Stay are separate ones. The JPLs can see that 1% share transfer, the JPLs can see the 1% share transfers in major operating subsidiaries, but at the same time, there are major share allotments happening in other subsidiaries. Taking the Zhuhai property, for example, it was held under the subsidiary New Energy Limited, whereas a few months before the appointment of the JPLs, 99999 shares were allotted to a Samoan company, which is known to be outside the group. And I emphasize those words. Then he continues, this effectively reduces the company's interest in the Zhuhai property from 100% to just 0.1%. Similar share allotments happened to New Ocean Energy Development Limited, which operates the LPG business in the group. These two subsidiaries should be the ones referred to with Mr. Say. So I ask you to look at these passages in the creditor meeting, because in the creditor meeting that took place in January, the proposition being put forward to the meeting of creditors is that the company had wrongfully entered into share allotments and transfers, which were designed, or perhaps not designed, but had the effect of dissipating assets from the group. Now, the reason why this is important to my submission is because Mr. Shun's affidavit evidence, not only his fourth affidavit, but also importantly his fifth affidavit, and also his, I think his sixth affidavit, I'll come back to that, deals in very considerable detail about why the allegations made against the company with respect to asset dissipation were wrong. And I can take you in detail to that if it's of assistance, but the submission is that when the judge is referring to proper information being put to creditors, in my submission, it has to be seen in the context of the creditors having been given this information by the JPLs at this meeting in terms of the allegation of asset dissipation and effectively wrongful action by the company. But of course, by the time we get to the hearings in April and May of this year, the judge is being given by the company very extensive affidavit explanations for those share transactions, which I need to deal with them in detail. I appreciate, because of Mr. Taylor's second main theme, which is the points that he alleges that they result in breach of the order, and we submit that they do not. But this part of my submission is to deal with the point that it is said by the appellant that the company, that the creditors had been provided with the fourth affidavit of Mr. Shum. The creditors had responded, who were supporting the petition with the appellant, and therefore it is incontrovertible that that creditor body is never going to support a consensual debt restructuring. And I take the court to this because in my submission, both the learned first instance judge and this court must also see and appreciate that Mr. Shum's fourth affidavit is just the start of the explanation as to why those allegations were wrong. And he then gives much further explanation in further affidavit evidence, which the judge had the benefit of reading.
So, so we have a position where the judge, at the very highest, cryptically refers to inaccurate information without revealing what it is. So we don't know which of the matters, if any, in Shum 4, 5, 6, or 4, 5, or 6 he accepted. He then refers to going forward so that the shareholders can have full and proper information. But what's he envisaging? That the shareholders get sent Shum 5 and 6 and the company's response thereto? I mean,
no, my lord. In my submission, what he's envisaging is that the company's position has always been that it wishes to promote a scheme of arrangement. And of course, Mr. Taylor takes all those points against me and took them against me below, which is to say, well, there was a scheme and it didn't work, etc., etc. But the proposition is that.
No, I'm so sorry. I shouldn't have said the company. I meant the petitioner.
Yeah. And so, in my submission, the court has, and of course, the judge in the hearings in March and March and April, which resulted in the May ruling, has already appointed JPLs with soft touch powers in December, on December the 14th, a decision against which there was no appeal. So he's made that fundamental decision in December that this was a case which was appropriate for the court's officers to be appointed to assist the company on a light touch basis to see whether or not it was going to be possible to put before the creditors a scheme which they would accept.
But it's not cast in concrete when the decision is made, Mr. Robinson. And what happened in this case was that after the light touch order had been made, the liquidators, the JPL, said, this isn't working. We're not getting the cooperation we need. And surely at that point, it's incumbent upon the judge to pay attention to those complaints.
Yes, but with respect, that's exactly what the judge did do. And if I could take you back to the JPL report, the point seems to be taken against me that the JPLs at the hearings in April and May, March and April, which led to the decision on the 9th of May, had formulated the position before the judge that a consensual restructuring by scheme of arrangement was impossible. And in my submission, my lord, that's not what the JPL's report said. And the JPL and what the judge said with regard to Mr. Rialoma's submissions, and if I could just look at that before I take you to the report, what the judge said about Mr. Rialoma's submissions was completely correct in terms of the position of the JPLs. And that's in binder A, my lords. Sorry, if you just give me a brief moment. Page 88. And Mr. Taylor's taken to this already, but page 88 in binder A is the subject ruling. And what the judge records in paragraph 21 is Mr. Rialoma submitted that the JPLs were willing to continue to work with the company. Now that, in my submission, is reflective of exactly the conclusion the JPLs reached in their report. And I'm sorry to jump around between binders. I appreciate that it's frustrating. But the JPL, the short conclusion in the JPL report that I want to direct the court to is in Bundle E at tab 1 at page 3399. 3399.
Thank you.
And the paragraph which I wish to refer to is on page 51. And Mr. Taylor took you to the previous paragraph, the second paragraph, first full paragraph on the page, which he referred to in terms of the potential for disorderly insolvency. But then what the JPLs then say is, in light of the situation, the JPLs have, by the letter of the 14th of March, written to Cobra and Kim to reiterate the need for the company and its advisors to provide the information, access, and cooperation the JPLs consider is necessary if a restructuring is to be proposed, and to formally put the company in notice that the company has 10 days in which to do so, and that the JPLs will report to the Bermudian court whether the company has reversed course. So the JPL report in my submission that was before the judge, which, as I've already explained, only came to the attention of the company partway through the hearing, did not conclude that a proposed restructuring by scheme of arrangement was a hopeless exercise. And in my submission, the judge quite correctly records in paragraph 21 of his judgment that Mr. Rialoma submitted the JPLs were willing to continue to work with the company. And so in my submission, the judge was not dealing with a situation where, having appointed his officers on the 14th of December, they had come back and made the conclusion that there was no possible way in which there could be a consensual restructuring. I was going to say quite the opposite of that. Now, I accept, as I must accept, that the JPL report and the response of the company shows that there was disagreement between the company and the JPLs with respect to the scope of their powers, their conduct in their office, and numerous other issues which are dealt with in detail in Mr. Schlimm's third affidavit. But the position is not reached at the hearing before the judge that a restructuring is not possible, or that the JPLs have given up all hope of being able to assist the company to propose a restructuring proposal that the creditors might accept. And so in my submission, that's an important point in terms of either, and of course, I can't say things to the judge that are not in his ruling. I've taken you to the paragraphs which he has stated his reasoning. But I go back to the same sentences, or the same sentence in paragraph 39, where the judge is referring to the company being given an opportunity to work with the restructuring troops so the proper information can be put to the creditors.
Mr. Robinson, cutting to the chase, there still hasn't been a proposed scheme given to the creditors after what has been months and months and months. So I don't. Let me just.
I'm sorry. I didn't mean to
interrupt. No. So I don't understand how the judge can possibly speculate as to whether the creditors might or might not support any scheme if no scheme has been produced.
Well, it was never envisaged that a scheme of arrangement would be proposed to the creditors before the first return date. Before the return date of the petition in April, and that I appreciate that is not clear from the judge's ruling, but it was very clear. And again, I appreciate that the Court of Appeal does not have this, but it was very clear from my skeleton argument that that the company was asking for 4 months in order to advance their proposal for a scheme with their creditors, but not that a scheme would in fact be proposed within 4 months. And if I could just, dealing with my Lord Justice of Appeal Bell's point, I think you have in your in binder A, at least I hope you have, that the judge's ruling, or you may be sent it separately, the judge's ruling on the 8th of July, which I appreciate is after the order that's appealed against. But you'll see I'm not sure, my lords, if you have that. I have it in my binder A. But
Sorry, what's the date of that, Mr. Robinson?
the ruling is the date of the 8th of July, 2020.
I believe we have it.
Well, for some reason, it's at tab 10 of your authorities.
Oh,
That's right, they got put at the end there.
well, at least I'm glad you have it. But what the judge on page 3 of his ruling, he directed in paragraph 7F that a proposal be submitted to the JPLs within 14 days of that ruling, and a proposal be submitted to the petitioner within 14 days thereafter. So I appreciate that this is not the ruling which is being appealed against, but subsequently the judge, having heard further argument on the 8th of July, it has still allowed the company the time to produce to the JPLs a proposal with regard to the debt restructuring. And my instructions are that target, or not that target, but that direction is being complied with.
So sorry, let me just work this out. You said the company was asking for 4 months to advance the scheme, but not actually to produce one. Is that what it amounts to?
Yes, Lord. It was not. The company did not. The company's evidence in Mr. Shum's first affidavit does not make that clear. He definitely says in his first affidavit that the company wants time in order to work on the promotion of the scheme. I accept exactly what it says, but in my submission, you don't, of course, have our skeletons from the previous hearings. Was the position put forward to the judge in the earlier hearings, which resulted in the 14th of December ruling, was not that the company was saying that it was going to be able to propose a scheme within 4 months. It was asking for 4 months in order to advance that situation. I mean, it's probably trite to say this, but my lords will have appreciated that the assets that the companies hold are not only extremely valuable, but also extremely complex. The company didn't come before the judge in November and December, simply shrugging his shoulders, saying this is very complex, but, for example, produced expert evidence as to why an immediate winding up order would be value destructive in the form of Chinese legal experts in terms of its licensing. So I could take you to all of that, but the fundamental point is the judge was not making his decision in March and April, which resulted in the 9th of May ruling, having been told in November and December that there would be a scheme order before the 4 months is up, but rather looking at the progress that the company had made towards advancing a scheme.
Did the company present proposals to the JPLs by last Friday?
I'm instructed, my lord, that they did. So I would like, if I may, to go back to the affidavit evidence of Mr. Shum, because I've submitted in broad terms that his 5th and 6th affidavit then deal in detail with some of the allegations made against the company. And I'd be grateful if you would allow me to do that. You've seen Mr. Taylor has taken you to Mr. Shum's 4th affidavit. And if I could ask you briefly to turn back to the 4th affidavit, which is, I've shown you the 3rd affidavit, which was filed in support of clarification of the order. And the 3rd affidavit deals, which is at tab 11, the 3rd affidavit deals with the issues and the problems that the company had with the JPLs between their appointment and the first return date. But Mr. Shum's 4th affidavit is at tab 14 of binder C, starting at page 334. And if I could ask you, first of all, to look at page 335, which is an overview of the situation that Mr. Shum put before the judge at that time. and paragraphs, particularly paragraphs 8 and 9 on page 335. In paragraph 8, he says, in addition to the LPG assets, which the company is negotiating to dispose of for up to 450 million, the company concluded an agreement with a buyer in mid-February 2022 for the potential sale of the Zhuhai commercial complex, with the potential to generate around 286 million in cash. These updates are set out in section A of this affirmation. And then in paragraph 9, the company's intention continues to be to dispose of its core LPG assets and the Zhuhai commercial complex. The targeted timeline for disposal is before October 2022 for the LPG assets, in accordance with the basis of the first adjournment to the order. And quarter 4 of 2022 for the Zhuhai commercial complex, barring unforeseen circumstances in the PRC. And just pausing there before I move to page 336, that reference by Mr. Shum to in accordance with the basis for the first adjournment to the order is the point which I have just been dealing with, and that is that the basis for the adjournment of the order was not the proposal of a scheme by 4 months or the approval of a scheme, but rather that this was the time scale that the company was working to in terms of the generation of cash by sale of its assets. Then if I could move on to the top of page 336.
I'm getting slightly puzzled. I quite follow that in order to raise money, you have to make a series of arrangements with people to buy the assets. But the essential scheme, as I have so far, understood it, is that there should be a restructured facility agreement pursuant to which the creditors who are party to it, and I'm not wholly sure which creditors were contemplated, would not have their debt repaid until September of this year or March of next. And that, in essence, was the scheme.
Yes, my lord, that's correct.
Well, why does it take 8 months to produce something which says that in paper rather more coherently than I've said it already?
Well, my lord, my response to that, my lord, is that the point which I've already briefly made in terms of the complexity of the group structure and its assets, Mr. Schultz, well,
means that it's difficult to sell the assets.
Yes,
the creditors are concerned with what the scheme is.
Yes, my lord, but Mr. Shum's Mr. Lawrence Shum, of course, there's two different Mr. Shums. Mr. Lawrence Shum's first affidavit deals in considerable detail with the difficulty that the company had in negotiations with the creditors in terms of the proposals which were intended to be part of the scheme for which the Hong Kong court and the Bermuda court gave sanction to convene scheme meetings, and the difficulties which the company had in getting to that stage of having a scheme vote. And then in the sequence of the timescale is that by September of 2021, the company had put forward its revised, it's not a scheme document, it's a refinancing agreement, which is referred to in the affidavit evidence as the scheme. But it wasn't able then to produce creditor support for that scheme, for that proposal, and negotiations effectively became difficult and broke down. And so I think, my lord, I'm trying to answer your question because it's an important point, but the point is it's perfectly true to say that the company could propose a scheme in the course of 4 months, because all it has to do is propose what it will do after the scheme has been approved in terms of the realization of assets. But in my respectful submission, without meaning any disrespect, Lord, in commercial terms, that's not really effective for the company, because the company is having to deal with the likelihood then of being able to sell those assets within the context of the scheme. And it simply can't be the case that the company can say, we've got these assets, here's a proposal to sell them, here's the scheme, and expect the creditors to change their minds and to row in behind a scheme. The company's going to have to produce a scheme which deals with the fact that there is, first of all, implacable opposition from the petitioning creditor, and then other creditors haven't so far supported the scheme. So, and no, my lord, it's not a perfect answer to your question, but the answer to your question is that it was never envisaged that there would be a proposal for a scheme by the end of the 4 months. But in my submission, in any event, that would be effectively unrealistic, given the kind of assets we're dealing with, the scale of the assets, and the need to produce something which the creditors might then vote, that there was a reasonable prospect that they would vote in favour of.
But that line of submission appears to indicate that you're not going to be able to have something that passes for a scheme until you found the purchasers of the assets which will pay the money due under the scheme.
Well, not necessarily, my lord. No, that's not those two things. That doesn't follow from the submission that I made.
If I was a creditor, in the light of the explanation you've so far given, I would be completely unclear what it is that you are proposing. Just if I'm owed £3 million and you're wanting me to agree to something which avoids liquidation, are you not capable of telling me in broad terms what exactly it is you want me to agree to?
I think, my lord, it's perfectly true to say that we could tell you in broad terms what we want you to agree to, but of course a scheme is not.
Yeah. Well, okay. Tell me. Okay, I appreciate the difficulties, but I need to be clear. Tell me in broad terms what it is that the creditors are being asked to agree to, or will be asked to agree to.
Well, the creditors are going to be asked to agree to the sale of the LPG asset as the first asset to be sold.
Yes.
And if that asset is sold successfully by a certain date, the date in the documentation was the end of October 2022, they then would afford the company a further accommodation to the end of March 2023 in order to sell other assets to raise the balance of the sum due.
Right.
The affidavit evidence, Lord, of Mr. Lawrence Shum deals with the point which you've put to me in terms of what were the difficulties and the negotiation difficulties with regard to the current proposal, and that is at paragraph 37 and 38 of his affidavit. So we're back in bundle C at tab 1. And I'm not going to read that or open that to you, but in paragraph 37 and 38 on pages 184 and 185, Mr. Lawrence Shum sets out the difficulties or the issues which had been caused the breakdown in negotiation with the bank creditors. And then in paragraph 38, he outlines the issues which remained. And so, Lord, I don't want to make light. I'm not making light of the point.
I'm sorry. Okay. Well, dealing it in the simplest of terms, under this arrangement, are the creditors covered by it to be the bank creditors?
Yes, my lord, that's correct. But the company, apart from the creditor which has petitioned in Hong Kong, the company's position is that there are no other. So all of the bank creditors are set out in Mr. Lawrence Shum's first affidavit at page paragraph 79, page 195, and you'll see that is a table of creditors. Are all bank creditors save for the creditor which is listed at the top of page 197. And the creditor listed at the top of page 197 are intercompany loans, which are 75 million Hong Kong dollars, 8.9% of the total indebtedness. So the bank creditors stop effectively at the bottom of page 196, and they total by my arithmetic 770.2. Somebody can correct me if I'm wrong on that, but so that Mr. Taylor, I think, made a submission this morning that the company's debts are 860 million, but the debts which are recorded in that paragraph, in that table, are bank creditors at 770.2. And Mr. Taylor, I think, is open to you already the letter from Cobra and King, which was written in response to the Hong Kong petition, and that is in bundle F, tab 2 at page 4350.
The problem with these numbers that you just referred us to in bundle C is that they're figures that are now over a year old. 30 June 2021.
Well, they are over a year old, Lord, but and I'll check this point, but I believe that the JPLs, when they were appointed, solicited numbers from each of the bank creditors, and so there is in the record at some point, and I'll get you the reference, an updated figure for the bank creditors beyond the table that the company refers to. But I take my Lord's point that those figures are historic figures. What I was going to ask you to notice was the letter from Cobra and Kim, which is at page 4350 of bundle F, in which
250?
sorry, 4350.
4350.
Where they confirmed that the company confirmed the last sentence of that paragraph 7. The company confirms that it does not have any other non-bank third-party creditors.
So where's this?
Oh, I'm sorry, my lord. It's in a letter from Cobra and Kim dated the
Yes, yes. But where in the letter?
Oh, sorry, paragraph 7.
Oh, I see. Yes. Okay.
The last sentence, my lord. Sorry if I wasn't clear.
So how does that tie in with Kuwait Petroleum?
So that's a response to the correspondence with regard to Kuwait Petroleum, saying effectively that Kuwait Petroleum is the only non-bank creditor. That's what Cobra and Kim's letter is effectively saying.
So wait a moment. If you go back to page 196 of bundle C,
it's in my office.
The bank creditors are the ones on page 195 and 196, which by your math add up to 770. Then there's a trade creditor of Kuwaiti Petroleum, which is obviously not a bank creditor. And K&K confirmed that the company didn't have any other non-bank third-party creditors. Though in fact, if you look at the top of page 197, it had $75 million worth.
Well, intercompany.
Well, intercompany loan guarantee for construction costs and other creditors.
Which I take, and I can check this point, my lords, but I take to mean other creditors of the group. I mean, the company we're concerned with is as you know, the holding company at the top.
Right. Okay.
I'm sorry, my lords, I was wondering if you were going to take a mid-afternoon break. My computer is just reading a charge, and I've unfortunately lost my.
No, we'll take a 10-minute break now. I think our computers are getting tired.
Thank you very much.
Are we going to the meeting room?
Yeah.
Thank you, Lords. I'm pleased to say I've managed to find a charger for my.
Oh, right. Were you running out of power?
Yes, I was. There were warning things on my screen telling me I was about to get
Right.
off. So, Lord, before the break, we got slightly sidetracked. Two important issues I appreciate, but I'd taken you to Mr. Shum's fourth affidavit, tab 14 of bundle 3, and I'd shown you paragraphs 8 and 9, started to show you paragraph 9. That's on page 335 to 336. Just ask you to go back to that part of the record. And I think I read to the bottom of page 335, but I wanted to show you the two short paragraphs following, where at the top of page 336, Mr. Shum says the anticipated generation of 450 million from the sale of the LPG assets and 286 from the sale of the Zhuhai commercial complex will be used to repay creditors representing over 95% of outstanding debt of the company. If the company is also able to dispose of its oil storage terminal, as defined in paragraph 24 of Lawrence Shum's first affidavit, valued at 103.65 million, which it is actively trying to achieve, it will be in a position to repay all of its creditors in full. In addition to the substantial progress already made on these endeavours, as detailed below, the company expects that in the next 3 to 4 months there will be further progress to report to the court. Just before I move on, the reference to the oil storage terminal, the company's structure doesn't own that 100%. It's something very close to 80%. I can find the references to that if helpful, but effectively what Mr. Shum is saying in that paragraph is that the LPG asset and the Zhuhai commercial premises will raise
Help. Mr. Robinson has frozen, so far as I'm concerned.
Yes, and for me. Here we seem to have Mr. Robinson again.
I'm so sorry.
We lost you.
For some reason I was just immediately kicked out. I'm sorry about that.
That's okay.
I'd taken you to the top of page 336, and I think I was just explaining before I left that the oil storage terminal, while the value is recorded there, is not 100% of that value is part of the group structure. And then at paragraph 10, Mr. Shum then continues, given the above positive developments in the prospective sale of its assets, the company firmly believes that it is essential in the best interest of the creditors and the company that it be given more time to complete the restructuring effort that has commenced. The company remains balance sheet solvent, and sale of core assets, including the LPG assets, Zhuhai commercial complex, and the oil storage terminal, as a going concern, will allow preservation of their value for creditors, including those who apparently support an immediate winding up, which is adverse to their own interests. For example, government licenses, which would otherwise be in significant risk of revocation upon winding up. Those assets would be severely devalued in an immediate liquidation due to revocation of licenses and termination of trade contracts, and would result in creditors receiving significantly less than the total amount of their debts. Not to go back to that point, but I made reference briefly earlier to the legal advice to the company from the Chinese law firm with regard to the licenses. If I may, I'll just give you the page reference to that, not ask you to turn to it. That's in bundle D, and the English translation starts at page 1909 of the record. And Mr. Shum.
This is in support of the statement that the licenses will lose value in the event of a compulsory winding up.
Yes, my lord, that's correct. The Chinese law opinion deals with 5 different kinds of licenses that various companies hold,
Right.
and opines that there's significant risk to those licenses in the event of a compulsory winding up.
Right.
Mr. Lawrence Shum, in his first affidavit, makes 2 broad points about that. One is the risk of the loss of the licenses, and also the risk that I think there's 115 key safety staff who are employed in the group, who are also essential to keep those obviously very. It goes without saying, the court doesn't need me to say this, but it goes without saying that that's a very a business which requires safety licenses, and so the evidence before the judge in the first affidavit of Lawrence Shum was with respect to the need to continue the employment of those people who may not continue in liquidation. But the point is that there was Mr. Shum in his fourth affidavit is simply reminding the court of the earlier evidence that was before the court, that there was significant risk to the company. Evidence that in my submission, the petitioner appellant never challenged, didn't challenge at first instance, didn't challenge when the order was made in December, didn't challenge in March or April, and apparently doesn't challenge before this court. But yet that was an issue which was clearly an issue before the judge at first instance. I took you back to this affidavit because I then wanted to deal with effectively 3 further points and to show you Mr. Shum's subsequent evidence. The first point starts at page 339 through 341, and in paragraph 14 of Mr. Shum's affidavit, he gives the court an update with regard to the sale process of the LPG asset, and the court will have appreciated that the LPG asset is the jewel in the crown, if you like, in terms of the assets that the company structure holds. And so Mr. Shum in paragraph 14 at pages 339 to 340 deals with the progress which has been made and details negotiations with various potential buyers. But over the page on page 341, he then deals with the Zhuhai commercial complex. And Mr. Taylor took you to paragraph 16F, and he showed you paragraph 16F, where Mr. Shum explained why it was necessary to enter into a charge with effectively with the potential buyer. And I just simply ask you to have regard to the whole of paragraph 16, A through H, because Mr. Shum gave the first instance judge and gives this court through that evidence a detailed account of why it was necessary for that subsidiary to enter into the charge of the title deeds. But what the judge also had, of course, and which Mr. Taylor didn't refer to, was the 5th affirmation of Mr. Shum, which is at tab 18, starting at page 369. And if I could ask you to look at page 370, please. And you'll see in page 370, paragraph 7, Mr. Shum, he deals with this charge right through from paragraph 7 through to paragraph 11. But I'll just show you paragraph 7, if I may, where he says, the Zhuhai Commercial Complex share pledge was an arm's length transaction and did not divest any ownership of the Zhuhai Commercial Complex from Shanghai. According to clause 3B of the agreement, and it's exhibited, Yu Suho is obliged to discharge the share pledge if the acquisition is not completed within the agreed range of 6 months. And so the date of that agreement was the 26th, I believe, of February 2022. And he continues, as such, the security was granted as a temporary precondition to Beijing Taizai to continue with the sale transaction, and is conditional upon Beijing Taizai's completion of the sale transaction within 6 months. The petitioner's allegations otherwise are based on an incomplete picture of the facts. So I not, of course, it will take me a long time to go through each of these transactions in detail, but what the point I'm making is that Mr. Shum in his 5th affidavit, paragraph 7 through 11, provided the judge with further information with regard to why the petitioner's allegations with regard to that share pledge were not correct. It has to be said that the JPL report, which was before the judge, had recited these allegations in considerable detail. But Mr. Shum's affidavit was actually sworn. This affidavit, the fifth affidavit, was sworn before that report was disclosed. And so I can make the same point with regard to the oil storage terminal. I'll just show you. I'm not doing any detail, but if I could just show you, first of all, where in his fourth affidavit he deals with it, and then where he elaborates upon it. So in the fourth affidavit, which is back in the same bundle at tab 14, he deals with the allegation that there was dissipation of assets with regard to what Mr. Taylor, I think, refers to Shangyang at page 346, which is at paragraph 21H. And you'll see there that, and I think Mr. Taylor opened part of that to you. But if you just turn over to tab 18, which is Mr. Shum's fifth affidavit, on page 372, you will see from paragraphs 12 on page 372 to paragraph 19 373 that Mr. Shum provides then much further detail with regard to the oil storage terminal share charge. So this is not a case that was not before the judge, a case where the company was accepting that these allegations of asset dissipation were correct. And quite apart from that, the company in its evidence gave extensive evidence which had not been shared with the creditor. And of course, the fundamental point is that the additional information in the fifth affidavit of Mr. Shum, which I've just showed you but not open to you in any detail, explained to the judge why the allegations that were made against the company were not correct. But of course, that account of the company as to why the allegations of asset dissipation were not correct were not shared with the creditors, because the fourth affidavit was shared with the creditors. In other words, the company wasn't hiding from the fact that these allegations were being made, but the company was giving the judge significant additional detail with documents exhibited to show that what the company was saying was correct. And if I could ask you to look back again at the fourth affidavit of Mr. Shum, and I appreciate I'm moving around, but I need to show you, first of all, what he says in the first instance and then how he deals with it. And if I could ask you to turn back to tab 14 on page 344. I've shown you those two major issues. One is the two share pledges that the petitioner appellant continues to complain about. But at paragraph 21 on page 344 of Mr. Shum's fourth affidavit, he deals with allegations with regard to share transfers to two companies, Dynamic Frontier, which you'll see mentioned in paragraph 21, and then I'm sorry, if you could allow me a moment. Yes, and then if you turn over the page to 345, at paragraph 21E, you'll see a reference in 21E to Sky Courage. And so the allegation had been made in Mr. C's affidavit that these Samoan companies had been introduced into the structure and that this was asset dissipation on the part of the company. And those were allegations which the JPLs had adopted. And I'll show you in a moment where the JPLs had adopted those allegations. But what Mr. Shum does in his fourth affidavit is that he explains in detail why the allegations with regard to the insertion of Dynamic Frontier and Sky Courage into the structure were not. It simply wasn't the case that there had been transactions which resulted in the assets leaving the structure. I said that I would show you where the JPLs had adopted those allegations against the company. And if I could ask you, please, to turn back to the JPL report, which is in Bundle E. And the JPLs, in the context of their report on page 41, which is bundle E, page 3389. You'll see a heading share transactions on page 41. And at 9.1 towards the bottom of page 3389, and then over to page 9.2 on page 3390, the JPLs give an account of what they say in respect of allegations of asset dissipation with regard to Dynamic Frontier and Sky Courage. The important point, of course, is that if the JPL's allegations had been correct and the allegations which the petitioner had been correct, it would have been a very serious allegation, because effectively the very assets which the company says it's able to sell to raise the funds would have been jeopardized in terms of the structure. But I can't go through that. It would take me several days to go through this in detail. But if I show you page 3389 and paragraph 9.1, share allegation in new energy. This is insertion of a holding company above the Zoo High commercial premises. And at the end of the first paragraph, you'll see a sentence that starts as a consequence. They say, as a consequence, it appears that the company now owns one share or 0.1% equity interest over the Zoo High commercial premises. And then effectively the same allegation then is made in respect of the LPG asset over the page in 9.2. Now the JPLs do put forward what the company says in brief. And if I could ask you to look at page 3390, just above where it says 9.2 share allocation, there's a paragraph which starts, the company advised that New Energy Limited is still wholly owned subsidiary of the group. This could only be the case if Dynamic Frontier is also wholly owned by the group. The company has not provided any further explanation or details about the ownership structure of Dynamic Frontier, nor the reasons for the allotment of shares. And then at the very bottom of 9.2, you'll see exactly the same sort of paragraph saying the company says they still own it. But the important point is that Mr. Schuman's affidavit evidence had given the judge extensive affidavit evidence as to why the allegations made by the JPLs, which had also been made by the petitioner, were not correct. In my respectful submissions, it's of note that these allegations that were made before the first instance judge with regard to the insertion of Dynamic Frontier and Sky Courage into the structure are not pursued in this appeal. And they're not pursued in this appeal because they had no basis. But yet the judge had all of that evidence before him. There were very detailed submissions with regard to extensive affidavit evidence, extensive exhibits, loan agreements, charges, which I took the judge to explain to him why the allegations being made by against the company were simply not correct.
And what did the judge say?
Well, so the judge then, I'll just find my ruling again. So the judge, I fully accept that the judge simply recorded that there had been allegations made and that I'd made submissions to him that the allegations were not correct. But my lord, the very important point in my submission is that the judge is not conducting a trial with witness evidence as to whether or not what the petitioner says is correct or what the company says is correct. If that were the case with regard to the adjournment of a winding up petition, there would be extensive trials of adjournments of winding up petitions. In my respectful submission, the judge was completely correct to record in his judgment the recording that he does to say Mr. Taylor has made submissions that the company's been guilty of asset dissipation. Mr. Robinson has submitted that they have not. And then he doesn't, I accept that he doesn't make a finding about whether or not my submissions were right or Mr. Taylor's submissions were right. But in my respectful submission, if the judge had made findings about those facts on the basis of the affidavit evidence before him and the exhibits, we would be before the Court of Appeal on an entirely different basis, which is to say the judge would be criticised for.
I follow that. But if the position is that the judge says Mr. X has submitted that this is all unlawful, and Mr. Y has submitted that it wasn't, where do we go from there?
Well, my lord, the
It's
situation.
true, but that's interesting.
Well, I'm sorry if that's the case, but the submission is that, and the paragraph is paragraph 39 again. Sorry, no, I've taken you to the wrong paragraph. Paragraph 38 on page 95.
Mm-hmm.
And what the judge said in paragraph 38 on page 95 is, I have considered the submissions of Mr. Taylor that the company's entered into various agreements and pledges without consulting the JPLs. Mr. Taylor's point is that it is doubtful whether the value of the company or the group, for that matter, has retained its value in light of asset dissipation that has taken place. So first of all, the submission to him from Mr. Taylor was that it was doubtful. And then he records, on the other hand, Mr. Robinson's pointed to evidence to show that there's not been any asset dissipation. Rather, the actions taken by the company were always intended to be taken to allow the company to restructure and address its financial obligations. Now, in my submission, my lords, the judge is not to be criticised for, or not to be taken to have gone wrong in his reasoning by failing to make a finding as to whether or not there had been the allegations of asset dissipation were correct, because the decision he's taking is: do I wind the company up today, or do I further adjourn the petition, having already inserted in with the company the court's officers as JPLs with soft touch powers? Now, there was obviously extensive submissions and evidence before the judge with regard to what had been an unhappy relationship between the JPLs and the company up to that point. And there's extensive correspondence about complaints that the company hadn't done this and the JPLs wanted the company to do X, et cetera, et cetera, et cetera. Again, I could be here for a very long time in making submissions about who was right and who was wrong in that situation. But the fundamental point is that the judge has seen fit not to make a finding that the allegations of wrongdoing against the company were correct. And in my submission, he was perfectly entitled to do that, because
what he does do, Mr. Robinson, is conclude by saying, in my view, the exceptional circumstance 3 still applies, but you don't know on what basis he gets there.
Well, the exceptional circumstance 3, my lord, is that there will be value destruction if there was a winding up order. So going to the top of paragraph 38, he says, in respect of the court's exceptional circumstance 3, I am still of the view that there's potential for value destructive consequences in making a winding up order. And then at the bottom of paragraph 38, after the 2 sections I've referred you to in terms of...
Yeah, he says it still applies.
However, I'm focused on the main issue, is that a winding up order has potential for a value destructive consequence. And that's the point which I've submitted to you this afternoon, which is that, and I've shown you briefly, the evidence that the company provided to the first instance judge, that the making of an immediate winding up order in the special circumstances of this case, given its business, would be value destructive because it risked having its licenses revoked for the LPG and the oil business that it's in. And so the judge is saying in paragraph 38 in my submission is that there's potential for value destruction. Mr. Taylor has said there might not be as much value left because the company has done X, Y, and Z. Mr. Robinson says the company still got the value because X, Y, and Z did not result in a dissipation of assets. And then the judge concludes the exceptional circumstance, which is that a winding up order would be value destructive, still applies.
But he doesn't say whether he accepts what you say or what Mr. Taylor says.
Well, that goes to the point that in my submission he didn't have to, because if
you said that,
he would have had to do an adjudication.
But I follow that, but there was a waste of time, including these sentences. But exceptional circumstance 3 is whether or not a winding up order has the potential for value destructive consequences. That's what he refers to in the first 2 sentences.
Yes, Lord.
He then sets out the submissions of the parties about whether or not there have been asset dissipation, which has absolutely nothing to do with whether or not a winding up order would have potential for value destructive consequences. And then, having set out the 2 matters, neither of which are relevant to what he's considering, he says quite rightly, however, I'm focused on the main issue, which is whether the winding up order has the potential for value destructive consequences.
Yes, but in my submission, the reason why he's referring to those submissions in that context is because the allegation had been made that effectively the company had dissipated its assets, so that the value which was no longer there. So I appreciate that. That's my submission. That's why he was dealing with that there, because he's talking about the value, and the allegation had been made by the petitioner that the value had gone, and the JPLs had jumped on the bandwagon in my submission to say that the value had gone. And Mr. Shum, as I've endeavoured to show you, has an extensive affidavit evidence and exhibits demonstrated to the judge on our case that wasn't the case, but the judge hasn't made a finding. I'm sorry if I'm repeating myself, but the judge is.
Well, I can see how you can put it. I'm concerned with the question as to whether or not there's value destructive consequences. One side has said there's no value to destroy, and the other side has said yes, there is. I can't reach a conclusion on any of those, so I turn back to the issue as to whether a winding up order would destroy any value if there was any.
Exactly, my lord. Not my submission is what he.
I follow.
And so I've taken you briefly to those extracts from the evidence in terms of the various allegations, and I simply say I would encourage and invite the court to read them in detail, because they do endeavour to explain.
What's the point of our reading them in detail?
Well, because I haven't been able to open them to you, my lord. That's
no. I know that you haven't had the time, but assume we have all the time in the world. What will we gain from the exercise of reading them in detail?
Well, it simply goes to the same point, my lord. No different point than the point I've already made. I'm sorry if I'm asking you to do things that are not relevant or helpful.
Well, on your submission, they're not relevant, because you say, well, what he's done is to say one side there has been a loss of value and the other side says there hasn't, and I'm not making any findings. There we are. What's the point of us going through in order to see why he decided he wouldn't decide?
I take that point, Lord. I'm sorry if I've invited you to do the wrong thing, but that's
I mean, there are limits on what we can be required to do.
You have my point, my Lord, in terms of that point. So I think, Lord, on that first major part of my reply submissions, I've probably come to the end of that part of my submissions, and I'd like to move on to, and they do of course overlap, but I'd like to come on to the submissions made by my learned friend on behalf of the appellant, that the judge was effectively wrong to further adjourn the petition, because he ought to have concluded that the company had breached the order, and there is an overlap. But if I could ask you first of all to look back at the order that he did grant. Sorry, Lord. And it's in binder B, tab 6, page 143.
Mm-hmm.
And my learned friend, Mr. Taylor, takes the position. Mr. Taylor takes the position that when the judge ordered the company, the soft touch order in December, that there's a breach of the order, because when one looks at paragraph 3, taking 3I as the example, in relation to the company, to review and approve any asset disposition of the company valued more than $40 million, that ought to be read that applied also to the subsidiaries of the company. Now, my submission, that's not correct. The order was proposed by the company. You can find exactly the same wording behind the company summons, which is at tab 4. Very small point, Mr. Taylor takes the position that this is going to special circumstance 1, that we hadn't come to the court on a wing and a prayer. The summons was filed on the 15th of November. You'll see that on page 139. But the company had made this proposal for soft touch provisional liquidation. It had proposed its choice of provisional liquidators, which you can see on tab 4, page 131. And you'll see in paragraph 1 that the company had proposed different Hong Kong-based provisional liquidators, but the same Bermuda liquidator. So this was the company's proposal for soft touch provisional liquidation powers, which the judge then saw fit to grant, but having substituted the company's nominees for the Hong Kong-based JPL for the petitioner's choice of what the petitioner would have wanted to be permanent liquidators. But it's still, in my submission, doesn't lie in the mouth of the petitioner now to say we would rather like the judge to have granted a different order, which included all companies in the structure, when in fact that's not the order that the judge granted, and the petitioner the petitioner made no contrary submission.
Mr. Robinson, is there not an argument that a holding company is only worth what the value of the companies below are? So if one of those, i.e. the subsidiaries, so if a subsidiary company loses value, that means that the value of the group has gone down.
Well, I fully accept that, Lord Justice Appeal Bell, and it actually takes me on to a different point, which is to say that the business of this company is a holding company, and the business of the company is to enter into is to hold the group. In fact, I mean, what this company holds, if you have to hand Mr. Taylor's client's revised structure chart, you'll see from that structure chart, which is page 2806, is that the only thing the company's holding are the shares of Best Resources Hong Kong Limited, and the JPLs accept that in their own report. They say in their own report that the company is a holding company. It simply has the assets of the underlying company, and that's in the JPL report, which is bundle E, page 3360. In the second paragraph, the JPL's report, the company is a holding company for at least 105 entities. The group's stated principal activities include a sale of distribution of LPG, oil, natural gas, electronic items, as in addition to property development. All business activities of the group are operated through the company's subsidiaries. So,
but if the company is a holding company and only operates through its subsidiaries, that makes it, whatever the order says, the more important that before you dispose of your subsidiaries, you should consult with the provisional liquidators.
well, my lord, that's not what...
Deeply unattractive to say. We're supposed to be cooperating, because I'm not going to tell you that I propose to dispose of our major subsidiary because the order doesn't require it.
Well, I'm trying to deal with the point that my learned friend submits that the company was in breach of the order. Yeah. The company was not in breach of the order. What the company then did when this complaint was made, and when the complaint is made, well, you know, it should, the order, effectively the complaint is made, the order should have said the group, and in the context of the company through its evidence, explaining to the court why it hadn't dissipated any assets, it was the company then that proposed the amended order, which is at tab 11 in the same binder. I actually think that page 160 to 168 should be before tab 10, before tab 11. Certainly in my bundle, those pages appear at tab 11, whereas in fact they are the annex to the order at tab 10.
But Mr. Robinson, the subsidiary couldn't act without the say-so of the holding company, could it? And that's in effect what Mr. Shum tells us. If we look at page 346 that we were taken to before, it's tab 14 of bundle C. he explains how pressure was being applied. Shangyang threatened to repudiate the lease unless the company would reimburse the prepaid rental fee or provide a pledge over the shares of the two other companies.
Yes, well,
Repudiation of the lease would be devastating. And he goes on to say, the company was not in a position to return the prepaid rental. Therefore, it, i.e. the company, granted Shangyang the share pledge as the most viable commercial option forward. It's the action of the company which is implemented through the subsidiary.
yes, well, I accept that. I accept that Mr. Shum's evidence refers to the company in that context. And when one looks at the share pledge, of course, the share pledge is not granted by the company. The share pledge is granted by the underlying company. But I accept that his evidence is framed in that way.
Yes, well,
And no doubt that's because he thinks in that way. But I'm simply trying to meet this allegation that there'd been a breach of the order, to say that there hadn't been a breach of the order.
Well, there are two allegations. One is that there was a breach of the order. The second is that even if technically there wasn't a breach of the order, it was manifestly unacceptable for a subsidiary, obviously with the consent of the parent, to dispose of an asset without any prior consultation with the JPL.
Yes, my lord, I accept that's the allegation that's made. The point I'm making is that when this issue has been raised, it's pointed out that in fact there'd been no technical breach of the order, and the company having
Assume that.
But the point I'm making, my lord, is that the company having explained that and explained what in fact happened, it was the company then that volunteered to have an amendment of the order.
Fantastically good, but that was after it had in effect broken the spirit of the order.
Well, I can't take that submission any further and to say that
No.
it hadn't broken the order. But what I would also like to point out simply is that as well as adding in three places in the order that the order applied to subsidiaries, the original order also had a limit of $40 million, which was then reduced to $5 million. And that was a debate with the judge as to what that figure should be. It having been pointed out that there was concerns about assets not being properly dealt with within the group. I can't take it any further than to say that Mr. Shum explained in his evidence what had happened with regard to the assets. The evidence clearly before the judge was that there hadn't been asset dissipation. And then in answer to that, then the company, as well as answering all of these allegations which are thrown at it, both from the JPLs and from the petitioner, then is proactive in terms of changing the order so that going forward, there is a more productive relationship with the JPLs in terms of consultation. Forward-looking, but in my submission, the appeal against the judge's order has to be looked at in the context of these steps having been taken before one gets to the end of the multiple hearings that took place up to the 10th of May, because of course this order was granted by the judge on the 14th of April, which I think was the second. The first hearing was on the 8th of April. The second hearing was on the 14th of April. So it having been raised by the petitioner, it was then dealt with in the course of the hearing before anybody gets anywhere close to the judge making a decision. I rather glossed over the point about the company being an asset holding company. I mean, obviously, it's a Hong Kong listed company, which it's in the business of holding the assets of the group, and that's made very clear. I probably don't need to deal with this point, but
we know that it's a holding company.
Well,
we know that everybody else knows that it's a holding company. I don't think we need to be shown that everybody knows what's obvious.
It goes to this point about whether or not it was in the ordinary course of business, because the point is taken against me that these transactions are not in the ordinary course of business. And of course, that's exactly what these transactions were. They were in the ordinary course of business. And if I could just ask you to look at Mr. Lawrence Shum's first affidavit again, he deals with the objects of the company. And he deals with the objects of the company. Paragraph, page 176, so it's bundle C, tab 1, 176, paragraph 16.
Yes.
And of course, those are pretty, in my submission, perhaps quite standard objects for a holding company. But the business of the company was, paragraph 16b, to act as an investment company for that purpose to acquire and hold upon any terms and either in the name of the company or any of his nominees, shares, stocks, and so on and so forth. And in my submission, there's nothing in the point that the company had acted beyond the ordinary course of business, because the company that the petitioner lent money to and petitions for its winding up is an asset holding company whose business is to deal with the underlying asset in terms of raising funds for the business of the group.
Right.
And so the point was also taken that paragraph 18B of the appointment order had been breached.
Yes.
In paragraph 18B, I think the words that my Lord President referred to, and to matters outside the ordinary course of business of the company, subject to the JPL's granting prior approval for the exercise of such powers. Well, that, in my respectful submission, that deals with that point. The company did not do anything outside the ordinary course of business. It might have done things that the petition didn't like or criticized or was suspicious about. And that, of course, in this situation, one can understand that. But this allegation of breach of the order, or that somehow that this appeal should be allowed, and the judge's decision to extend the soft touch provisional liquidation should be overturned because the company was in breach of the order, in my submission is not correct in terms of the allegations, which are all answered in my submission with regard to the asset dissipation. There's a slightly different point in terms of paragraph 4 of the order, and paragraph 4 of the order is the primary obligation of the company to cooperate with the JPLs, and paragraph 4 is on page 164, tab 6 of the same binder. And the directors and officers of the company shall provide the JPLs with such information as the JPLs may require, whether expressly requested or not, in order that they properly undertake their duties.
Yes.
And so the point taken against the company is that, well, the allegation is that the company has failed to provide information to the JPLs, and much is made of the issue with regard to the Hong Kong petition. Now, all I would say in response to that allegation is, if I'd ask you please to look at Mr. Shum's 7th affidavit, which is in, sorry to go back through different bundles, but bundle C again, and the 7th affidavit is behind tab 21. And this affidavit was sworn by Mr. Shum and provided to the judge on the morning of the hearing on the 9th of
so what are we looking at?
Sorry, Lord, it's Mr. Shum's 7th affidavit, which is on the 9th of May. And you'll recall that Mr. Shum and the company's advisors were dealing with the issue of the disclosure of the JPL report, and he provides his response to that in the 6th affirmation. And he says in paragraph 2 on page 416 of the 7th affirmation, I make this 7th affirmation as requested by the court at the hearing on the 4th of May to state the company's position on the provision of information to the JPLs. In this affirmation, I'll set out the company's position in respect of 1, information and documents already supplied to the JPLs, 2, information and documents that the company will make available to the JPLs, and 3, steps that the company will take to provide the JPLs with further information as they have requested. Now, turning over the page 417 and following, I'm not opening this to you, but what Mr. Shum in that affidavit then did in detail was explain what the company has in fact done. If I could just briefly show you on page 417, paragraph 6. The company is not, paragraph 6, he says the company isn't always been willing to cooperate with the JPLs with regard to their request for information. The JPLs have already received substantial information regarding the company's latest audited financials, the previous scheme of arrangement, updates on the sale of the LPG assets and the Zhuhai commercial premises, and the valuation report of the company's core assets. And then in paragraph 7, he says, if the court's minded to adjourn the petition, this is what the company is then proceeding to propose. And so in my submission, it's not a case where the JPLs have come to the judge before the hearings, which led to the order on the 9th of May, and made, as they did do, made complaints with regard to the cooperation that they obtained from the company. But again, it's not a case where the company has simply said nothing in response to that and shrugged its shoulders. Mr. Schumann, his 9th affidavit, says, this is what we provided, this is what we're going to provide. And I fully accept and appreciate that in the second JPL report, the JPLs say in the second report, well, we still haven't got all of the information that we want. And that second JPL report, just for your notice in bundle 8 at tab 2, it's quite a short report. It makes a page 4294 deals with the outstanding information that hasn't been provided. But yet again, Lords, on page 4297, the conclusion is of the second JPL report. And this is all post-dating the order, of course. This is in June, 6th of June. The JPLs are therefore to view that the relevant critical information remains outstanding in order to assess the viability of any restructuring proposal being put forward by the company. So while the JPLs in their second report say there's further information we haven't got, again, they're not saying that the company should be wound up because it's hopeless. And Mr. Schumann's 7th affidavit deals with the information that he's provided. And then just turning to the back of the bundle you have in bundle C, which is the 8th affirmation of Mr. Schum.
Just before you go on to that, Mr. Robinson, the Schum 7 gave an undertaking that all of the additional information that was set out in that would be provided within 15 days of the date the affirmation was sworn, which was the 9th of May. So that would, the JPL's second report would suggest that that didn't happen.
Well, no, Lord, the reference to 15 days is on page 8, paragraph 8, where he says in paragraph 8, as you'll see, the company will seek consent within 24 hours for potential investors to waive the company's contractual obligations under the non-disclosure agreements and to provide the following additional information to the JPL within the next 15 days with the consent of the investors, which will give the JPLs full information. Now, I need to check the dates, but my recollection is that one of the investors provided that consent and the information was provided, and the other investors did not provide the consent and it wasn't provided. And that continues to be dealt with in Mr. Schum's 8th affirmation, which gives an update to the court in terms of the available next steps. I certainly don't understand it to be the case that there's an allegation that the order that the judge made in terms of the disclosure of information, that the company hasn't been making productive efforts to comply with those disclosure obligations. The submission I make is that the judge, having adjourned the petition on terms that there would be provision of information, that the company is continuing to deal with those points. And as you'll recall from the papers, perhaps, the registered office is in the PRC, and Mr. Schum is in Hong Kong. And so, as I said to the learned trial judge, I'm not suggesting or submitting that there's not issues with regard to information flow and so on. But what I do submit is that the suggestion or the submission that the court should conclude that the judge went wrong on the 9th of May because he ought to have concluded that the company was effectively not prepared to cooperate with the JPLs and that a soft touch provision liquidation was hopeless is simply not correct. And I've taken you to the short portion of the judgment where the judge recites Mr. Rialoma's submission that he made to the judge. So just before I repeat it, I'll perhaps remind myself of what exactly the judge said. Page 88 on tab 5 of the Mr. Rialoma submitted that the JPLs were willing to continue to work with the company. It may well be on a granular analysis of what's happened subsequent to that. The JPLs say, well, we didn't get this in time, or we need this. But what I submit is that the company has been dealing in a productive way with those requests. And I submit that there's no basis for the Court of Appeal, respectively, I say, to say that the judge's order was wrong, because he ought to have concluded, and the submission of Mr. Taylor is effectively that the judge ought to have concluded on the 9th of May that the company couldn't be trusted to cooperate further with the JPLs. And in my submission, there's simply no basis for the court to interfere with the judge's exercise of discretion to adjourn on the basis that he was confident that, having had extensive hearings over the course of 5 or 6 days, where these issues were debated at great length, that the judge was satisfied that there was sufficient merit in the proposal of the company, and in the relationship with the JPLs was not fractured beyond restoration. And in my submission, the fact that the judge has made the order on the 8th of July in the way that he did, and in my submission, the company has complied with that order in terms of providing restructuring information to the JPLs, that in my submission, the judge was quite right to reach that conclusion. And his decision-making can't be impeached because the petitioner now says, oh, well, he ought to have, the court ought to have thrown in the towel and wound up this company.
Yes.
Well, I've gone rather quickly through those submissions, but if you'd allow me just one moment, Lord, just to check my notes, I will confirm whether I have anything else to say. I think I've made the point, my lords, that Mr. Taylor's submission with the 2 charges that were in much controversy in this case were granted on the same day. The implication being that, therefore, that they were suspicious. They were not, in fact, made on the same day. And I could take you to those points, but probably it's a very minor issue at this stage, given, of course, that at least 2 of my lords, I think, are in the UK. So I probably, in my submissions, fundamentally, my submission is, I don't intend to go to the law, because the law in my submission is quite clear, in the sense that in my skeleton I've dealt with the power of the judge to adjourn and the discretion of the judge to adjourn, and I've sought in my submissions to focus on the factual issues as to why we say the judge was quite right to adjourn, and why his judgment to adjourn isn't impeachable. Of course, I'll deal with any of those points that you wish me to do. But
well, the judge plainly has a power to adjourn. But I mean, the critical thing that is said is that, generally speaking, the judge has a discretion whether to adjourn, and the judge has a discretion whether to make a winding up order. Yes, but what is said, authorities express it in a slightly different way and with slightly different phrases, is that as a general rule, the wish of the majority of the creditors, certainly if they're all creditors of a single class and all unsecured, is to prevail, provided that the creditors have a good reason for wanting the winding up order, unless there is some special circumstance. In other words, the majority view is of great importance. It's not apparent, or it's said that it's not apparent, that the judge took that on board.
Well, my lord, on that point, in my submission, of course, I accept that the judge's reference to the case law in his 31st of May ruling is very brief, and he refers principally, my lord, at paragraph. So in his ruling on the 31st of May, he refers back, as you know, to the 4 exceptional circumstances. And he quotes at page 83, tab 5 of bundle A. He quotes his previous ruling at page 41, where he says, "I am guided by Reid Damoglass," reference to Justice Brightman and Lee Southard, "and the exercise of the court's discretion will not be dependent upon mathematical niceties or the counting of the heads." And thus, in the several reasons, he decided to adjourn, because he holds that there were exceptional circumstances. And when one looks at his previous ruling on the 4th of March, he deals in much greater detail with the submissions that I made to him and that he accepted, and that is that the judge's decision whether to adjourn is untrammeled by any rule that he must. The proposition being put to him was effectively that he must wind the company up, and in my submission, that is not correct. And the judge. No, that's right. He refers. and I think we've extracted it in our skeleton, but it's at tab 5, page 71 of Bundle A, where he refers in detail to the submissions we made from P&J McRae Limited. And he refers to the decisions of both Lord Justice Wilmer and Lord Justice Upjohn in P&J McRae Limited, that the final decision is with the judge.
Yes.
And so it goes really to the point which I started my submissions with, which is that the judge, in his ruling on the 31st of May, in paragraph 39, he says, I have once again given serious consideration to the views of the creditors and their position atop the hierarchy of interest that I should bear in mind. But the submission that he accepted, relying upon P&J McRae Limited, was that, yes, of course, there is the principle that a petitioner is entitled to a winding up order ex debito justitiae. Of course, the final decision is for the judge in weighing up all of the circumstances. Now, that's exactly what our legislation says in section 166, that the judge has got the discretion to adjourn. And so he refers to Lord Justice Upjohn in particular. If you have, I'm sorry, I'm just jumping around rather, but bundle C, tab 5, page 71, paragraph 33, he says, Lord Upjohn spoke of the complete and unfettered statutory discretion of the court. He stated that, quote, a low and undoubted creditor is as a general rule entitled to an order ex debito justitiae. There may be special cases where, apart altogether from the wishes of the creditors generally, the court may not think fit to make an order. And so in my submission, the judge got that position in his first decision on the 4th of March completely right. Of course.
What's so special about this case?
Well, because, Lord, we've been there. We've been through the 4 exceptional circumstances that he held were exceptional, and I've taken you to the position with regard to the deficit. What we submitted to the judge and what we submitted to this court would be the deficit value of the assets of the company if it were to be wound up. Now, you may say, well, it's the petition, and Mr. Taylor would no doubt say, the petitioner's in the best place to know whether it wants 15 cents on the dollar in a compulsory liquidation, as to whether it might want to take a chance of 100 cents on the dollar in a soft touch provisional liquidation followed by a scheme. But the judge, in my respectful submission, was entitled to weigh up all of the factual circumstances in the case and decide that he was prepared to adjourn the petition to allow soft touch provisional liquidators to develop with the company a potential scheme of arrangement. And I started my submissions by addressing Mr. Taylor's proposition that because the creditors were shown shum 4, none of the bank creditors that his client has as supporting individuals have changed their mind. One other one has joined. But of course, Mr. Shum's first affidavit, you were shown this briefly by Mr. Taylor, Mr. Shum's first affidavit referred to a number of creditors who didn't support a winding up. I accept that those their position was not further developed after the second affidavit of Lawrence Shum, but it would be wrong to proceed on the basis that the judge was under the impression that there was simply no creditor support. Mr. Taylor puts his case on the basis of the fact that every creditor wanted the company wound up. That's simply not correct. His own percentage statistics are 64, 65, 66%. And so the judge doesn't have anybody. It's maybe a trite point, but of course the winding up rules provide that if you want to appear in the petition, you file a notice and you appear in the petition. The extraordinary thing in my submission about this case is that even though HSBC turns up as petitioner and says, we've got all of this support, not one single creditor appeared on the petition, either to support or to oppose the petition. And therefore the court gets in, and the learned trial judge had the situation where he was having to try and weigh up the information he was given about creditor support and creditor support for a scheme. And I don't resile from the point that Mr. Taylor says, well, you're never going to get a scheme passed. Well, in my submission, that's not correct. At the moment, the creditors appear not to be supportive. But what I took you to at the start of this hearing, my submissions was the proposition put forward by the judge that he was prepared to let the company allow the creditors to have proper analysis of whether or not they should support a scheme.
But the scheme that you're indicating the company I'm
sorry, Lord, I didn't hear that.
You froze for a moment.
The scheme, can you hear me?
Yes, I can.
Yeah, the scheme that we're talking about, the creditors rejected in 2021, which is why that particular creditors meeting was adjourned. So what basis is there for thinking that they're going to do a volte-face when they've all basically 64%, which is far and above the number needed to defeat the scheme, are saying we want to get on with the liquidation?
Well, my Lord, the answer to that in my submission is that the court has seen fit in December to appoint provisional liquidators with soft touch powers. And so while of course the company didn't proceed with its scheme meetings because it perceived that the scheme would not pass in 2021, it now has the benefit of the court's officers. And so if the court's officers come, the company having provided a scheme of arrangement detailed to the court's officers, and the court's officers then say to the creditors, when a scheme is proposed, our view is that there'll be a liquidation analysis. That is the nature of these things. There'll be a liquidation analysis. You'll get 20 cents on your dollar if there's a liquidation. You'll get 70, 80, 90, 100. In our case, they said you'll get 100, but you'll get the proposition being put before the judge and before this court is that in no circumstances, there's no way in which creditors will not vote for a scheme. I submit as a matter of commercial reality that if you get a scheme proposed by the company with the JPLs in office on a soft touch basis, and the JPLs inform the creditors that in their view, they'll get 20 cents in the dollar under a liquidation, and they'll get, I might even go further and say if they get 30 cents in the dollar under a scheme, commercially.
But it's all speculative, isn't it?
It is all speculative.
Nobody knows what the numbers are going to be.
That's right, but my Lord, the point you put me to me was what's the difference between the previous scheme and this scheme? The difference is that if the company is able to propose a scheme with the benefit of a soft touch provisional liquidation, then the company then will have the basis of the court's officers who are appointed to be honest brokers. That's what Justice Mussington referred numerous times to Chief Justice Caveley's reference to the restructuring troops. If the restructuring troops, who are the JPLs, say this is a better outcome, in my submission, the court, neither Justice Mussington nor this court can then conclude that there's no prospect of a scheme passing.
There's an if in that's the problem.
I'm sorry, Lord, I didn't hear that.
I said there's an if in there, and that's the problem. If the liquidators say this, thus, or so.
Well, Lord, that's quite right. But the court is, the liquidators are still in office, and they're going through a process with the company in order to for the company to propose a restructuring of its debt. I can't stop there being an if. Of course, there's an if. But the point is that there's somebody who's adjudicating on whether or not what the company might propose to the creditors is a realistic restructuring plan. And it doesn't follow in my submission that because Mr. Taylor says I've got 65% and a scheme will never pass, that the court should accept that he's right. And Mr. Justice Mussington didn't accept that he was right, and I submit that this court shouldn't accept that he's right.
I follow your point there.
And so there's one further point on the case law which I would just like to touch on. I know we're running quite late and it's been a long day, especially for my lords here in the UK. But in Redeemaglass, it's in Mr. Taylor's bundle of tab 17. In my submission, there's one important point which the court should have regard to. And in Redeemaglass, sorry, I'll just give you a moment to turn to that. And Redeemaglass was a case where there was a glass company and there'd been a minister of receivers appointed, and the petitioning creditor wanted the company wound up, but the evidence was that if the company had been allowed certain time to sell the glassware in the market at a much slower rate, that there'd be much better value for the creditors. And Mr. Justice Neuberger, as he then was, starting at page 637, he refers to the correct approach. And I'm not asking you to look at those propositions. We referred to them in our previous skeleton. The judge refers to several of the propositions in his ruling. There's just 2 points in it that I want to draw to your attention, and that is at the bottom of page 638 at letter I. Justice Neuberger says, for my part, I would not accept that the mere fact that a majority of creditors support the making of a winding up order would be an absolute bar in all circumstances of the court refusing the winding up order. The wording of section 25(1) of the 86 Act is such, and the nature of the winding up jurisdiction is such that, as Justice Brightman himself recognised in the passage I've quoted, the discretion of the court is to be regarded as untrammeled by any absolute rule. Then he refers to Tory Palmer, and then I accept that he then does say, nonetheless, I think it would be required a wholly exceptional case before the court would deny a petitioning creditor a winding up order in circumstances where the majority of creditors support the making of a winding up order. I submit in respect to that this is an exceptional case, but one also has to bear in mind in Bermuda.
Wait, just pause. Wait, don't go so fast. Just pause there. You say this is an exceptional case, but I mean, I think the logic of your position is that whenever the company has a potentially plausible scheme, the order, despite the fact that the majority of the creditors want the thing wound up, is to proceed to a scheme of arrangement.
My lord, my position is that the judge has a discretion as to whether or not to wind the company up.
Well, of course he's got a discretion, we know that. But if the position is that in present circumstances, what you say is a plausible scheme is put forward, if that constitutes the basis upon which the court must or should ignore the views of the majority of the creditors, it's difficult to see that that fits in with Mr. Justice Neuberger's proposition that it would require a wholly exceptional case before the court would deny a petitioning creditor a winding up.
Lord, in my submission, and the reason why this is a wholly exceptional case is because of the nature of the business and the devastating impact that the winding up order would have on the value of the business. It's not in every case where that's going to be the case. In some cases where you've got stock in trade that could be sold on the market, for example, that's not going to be the case. It doesn't follow that because the proposition I put to the court that in the case of an exceptional case, the court can refuse a winding up order would apply in every case. I say that this case is a very specific, exceptional case in terms of its business. But the point I was going to come on to was that one needs to be careful in reading these authorities because, of course, Bermuda does not have any statutory jurisdiction in order to help a company work out of a liquidity crunch, except for provisional liquidation. And provisional liquidation has been developed by case law, largely, in my respectful submission, by Chief Justice Caveley, to develop for Bermuda a system of corporate rescue, which is judge-made, based upon the proposition that the court's got the power to appoint provisional liquidators without a winding up order, and then will, from time to time, either adjourn that petition or wind the company up if there's no hope, but will allow the court's officers to decide and to advise the court as to whether there's a proposition that there could be a restructuring. There's no system of administrative receivers, no other system of corporate rescue apart from the judge-made rule that you can apply for joint.
And the structure of the scheme, which is there and which hasn't been taken advantage of.
Yes, I accept, Lord, that Section 99 is there, creditor and member scheme is there as part of our statute, but there's no other corporate rescue statutory procedure in terms of having office holders of the court who can supervise a company that's got into trouble, except for this process. So the point I'm making is that we must read this case law with some caution because, of course, we've got the judge-made rule. In my submission, is a very good one in terms of giving companies the opportunity to restructure. But I've slightly gone off my point on Demon Glass. What I really wanted to show you was over the page in 640. And that was where Mr. Justice Neuberger, so he has 7 propositions. But in my respectful submission, the 7 propositions are propositions dealing with whether to grant a winding up order or whether to dismiss a winding up order. He says at letter C the paragraph which starts in the present case. In the present case, I am not concerned with the familiar type of case, namely whether to dismiss the petition or to make a winding of order. Mr. Trower QC, who appeared for the receivers, merely seeks an adjournment of some 10 weeks. Indeed, he accepts that it is virtually certain that if the matter is stood over, then when the petition is relisted for hearing in 10 weeks, the making of the winding of order is virtually a foregone conclusion. He says, it seems to me that the principles applicable to a case such as this are not wholly dissimilar from those in the cases I've been considering. If a creditor of a company is entitled to a winding up order and has good reasons for seeking it, then while an adjournment is not an outright denial of the right, it is a temporary refusal. It nonetheless seems to me that the court should be less reluctant to adjourn the hearing of a winding up petition than it would be to dismiss the petition, in each case over the wishes of the petitioner, especially where the adjournment is for a relatively short period. Adjourning as opposed to dismissing is much less significant interference with or denial of a petitioner's rights or claim in a particular case. The longer the adjournment sought, the closer the case comes to the more familiar type of case. I simply draw to your attention that
It doesn't seem to have had in mind something that drags on for a year over numerous hearings.
no, my lord, I accept that, but it goes back to my previous point, which is to say that soft touch provisional liquidation is the process which Bermuda has to have judge supervised corporate rescue. And I know that's putting it very glibly, but that is the case. And therefore, I simply draw to your attention that what the judge is doing is he's adjourning, he's not dismissing or granting the petition. And it's clear from Damon Glass that that's a less severe interference with the rights.
Well, that's plain. But if we're not in the realm of adjournment. The court has, pure adjournment. The court has a power to adjourn if somebody, whether an individual or a corporation, owes a debt upon the basis that you can do so if the money is going to be available in a reasonable period of time. That's not this case, among other reasons, because you're relying upon a scheme and relying upon Section 99. So you've got to get in a scheme and you've got to get a majority in order for the scheme to go ahead. So although you're seeking an adjournment, it's not a classic adjournment simply to pay the money.
Well, Lord, it's not a classic adjournment in that sense, but it is not an uncommon adjournment application in this jurisdiction when a company has got into trouble and wants to have a provisional liquidator appointed to promote a scheme. And there are many other cases in which that has happened and where there has been adjournment. And to go to my Lord Justice Kay's point, there have been cases in which, of course, there have been adjournments over many months and years for that very purpose. But that's on the basis that the JPLs are officers of the court and they're coming back to court before each adjournment and they're reporting to the court as to whether or not there's been progress towards the restructuring of the company's debt. And so I completely accept that it's a different territory, but it's a different territory for a reason. And of course, as the court will know, there are many hundreds of Hong Kong listed companies that routinely come before the Bermuda court in order to restructure their debts given the domicile of the company. And so it's not as simple as, and with all due respect, it's not as simple as a time to pay case. Of course, there are time to pay cases where a company might come and say, if you give me 10 weeks, as in this case, it'll be paid. This company didn't say that. And any complex listed company, in my submission, would be very unlikely to be able to say that. This company's got is $1 billion company, we say. It's got extensive debts, but of course, it's going to be complex and time consuming. But of course, the court's got the comfort that its officers are there, and if they do come in and say, "Game's up," there's no way this company's going to be restructuring its debt, then of course, in my submission, the court will act accordingly. But that's not this case.
Right.
So,
okay.
I've taken the case law very quickly, but in substance, the two cases which I say are important are P&J McRae and Reed Demoglass, which are the two that I've briefly referred to. I think unless I can assist you further, my lords, those are my submission.
No, unless any of my brethren have questions.
No,
Mr. Robinson, I was just going to ask, what do you expect to happen on Wednesday in Hong Kong?
Lord, I'm afraid I can't answer that question. The company will be applying for an adjournment. But I just don't have the answer. I can't.
I mean, you've given me the answer. The company will be seeking an adjournment in Hong Kong.
I've no specific instructions about that, but I mean that would seem to follow from my submissions to you today. Of course, that's logical.
Thank you.
Thank you. Now, does counsel for the liquidators have anything she wishes to add?
Yes, my lord. There are just a few points that I'd wish to clarify to assist the court, if I may. The first point was that there was a question of what debt was owed by the company to the creditors. I'd like to draw your lordships to page 3362 of the first JPL report. That is in binder E.
Yes.
In the top left, at the first paragraph, my lord, the JPLs have taken the initiative to correspond with the bank lenders so that the JPLs can have some understanding of the company's current debt position. The JPLs have received responses from 27 out of the 32 bank lenders to whom they wrote. Based on the information provided by the 27 bank lenders, it appears that the company is indebted to them in the sum of approximately USD $821 million.
Right.
The next point I wanted to clarify was that there was a comment or suggestion made that at the first informal meeting of creditors, the JPLs were influencing the creditors in some way. The comment, which I believe is the comment in question, was a comment made by Mr. Sutton, who is one of the provisional liquidators. If I could take my lords to page 4280 of bundle E. I do apologize for the maneuvering of the bundles.
4280.
Yes,
Mhm.
4280.
Oh.
Yes.
In the third paragraph, my lords, and these are the minutes from the informal creditors meeting. It is said, what Oriental Patron said is not a restructuring, but essentially a sell down of assets because the business can't work anymore, that being indeed a liquidation summary. So the point there is that Mr. Sutton was relaying to the creditors what was told to them by the company's financial advisor. The JPLs were not making a view at that point as to what form the restructuring was taken. And this is also clarified in Mr.
I'm so sorry. I'm so just where I haven't found it on 4280. Which paragraph is it?
My apologies. It's the third paragraph, the second last
Right.
sentence.
Mr. Rod Sutton?
Yes.
Yes, I see.
It's what Oriental Patron said. It's not a restructuring, but essentially a sell down of assets because the business can't work anymore. That being indeed a liquidation summary. So Mr. Sutton was merely relaying to the creditors what had been told to them by Oriental Patron. And that is also placed in evidence in the first affirmation of Ken Fung at paragraph 24. And that's at page 274 of bundle C.
Yes.
Paragraph 24, my lord. The comments was a direct response to Oriental Petroleum, the company's financial advisors, describing what was intended by the company. Mr. Sutton, one of the JPLs, commented that what Oriental Petroleum were describing was not a restructuring, but essentially a sell down of core operational assets, which implied there was or would be no ongoing business of any substance, that being indeed a liquidation summary. Mr. Fung goes on to say that Mr. Sutton was plainly not in context saying that the JPLs intended that a liquidation should take place, or that a sale of assets should only be conducted in a liquidation, or even that the JPLs thought a liquidation was imminent. So it's quite unfortunate that this comment was taken out of context.
Yes, I see. Okay.
One further point, my lords. There was the JPL's motives for sealing the report seem to have been brought into question. And to add some clarity to that, the JPLs have said in evidence that the first report contained commercially sensitive information. And they did not, and in particular, the report provides, amongst other things, details of offers made for assets, a discussion of the JPL's attempt to participate in negotiations, and the JPL's preliminary views on various transactions undertaken by the respondent without any consultation to the JPLs. The JPL certainly did not want to enter the fray between the petitioner and just wanted to report an unvarnished account of the state of play in the provisional liquidation. And all of the concerns that the JPLs had vis-a-vis the company were ventilated in a whole series of communications to the company. So what was placed in the report was not new news. And all of the communications are annexed I to the JPL report.
Mm-hmm.
And just one final point, my lords. It is true that the JPLs have received the draft restructuring agreement on Friday. There is a point of compliance with that order as the JPL's fees, the order provided for payments of the JPL's fees, and that has not yet been forthcoming. And the JPLs have gone through the draft restructuring agreement over the weekend, and they do have some preliminary comments, which will be reported to the company in due course.
Right.
And if I can give any further assistance.
Well, right. Could you just tell me what is the state of the accounting information available about the company? Or do you not know?
I crave your indulgence, my lord. I'm instructed, my lord, that on the 15th of July 2012, the JPLs received what can only be described as an unsupported and overtly simplified profit and loss statement with opening and closing cash balances for from the company for the year ending the 31st of December 2022.
Sorry, we can't.
What?
We can't have a year ending.
Haven't got there yet.
No.
The JPL do not find this to be an acceptable.
No. I'm
No,
sorry.
no.
Don't, please listen and don't speak so fast. You talked about receiving some sort of account, but you said it so fast I couldn't note it down, for the period ending the 31st of December 2022. We haven't got to the 31st of December 2022.
Yes, my lord, this is a cash flow production. A projection.
This is a what?
A cash flow projection.
Yes.
So that document was received by the JPLs on Friday.
Yes.
And the JPLs do not find this to be an acceptable cash flow projection for a Hong Kong listed company. The JPLs have written to the company indicating their concerns with this projection.
Okay.
If the court wishes, I'm happy to speak to the JPL's concerns.
No, I mean, I haven't seen the document, but I'm interested in finding out what balance sheet statements it's got. Or ordinary accounts, profit and loss and balance sheet.
My lords,
Yeah.
the JPLs do not have any audited financial statements this year.
When you say this year, you haven't got any audited financial statements.
My apologies, for the last financial year that was completed.
For December 21.
Yes, my lord.
And have you got any unaudited financial statements?
I believe that there are some management accounts for some of the entities, but not all. And I don't believe the JPLs have a complete picture.
Sorry, when you say for some of the entities, are you talking about the subsidiaries?
Yes, my lord, of some of the subsidiaries. But at this point, the JPLs do not have a complete picture of the current financial position of the company.
Okay. Right. I don't know whether either of my colleagues have any questions.
No, not for my part.
No.
Yep.
Mr. Taylor.
My lord, very briefly, I appreciate the hour. A couple things factually, I think we very much wish to clear up. Firstly, as regards the JPL report that my learned friend Mr. Robinson indicated that his client applied to have unsealed, I wish to make it very clear to my lords that the petitioner was not in possession of that report. So please understand that to the extent there is a suggestion from the company that somehow information contained in that report was somehow used or somehow formed a view that the creditors had, it was not, because it was sealed from the world. We did not have that report. So that's point number one. Whereas there was criticism, or I think there was a point made by my learned friend that Mr. Shum's 7th affidavit hadn't been circulated to the creditors, and somehow that was evidence. So that was, the submission was made that means the creditors still didn't have the full position. Keep in mind, Mr. Shum's 7th affidavit was filed on the 9th of May, was the date upon which the order was made by the learned judge that's being appealed from. And that unfortunately formed a bit of a pattern that the company would put late evidence in and then make submissions that the creditors didn't know everything because the new information was there. The other point I should make is that when Mr. Shum's 4th affirmation was, in order to assist the court, provided to the creditors, of course, arguably that all should have been provided to the creditors by the company. But when it was provided by the petitioner, the company threatened to seek a contempt order against the petitioner for breach of the implied undertaking. And so this is the sort of situation that the company, or pardon me, that the petitioner has been dealing with. And so nonetheless, we say that Shum 4 sufficiently addressed the company's concerns about the PLs, what the PLs were saying, such that the creditor knew exactly what was going on. My lord, I think my learned friend, Ms. Waswani, raised that, of course, my learned friend took you to Mr. Fung's, or my learned friend took you to Mr. Shum's 3rd affidavit. Of course, Mr. Fung of the PLs responded to that in his 3rd. So obviously the provisional liquidators have their own views on what exactly is taking place. My Lord, of course, my learned friend made submissions about paragraph 38 of the judge's ruling, and that it would be inappropriate for the judge to, on the face of affidavits, made any findings of fact. It may well be a fair submission, but of course, it wasn't just about the fact. The order is the order, and the judge, as I said in the submissions in the main, he didn't engage with whether the conduct in terms of the Shenyang pledge and the new Soho pledge actually breached the order. And there's no need, obviously, for the judge to deal with any controversy of fact in that analysis. Mr. Shum's explanation is there. The judge, unfortunately, did not make a determination. And then we say, as you know, failed to make further inquiries and considerations because of that. Lord, finally, my reply on Justice Neuberger's decision in the case of Demiglass. Of course, the facts in that case were quite a bit different, where you had a secured creditor who had appointed receivers, and the receivers had taken possession of certain chattels, as I recall the judgment, and were comfortable that in a period of 10 weeks only, they'd be able to sell these, and then ultimately a winding up order would be made. That's obviously not this case, because there is no agreements to sell anything, as we know. My learned friend also referred to this particular case as a wholly exceptional one, using the words of Justice Neuberger. In other words, there is nothing wholly exceptional about this case. There's nothing wholly exceptional about allegations that a company that's insolvent from a cash flow perspective is balance sheet solvent. There's nothing exceptional about Hong Kong listed companies that have operations in mainland China having, in this case, whatever the licenses are regarding the use of liquid petroleum gas. It could equally apply to mining licenses. There's nothing exceptional about that either. And in fact, it takes this case out of sort of any, and I've said this in my skeleton, which you read. We really think, although his first ruling isn't under appeal, the learned judge's exceptional circumstances analysis has flowed through. And unfortunately, we say that he was incorrect from the start, because there isn't anything exceptional about this case. The proper lens to consider this, the overlay that needs to happen, is the context of a provisional liquidation. And what's happened in Midland, of course, is the overlay about the importance of what is the creditor's sentiment in terms of ultimately this company being successfully schemed. And when that, quite simply, when that answer is properly analyzed, the fact that a winding up order or the follow-on of a winding up order is quite straightforward, we say. The last point I wish to make is my learned friend's taken the point that because despite all of the acrimony between the provisional liquidators and the company, that the PLs continue to say that they continue and they're willing to work on a scheme, somehow suggests that the process could continue. But there's a difference between the provisional liquidators, I say, what they set out in their report, what they're willing to do, and of course they're willing to work on a restructuring because that's what the court has ordered them to do. But the final sentence of the report, which is at bundle E at page 3399, really this is the key. And it seems to me that the provisional liquidators understand the position quite well. So my learned friend referenced the last paragraph wherein, or the second to last paragraph, when the JPLs indicated that they'd written to Cobre and Kim to reiterate the need for the company, its advisors, to provide the information, access, and cooperation the JPLs consider as necessary if a restructuring is to be proposed. Well, then they go on to say, and to formally put the company on notice that the company has 10 days in which to do so, and that the JPLs will report to the Bermudian court whether the company has reversed course. Whether this outcome can be averted with the board in situ is respectfully a matter for the Bermudian court and the creditors of the company. And the point is, Lord, as I understand what Mr. Fung is saying here is, we can work on a restructuring, the nuts and bolts of it as much as we want. We can consider a liquidation analysis. We can consider what the company proposes. But Mr. Fung recognizes very well here that if the creditors aren't on board, it's going nowhere. And that's an important sentence that my learned friend did not follow through on when he was reading this, page 3399.
Sorry, which is the important sentence which wasn't referred to?
Yes, my lord, on page 3399, this is the final page of the report.
Yes, I'm looking at it.
Yes, where Mr. Fung writes, whether this outcome can be averted with the board in
I'm so sorry.
is respectfully a matter for the Bermudian court and the creditors. Yes, so let's not, in my mind, let's not conflate what the provisional liquidators say they're willing to do, of course, within their mandate, with what they appreciate they can't do, which is override creditor views. They could certainly provide their views of all of this, but in reality, this sort of concept or this construct that seems to have been flowing through these proceedings, that the provisional liquidators will look at all of this, assuming one day they receive the information that's required to properly consider this, that they somehow can convince these particular creditors in these particular situations to change their mind. Lord Justice of Appeal Bell said on an occasion or two today, it was speculative. I mean, it's extremely speculative, even with the PL's participation. In other words, because the PL's recognize that, they can't force anybody to do anything. Certainly not the creditors.
Just help me on this.
Yes.
I was asking Mr. Robinson why he said that the present case was exceptional, and effectively he said, well, it's because the company has made strenuous efforts to produce this scheme, and because there's a real risk that if liquidation takes place, it'll have a dramatic effect upon the assets of the company and the group, and that constitutes its exceptionality. You say that it's not exceptional. If you are right, is the practical reality to be that if the majority of the creditors, at any rate, if they're the creditors of a single unsecured class, want there to be a winding up, there is no realistic prospect of a provisional liquidation leading to a scheme?
I don't say that. I don't say
well,
that.
No, you don't say that, but I'm asking you whether that is in fact the consequence of your submissions.
Well, no, it's not, my lord, because we're dealing with a very particular situation. You've been referred in different contexts today, the case of Up Energy Development Group. It's a case I was involved in that former Chief Justice Cayley was managing. Yeah. And early on in those proceedings, my lord, the creditor numbers were, if I can put it this way, were on either side of the ledger, and they were sufficiently mixed that there was some controversy about it. And the judge did adjourn on the basis that it would be possible that some creditors might take a different position. The other thing that we were aware of was that the creditors that appeared were a relatively small number of the creditors broadly, as I recall. My lord, if the Court of Appeal decides to find with the petitioner in this case, there is really no broader proposition that a light touch will never work. All the court would be saying is that in the very unusual circumstances, admittedly of this case, where you have the scheme that is being proposed effectively, which is already being rejected, being proposed again, the creditors not wanting it, and literally a significant majority of the aggregate value. So this isn't just a small subset of the creditor body. Of the banking creditors, we're using the round number, it's 65% of the aggregate debts say we don't want this. It certainly doesn't spell the end of light touch provisional liquidations. It just brings some control to a process, which in this case, it's appropriate to bring some control to, because nothing has displaced in the light touch regime the primacy of creditor, the primacy of creditor views. And nothing in the law has changed. I will say this, my lord, if there is a single case in the light touch provisional liquidation world, be it in Bermuda, Cayman, or elsewhere, where the court has decided with these sorts of majorities that they would continue to adjourn over and over again, I'm certainly unaware of it. It's not in the materials. And in fact, as Justice Neuberger said in Demaglass at that point in time in 2001, he said, I'm referred to no case where if a majority of creditors want a winding up order, it hasn't been issued or it hasn't been made. So, my lord, I hope I've responded. I hope I've responded to your question.
Yes. And what about, lastly, absolutely my last question, is the fact that there's a real prospect of the loss of licenses causing grave effects on the assets of the group, is that not capable of being a special circumstance?
Well, I wouldn't say so. I mean, certainly it's not exceptional in the sense that it's unique or rare. And ultimately, exceptional circumstances, I don't think applies to that particular situation. Keep in mind, my lord, the so-called expert report that was provided in terms of the licenses being, the license being revoked. It's an opinion from a law firm. There was no leave that was given to adduce that evidence. But there's nothing that precludes the provisional liquidators, of course, from stepping in and doing whatever they can to maintain those licenses. It's not unusual at all. And so I certainly wouldn't consider that an exceptional circumstance that would displace the very clear stated views of a vast majority of the creditor class.
Wait a minute, the provisional liquidator, if you're right, the provisional liquidators are going to bow out. I mean, they're going to get compulsory liquidation.
No, well, my lord, they don't bow out. So of course, if you make a winding up order, Mr. Fung and Mr. Sutton remain in place.
Yeah.
They continue, of course, to be provisional until such time as a first meeting of creditors is convened.
Oh, I see. Yes, yes.
And the creditor body decides whether to leave them in place or not. Of course, what that does.
So it'll happen at the creditors' meeting.
That's correct.
Yeah,
it provides continuity. Yes. So
yes.
One assumes if the court has accepted the license issue, one of the first things Mr. Fung and Mr. Sutton will do is either travel to China to deal with the licenses or alternatively have one of their staff in China deal with them to see what can be done. So it's not special in the sense of displacing the creditor views, we say.
Yeah, I follow. Thank you. Well, unless any of my colleagues have any questions.
Nope, not for my part.
Right. Well, we'll just adjourn for a moment. We will retire to our online room. So please don't disappear.
Thank you very much.
Hello?
Hello.
Okay. The court is going to adjourn this matter, but we want the parties to be on standby from 10:30 onwards tomorrow. So you will get a link from me if we do decide to proceed tomorrow at 10:30 onward.
Okay, thank you very much.
Thank you. Thank you.